How did you manage that?
I didn't immediately get it, Chief Justice. It took some time, but I think what I produced made people talk and about the kind of work that I'm doing. And one thing led to another. And my first instructions from a big client was with the First National Bank, and that was only because I went there to ask for a loan to start my practice. And then the manager then, Mr. Mtia, said, I'll give you one collection matter and see if you'll be able to do it. And I did it, and the rest is history.
But then your legal career had started before that, when you were doing your articles of clerkship in Durban.
Yes,
in 1987, but you were still at university then. How did that work?
What had happened is that because when I did a BProc, I did all my law courses in my BProc degree. Remember, I started BProc at the University of Transkei. And then in 1984, when we had those upheavals, I transferred. I applied to go in the next year to Natal University. And then they made me repeat some courses, which I had done at UNITRA, such that by the time I finished my BProc, I had done a lot of courses that I didn't had to do. So when I did LLB, I had very little to do. I was doing mostly electives, and I thought I could start my articles because I knew that I wanted to make use of the fact that I was sponsored by the Transkei bursaries. So I knew that when I started my articles, there would be very little money. I mean, I think my salary was 300 rand a month. So I was taking advantage of the fact that I had a bit of space in my studies, and also I had some funding.
All right. And you say your salary was 300 rand a month?
It was 300 rand a month.
That was a lot then.
Yeah. Well, you could get by.
So you ran your own practice until 2000, and then decided to consolidate with another attorney.
Yes. We consolidated with Mr. Mngandi, Philisa Mngandi, because we wanted to get some capacity, because we did continue to get, considerable amount of work, and we consolidated, and we were asked to open an office in East London, and so we did that. But it was at that time, shortly thereafter, that I was invited to come and act at the Bishop High Court then.
So how long in all were you in private practice?
I was in private practice for 12 years, Chief Justice.
And during that time, you also taught law on a part-time basis.
Yes.
Can you tell us a bit about that?
I started, I became interested in the law school, the legal training school that the BLA was running in East London. So I would go and do a week of lecturing there to article clerks as I was practicing. And whilst I was there, I somehow met the Dean of Faculty at Fort Hare University, who also invited me to come and teach at Fort Hare in Bishop, in the evening classes. So I did that as well.
But then your involvement in the world of teaching did not stop at Fort Hare. It continues to this day, as I understand it.
It does. I a visiting professor at Rhodes University currently. So I go there and do a number of lectures in a year. I structure them in the way that is most convenient to me. And also I have done a lot of facilitation with the South African Judicial Education Institute, Sajai. From 2013 until 2023, I was on the council of the Sajai. And I did a lot of facilitation. Actually, it was short, not very long after Sajai had really taken off that I was invited.
Sajai being the South African Judicial Education Institute
Yes.
that's responsible for the training and education of judges.
Yes, and magistrates now.
Yes.
And so there was a rudimentary curriculum, but we kept improving it, and we've been doing that from 2013 when I joined until now. When I started, I was just an ordinary facilitator doing, in the main, appeals and reviews. And then I became responsible for convening the new judges induction course that we run over a couple of days after every intake from the JSC. So I became responsible for that whilst also doing my other facilitation. And then I also helped Dr. Mushweu to arrange
The CEO of the institute.
the CEO of the institute, yes, to arrange and determine seminars that judges need or require as we go on, the continuing legal education aspect division of Sajai. So I facilitated that for a while until 2022, I think, when my responsibilities in the court became a bit much. So I asked to be excused from some of my Sajai responsibilities.
So,
Although I still facilitate, in other words, I don't like to say teach, but leading the discussion now and then.
leading discussions, teach, and
Yes.
being responsible for the development of the curriculum of what goes on there actually at the
Yes.
same time.
Yes, definitely.
And now you sit in Sajai's council.
I don't sit in Sajai's council anymore.
Anymore.
I asked to be excused in 2023 because of my workload. So, but I just now facilitate, and I'm still involved in the environmental, particularly environmental law education, environmental law education, which Sajai has been championing both domestically here at home and throughout the continent, which when we set up the African Judicial Education on Environmental Law, which is the continental body. So I still am involved in that space and also in the global judicial education on the environment, which I was invited to through my work with the African body to sit in the board of trustees of that network of judges with interest in environmental law.
You are also a board member of the Global Judicial Institute on the environment.
Yes, Chief Justice, that's the one that I'm referring to.
Is that the one?
Yes, that's the one.
What is it that you do with in New York with Pace University?
Oh, that is, I am a trustee in Pace University. It also invites me from time to time to go and lecture. What prompted this is in 2022, when the UN recognized the environment, the right to the environment for the first time, passed that resolution. Because South Africa has always had this clause in our constitution that entrenches the right to a clean environment. So they asked us, me, I have been there together with Dr. Mshweu and sometimes myself. Through Pace University, they asked us to go and share some of the rights jurisprudence that comes from this jurisdiction. Basically, not necessarily on the environmental law space only, but the right to healthcare and all those cases that came out of our constitutional court in particular in the 2000s and early 2010s, 2010 to 2015. Because the reasoning, the entrenchment of the right works more or less the same way.
Mm-hmm. You have chaired the African Judges Education Network on Environmental Law. Is that what you talked about? So you were not just an ordinary member there, you actually chaired that body.
I chaired it for 2 years, and actually we did quite well as Sajai in chairing that. I chaired it as a representative of Sajai, because Sajai was asked to chair it when it had become stagnant. And we did manage to revive it, and I did my 2-year chairmanship stint, and we left it on a very high. I'm not sure what's going on now, because the politics had started creeping in, and we thought we want to back off a little bit.
It's a pity. You're a jury member. So in the global space on environmental law, you're a jury member of the Elizabeth Hobb Award for Environmental Law and Policy. What exactly is that?
It is the body that recognizes, it was set up by some family in New York. It recognizes persons who have made a significant contribution to the advancement of environmental law.
All right.
So they are honored once a year. It's usually one or sometimes 2 people, depending on what has come through. For example, this past year, it was John Knox, who's a lawyer and also has worked a lot with the UN on environmental law.
All right. And you've managed to deliver 3 papers in that space during all this activity and your judicial work.
Yes, Chief Justice, I have managed to. And I think it actually is more than 3 papers, because a lot of work was going on when I was the chair of the Continental Environmental Law for Judges body. As chair, you get asked to speak in all sorts of places. And I think, again, because I came from South Africa, and again, because of the jurisprudence, because that's what colleagues would tell me, would want to hear about how we do things, how we interpret our constitution, and how things are panning out.
All right. We skipped 2 not so tiny details before we got to the Sajai. You were also involved with the Walter Sisulu University. I remember during a very troubled time for that institution. What exactly did you do there?
I was the chair of the council there. I started also with the BLA continuous education program, going there during recesses to just teach them article clerks from the surrounding areas, not only from to the Transkei, University of Transkei section then of what is now Walter Sisulu. So I would go to Mthatha and teach article clerks, for a period of a week. And so I got to know people, and the university went through some turbulent time in the I think late 2000s, and it went under administration. And when it was ready again, I was asked to chair the council that would then sort of instate it to and take it forward, re-establish sort of together with other council members, the university council. So I ended up chairing the university from having done these lectures and gotten to know people, particularly in the law faculty.
Did you and your crew have any luck with bringing things back to even keel?
The university?
Uh-huh.
Yes, I think we did make considerable progress and stability in very difficult circumstances. But we managed to move the finances of the council, the university, from nothing to a bit of at least positive, and we even started saving some money.
There is also the work you do at Nelson Mandela University, which you have not mentioned.
Oh, yeah, there I just chair the council.
Just chair the council.
Yes, Chief Justice. I have been chairing the council for, this is now the second year.
All right. Now,
that's my hometown university.
Yes.
So they managed to twist my arm, even though I had thought I'm
it's a labor
getting
of
out
love.
Of the space. Yeah.
Just back to Sajai quickly, but this is important. The Sajai has an illustrious journal, law journal, and there's also the book which it produced very recently. Can you tell us a bit about those milestones?
Yes, the journal, I can't remember now when we started it, but we managed to get it. The aim was that we would have 2 publications a year. But I know that hasn't held through because, judges are very busy. It was established as a sort of a space where judges can express themselves with the support of Sajai, outside the confines of the pleadings that they adjudicate on all the time. But it is still going on, I understand. But I am no longer involved in the journal itself. But in 2019, in anticipation of the 10th year anniversary of Sajai, the CEO, Dr. Mushweu, approached me about a book project that she's thinking of, that we could have a 10th anniversary book in celebration of the 10-year anniversary of Sajai. And because I was still very involved then in judicial education and also still a member of the council, I agreed to sort of coordinate and facilitate this book and talk to judges to write. I wrote in Justice Madlanga to assist me because it was a big project. But after some time, because of his work commitments, he couldn't assist me anymore, and I tried other people. I ended up doing the editorial work myself, And although we missed the mark, we missed the point in that the anniversary was in 2022, we only managed to finish that project earlier in the year, and we launched, as you know, Chief Justice and other members and I see President Mulimel were there for the launch. That was just in August before we started our court term. So that book is out over and above other editorial journals and publications that Sajai runs. Yes, yeah.
Just to round off on your extrajudicial activities, you were once a council member of your Law Society of the Cape of Good Hope back in your other life as an attorney.
Yes.
Currently, and at some stage, you were a member of the Judicial Conduct Committee.
Yes.
And now you are chairperson of the Rules Board for Courts of Law since 2018.
Yes, Chair.
Okay. You can't possibly still be nervous, but by now.
This is a big room, Chief Justice.
Let's go to the meat of your CV, your judicial work. So you started acting as a judge in April 2003 in the Eastern Cape Division of the High Court.
Yes, Chief Justice.
And acted until your permanent appointment in 2005.
Yes.
And you were in that court until May 2014.
Yes, Chief Justice.
But you had interposed your judicial career because in 2009 you were appointed to the Competition Appeal Court.
Yes, yes.
How long did you remain in that court?
I remained there effectively for just over 2 years, Chief Justice. I think it was 9 terms or 10 terms. Because then when I started in 2009, in 2012, I went to act at the Constitutional Court. And from there, I never effectively went back. I acted at the Constitutional Court for 2 terms, and then I went back to my court for a term. But before I got my allocation for that, from the Competition Appeal Court for that period, I was invited to go to the SCA to act there.
You had been invited to the SCA before you actually went to the Concourt.
Yes, I did.
I saw in the record that Judge Mpati, the then president, was not happy about that.
Yes, it was a cause for a bit of discomfort.
So these 2 courts were fighting over you. You acted at the Constitutional Court for, was it 2 terms?
Yes, it was 2 terms. 2013 in the last term, November term, and then I acted in 2014 in the first term up to March, on the 31st of March.
All right. And there was a high expectation that you would make yourself available for permanent appointment at the Constitutional Court at the time, I remember. But then you chose to go to the SCA. May I ask why?
The expectation, I was not aware of it. I went because I had promised Justice Mpati that I would come after my stint at the Constitutional Court, which I did. But when I got to the SCA, I thought it would serve me well, it would be beneficial for my career for me to start in that court. Because going straight from the High Court to the Constitutional Court was a bit of a culture shock for me. I mean, in the High Court, you're used to running your own court the way you want, you write your own judgments. So from there, of course, you do sit in full benches and full courts, but the rigor is not as much. But from there to working with 10 other colleagues and, the level of what I think could be an intrusion into your writing space and how you conduct your things was a bit of a shock. I thought when I got to the SCA, where I work with 4 other colleagues, it's a better space to familiarize myself with the art of a collegial court continuously, and also the working systems were very different, and I thought it would be best for me to start in that court. The pace of the production of work. And I thought it would be a good training ground for me, so that if and I went to the Constitutional Court, I would be a better person, better judge, or add value, rather than being babied around until I found my feet.
Looking back now, are you happy you chose that detour?
Yes, I'm quite comfortable with that. I would do it in that fashion again, given a chance.
So you acted for a year at the SCA from 2014 until your permanent appointment in 2015.
Yes.
And you've been at the SCA to date.
Yes, I have been at the SCA now for about 11 years.
But then, yes. And in that time, you have once more returned to the Constitutional Court to act for another 2 terms?
Yes, Chief Justice. You invited me to act in the last term of last year, 2024, and then another term sorry. It was the first and second term of this year, until the 31st of May.
How did you find the experience this time?
The experience was much better than last time. I think I knew what to expect, and I was already steeped in the culture of a collegial court and appellate decision making. There's much more work than there was before when I was there in 2013, 2014, way more. And so the work is just relentless. Those applications for leave to appeal keep coming, and the decision-making process is slower than I'm used to in the SCA, of course, because judges, they have got to make, it's an en banc sitting court. Also for every decision, judges have got to work together. But it is quite a rewarding kind of work. It is very exacting. You are held accountable by your judges to a larger extent. And perhaps because in the SCA, I have grown to be one of the people that are regarded as senior, it is quite humbling when you really have to go back to accounting at that level with everybody else.
Well, you're not just one of the senior judges at the SCA. You acted as the president of that court for a while, not so?
Yes, I did act as a president of the court for a term. And I also, after you had left the court, Sajai, I acted as the deputy president of that court for 3 terms, I think.
How did you find the experience in the leadership space? And what lessons, if any, did you learn from that?
I learned, actually, that's when I realized that I would have to jettison some of the side projects that I was involved in, because as as a leader of the court, you have other functions as well to see that in support of acting President Betseden, that the role works well. You are there to support him when there is a problem, and you are there to raise your hand if there is work that needs to be done. And also because now I found myself propelled from, I think, being number 5 at the time to being number 2 and then number 1, meaning that you preside in all the appeals that you sit in, both at number 1 and number 2. So the responsibility is huge, in that you've got to see to it that members of your bench are productive and you can help, and you need to be proactive. So you need to be focused. So that the experience that I took from there is mentoring colleagues, but still being on the same plane as everybody. It is a balance that can be very fine to strike, to sort of chart the path, but not impose yourself on colleagues' space and independence to make their own decisions or to write their judgment in the way that they feel expressing themselves. That's in the main the experience that I got from there, that I'm still getting even now, because I'm still high up and preside on almost all the appeals that I sit on.
So female leadership is commonplace at that court,
Absolutely.
it seems.
Yes.
And I was surprised to realize that there are actually more women judges than male judges in that court now.
Yes, we finally managed to attain
come a
that.
long way.
Good work, actually, to you and Acting President Betseden and President Mulimela,
Yes.
for keeping on giving women a chance to come to the court. And in fact, I remember that you had wanted me to come to the judiciary even when I was practicing, and I kept, ducking that responsibility.
Yeah, it was a struggle to get you on the judicial path, Justice Gambuza. How many, well, you've written judgments in the High Court, in the Competition Appeal Court. Have you acted in the Labor Court?
No, I never acted in the Labor Court, although Judge Mlambo came down to the Eastern Cape to invite me, but it is at a point where I had made a promise to myself and to my children that I would not leave them anymore because of an experience I had while I was acting, and came home to find that my helper was selling alcohol from my house, and that shook me. I found my house that it was a shipyard unknowingly, because I used to come home from Grahamstown on weekends, and then when I gave her leave, people still came to buy. So that's how I got to know. So when Justice Mlambo, the DCJ, came to invite me, I asked to be excused because I just couldn't at the time.
Trials and tribulations of working mothers. So you've written judgments in the High Court, Competition Appeal Court, the SCA and the Constitutional Court.
Yes.
Toting all that output, how many judgments would you say you have under your belt?
I tried to look, Chief Justice, but I got the figure of 425, but I found that some of what Safli has put under my name is judgments in which I was sitting with other colleagues. So I couldn't filter that to get my own. But I would say more than 200.
It's a handful.
Including because judgments that we write in criminal trials hardly find their way to these publication platforms. But we do a lot of work especially as a trial judge in the high courts, we do a lot of work there. And we write a lot of review judgments that never find their way to publication. So it sometimes is difficult to set out a definite and truly reflective figure.
You will turn 61 soon. How long does that give you to still serve on the bench until retirement?
If the court would have me, I would have at least 9 years to serve until I'm 70. I can go on until then.
You are in a healthy state.
Yes, Chief Justice.
Do you still run?
No, I don't run anymore. I just walk. I do a lot of walking. I gave up. My knees gave in.
Thank you, Justice Dambuza. I will now hand
Chief
over
Justice.
to the commissioners to put questions to you. Any questions, colleagues? President Mulumela.
Thank you very much, Chief Justice. Good morning, Justice Dambuza.
Morning, President.
How are you?
I'm well, thank you. And how are you?
Well, thank you very much. Section 174, subsection 2 of the Constitution states that there's a need for the judiciary to reflect broadly the racial and gender composition of South Africa, and that this must be considered when judicial officers are appointed. Would you say it is essential for the complement of judges of the Constitutional Court as the apex court and as a court that was established now more than 30 years ago? Would you say that it is essential for its complement to reflect gender representativity in particular? Thank you.
Thanks, President Mulumela. Yes, I definitely would say so. I think presently the court has 4 women and 4 men, and I think it is well poised to implement that requisite in Section 174. And therefore, it would enhance the confidence that people would have in the court, in seeing that it truly represents what obtains in their communities. As a leading court, we need to ensure that in as far as that can be done, it is done.
Thank you very much, CJ.
It is 5 men, actually.
Is it 5 men?
5 men and 4 women.
Oh, 5 men and 4. You see, it is even more important. There's a deficit.
Yes. Thank you very much. CJ, I know that we are limited to 2 questions. I'm asking now my second question, but it has a few elements. Okay, so I am asking this question, which relates to the jurisdiction of the Constitutional Court. It's provided for in Section 167, subsection 3B of the Constitution. And some people refer to it as the clause that gave the Constitutional Court general jurisdiction. Now, can you maybe just inform us about the provisions of this section in terms of the jurisdiction of the Constitutional Court? Let's not talk about purely constitutional matters. Which other matters that are not of a constitutional nature may it adjudicate?
that are not of a constitutional nature.
Nature,
Okay.
yes.
Let me say, President, that in a sense, as the Constitutional Court tells us all the time, that the Constitution permeates all areas of our law. And I think that is the mindset or the unwritten policy that the court assumes when determining which matters to assume jurisdiction over. And therefore, the range of matters that it has assumed jurisdiction over range from matters where interpretation of a law or statute is required to matters that are of general public importance. So those have been the guiding principles in matters that do not fall within the exclusive jurisdiction of that court.
Yes, the section refers to matters of general public importance in which arguable points of law are raised. Would you be in a position to maybe give 2 or 3 examples of what you would regard as an arguable point of law that is of public importance?
An unarguable point of law would be of public importance would be an issue that arises from the pleaded case that is not confined to the litigants in that case. That is of general, as the principle spells out, that is of general, that impacts on the wider South African society, that is not confined to the immediate litigants and perhaps a few others close to it, and a matter that impacts on the understanding of a particular law, of the interpretation and the meaning and the impact of a particular law, that impacts then on the wider public, wide community.
Thank you. Thank you very much, Justice Dambuza. Thank you, Chief Justice.
Thank you.
Thank you, President. Commissioner Mwima?
Thank you, CJ. Good morning, Judge Dambuza.
Morning, Commissioner.
Just one question from my side. Judge Dambuza, the Chief Justice in celebrating the Constitutional Court's 30 years journey made a pronouncement as follows, that this celebration is not only about honor,
but also about looking to the future, to a continued commitment to constitutionalism, human rights, and justice for all. And I believe this proposition. Made by the Chief Justice is she's following on the footsteps that were developed by her predecessors. Now, the question that I want to pose is, what is your appreciation of these 3 concepts: constitutionalism, human rights, and justice for all, and how will you help the Chief Justice to implement this vision for the next coming 10 years? Thank you.
Thank you, Commissioner. I think the values that you refer to are some of the values that anchor our Bill of Rights. That when the Chief Justice talks about constitutionalism and within the context of those values, meaning that these are our guiding light when we do our job, in as far as that pertains to us as members of the judiciary. These are values that we will take forward into this future and perhaps take them to even higher heights in doing our job and in interpreting the law and adjudicating the cases that come before us. It is the values that focus our decision-making process that we must not forget. And therefore, like my colleagues, as the Chief Justice said, it is values that henceforth one always has to evaluate, how can I do this better in the context assisted by these guiding principles. We have been doing this job for decades past. I have been doing this job for over 20 years, but there is always room for enhancing the process, enhancing the product, the judgments which have an impact on people. It means we have always to be searching for how we can still anchored in these values, do our job better, you know, to keep on doing, meting out jurisprudence that is aimed at improving the lives of South Africans.
Thank you, Judge Dambuza. Thank you, CJ.
Thank you, Chief Justice. Good morning, Judge Dambuza Mayos.
Morning, Minister.
How are you?
I'm well, thank you.
I'm okay. I'm just following up, and perhaps maybe it will go into what I put as a question. Listening to what you say, you've got quite vast experience, your knowledge coming through, looking at how you've been able to cover such areas as sexual violence, accountability, but also just, yeah, you spoke earlier on about the work you do in terms of environmental law. Looking at all those, where do you think that we should be able to focus as part of us widening access to justice in the country?
I'll say, Minister, I also sit in the, as you know, in the Rules Board. We work together. And I always think that how we construct the rules, how we make provision for what should happen to costs, how we use technology. I think in the areas that I am involved in, I would say the rules are the engine room. They are the engine room of the judiciary. They direct how courts work. The procedures that we determine there have a wide impact on access to justice. And I think that's where we can focus. How we allow people to come to our courts is at the heart of access to justice.
Did your work in terms of being the chairperson of the Rules Board it is acknowledged, Justice Tambus.
Thank you very much, Minister.
Commissioner Professor Marumukhai.
Thank you very much, CJ. Good morning, Justice Tambus.
Morning, morning, Prof. Morning.
I have two questions for you. The first question, it relates to what appears to be your passion. There has been some criticism, I'm not sure if it is warranted or not, that the Constitutional Court has not yet meaningfully engaged Section 24 of the Constitution, and that we need serious guidance on how environmental rights and various aspects, including water and all those, needs to be dealt with. And in particular, when one looks at the need for business to operate and to create jobs, on the other hand, the health concerns and the procedural rights that are needed, or procedural requirements that are needed for business to operate, and the balancing of those rights. I see that this year you wrote a wonderful judgment, Minister of Environmental Affairs versus Trustees, that dealt with ESCOM and what they wanted to do at Richards Bay. And it seems to me that you were able to look at the health aspects and their lack of following the procedural rights. What I want to understand is, should you be successful, how should those tensions be properly balanced? The need to understand adequately the environmental concerns, while on the other hand, there is this unemployment and the need to do business and all those kinds. How do we balance that kind of tension in the country?
Thank you, Prof. Thank you, Commissioner. What we realized in that case that you're referring to is that there seems to be a gap, perhaps, in the administrators in understanding that they have an important guiding tool in the National Environmental Management Act. It hasn't been invoked much when interrogating the decisions that government officials do. And it seems that public officials were of the view that once a policy is determined, for example, in that case, on the part of ESCOM, once a policy is determined that we do not have electricity and therefore we need to add so many megawatts of electricity, they are oblivious to the guiding principles that are set out in the NEMA Act, which actually talk to what you're asking about, that all decisions where there is likely to be a significant impact on the environment, the principles set out, especially in Section 2 of NEMA, have to be applied. In other words, the decision-making process has got to be made up through the prism of those those guiding principles. Applying caution, because science changes every time, we don't know what might happen. But us as courts, there is a level to which we can't go. We can't say that to a public official, this is how much, when the scientist says the emissions are likely to to this extent and cause this damage, then this is how you decide. What we as courts, we are duty-bound to do is to ensure that all the relevant principles, you've got to take into account what the emissions are, you've got to take into account the context that you are living in South Africa. Actually, job creation is part of the factors that are also referred to in NEMA. So the balancing act will be done by people who are properly qualified to do that. All we do is to ensure that they do so, and it's got to reflect in their decisions that this is how we came to this conclusion. We took into account, we were cautious, the public participation procedures were all adhered to and meaningfully. And although perhaps the emissions are likely to cause this damage, at this point we feel that this factor, which might be the need for power, leads us to the decision that we take ultimately.
Thank you very much, Justice Dambuza. And also the issue of corruption comes into play in these matters.
Sorry then?
I was just saying the issue of corruption comes into play on these matters. But I need you not to comment on that. Let me ask you my second question. When you were engaging with President Molemela and you were dealing with the extended jurisdiction of the Supreme Court of the Constitutional Court, I was not quite sure if I understood your answer. I want to give you an opportunity to reflect on it. My understanding is, and please correct me if I'm wrong, in the case of Paulson versus Slicknot investment, that's where the Constitutional Court actually tried to explain to us what this particular extended jurisdiction actually means. And in that court, one of the things that the court said was it has not yet laid a basis upon which we can understand what really this public interest or general actually means. So what I want to understand from you is there a particular guideline that the court should use in order to determine that when a matter is before it has actually met this particular criterion of this extended jurisdiction, that is a non-constitutional sort of matter jurisdiction?
Oh, Prof, I thought the principles themselves that the determination of the impact of the likely decision is itself a guideline. These cases are the constitutional assumption of jurisdiction is determined on a case-by-case basis. And the best I can put it is that those guiding principles are what one takes into account in determining whether the issue is an issue that requires the attention of the court, in the sense that either it will impact on the wider society or it entails interpretation of a law or a statute that, if left misinterpreted, would result into a negative impact on its application in cases that follow.
Thank you very much, Judge Dambuza. I think it's important that the starting point is whether it is of general public importance, then yes, everything else follows thereafter. Thank you very much, CJ.
Commissioner Hassan?
Thank you very much, CJ. My name is Fasiha Hassan. I find myself in the JSC as appointed through the National Assembly. Judge Nambuza, thank you so much for coming today. It's always wonderful to see black women in particular who have such strong credentials coming to interview before us. I have two questions. My first is related to technology in the law. We're currently in this digital age, and it presents new challenges, particularly to rights such as privacy, freedom of expression, equality, etc. I'm interested in your thoughts on how the Constitution should be interpreted to address issues such as data privacy, algorithmic biases, or maybe even the regulation, potentially, of social media platforms. That's my first question, CJ. Thank you.
Thanks, Commissioner. That's not an area that I'm very strong in, but I know that the Judicial Education Institute is involved in a project to familiarize judges with the developments in the world of technology. I suppose the Constitution, being a framework really, would not particularly talk to areas of that kind of development, except insofar as aspects in the Bill of Rights, say, for example, freedom of expression and communication within that context, and the right to dignity and how it may be impacted negatively, and the vastness of the extent of communication and the impact thereof on people because, of technology. Things like social media and how that impacts on the rights that are protected in the Constitution. So in the decision-making process, I'm sure it is a matter that we would have to filter through, that what used to be something that would be communicated to 2 or 3 people can now go to millions, and the impact on the dignity and the life of a person may be violated in a fundamental way. Thanks.
Commissioner, CJ, can I come in here? Judge Tambuza, I think you are being too modest. Under your leadership, the Rules Board dealt with courts having to proceed and operate under COVID-19. That's the use of technology. Maybe share that experience, because I think that was a fantastic job that was done to enable continuity in the midst of lockdowns and all that.
Oh, thank you. I had not thought of that. Yes, we in the Rules Board, we from the time of COVID, we had to quickly cobble together rules that would enable the courts to function within that context. I didn't think of that because the rules haven't gone to promulgation stage because of the problems that you and I know about, Minister. So they're not out in the public domain. But technology indeed does bring access to justice, as we saw during COVID. And therefore, access to justice, Section 34 of the Constitution, is impacted. And it is in that line that we are trying to have the rules formalized so that technology can be used to enhance access to justice and the lives of people. I know Justice Mlambo also champions the use of technology, and I think the use of case lines in our court has revolutionized how courts function, and this can become better with time.
Thank you very much, Judge. My second question is related to the reserve judgments that you cite in 16.4 of your questionnaire. And of course, the question must be asked, I think, given some of the previous challenges, which you have, I think, succinctly explained the previous case, I think, when you were acting in the Concourt, but of course it was in a different division in which the challenge happened. But the question is around the status of these reserve judgments, where are they, and what interventions you've put in place to prevent a delay of 2 years. I mean, I understand that was an exceptional circumstance, but what interventions have you put in place to ensure that this doesn't happen in the future? Thank you.
Yeah, that was quite an unfortunate incident. Thank you, Commissioner. The judgments that I put out in the as reserved, outstanding, 2 of them have been handed down. The one is the one that Prof. Marumo Achaye was referring to, the ESCOM versus Minister of Environment, and the Woolworths ones. The measures that I have put in place are just keeping a schedule of my judgments and knowing what is outstanding. That matter that referred to happened in 2011. It's a case that I heard in 2011, even before I went to the SCA. And it is unfortunate that the file went to the registrar's office and it was filed there, and because I had not kept that kind of schedule, we normally kept our files that are outstanding in our chambers, but because the registrar that I was working with was a new registrar, she just took all the files to the registrar. And I think because of the pace of work, that matter simply escaped my mind totally, to the extent that even when I was alerted to it, I was sure that there was a mistake, because it's not a matter that really happens, and especially at that time. So I do keep a schedule.
Sorry, CJ, just to confirm, so of the 6, 2 have already been handed down. The 4?
The 4, 2 are from my acting stint in the Constitutional Court now, up until May, and 2 are from my court, and 1 is finalized and will be handed in next week, and then the 1 is the one I'm working on right now. Thank you.
Chair, arising from...
Follow up?
Yes. From the question from Commissioner Hassan. Good morning, Chief Justice. Good morning, fellow commissioners. Good morning, Justice Dambuza.
Morning,
Yes.
Commissioner.
Now, arising from your response, we know that during the last interview for the position in the SCA, there was a question that was posed, I think, Professor Slema, who informed you that some of your judgments have been handed down, took 10 to 7 months to be handed down, which can...
Sorry, Commissioner Konyane, would you just bring the mic closer?
Oh, sorry,
I'm hard of hearing this morning.
Sorry. During your interview for the SCA position, a question was posed to you from Professor Schlemmer, who informed you that some of your judgment, which handed down, took 10 to 7 months to be handed down, which the candidate, you confirmed that indeed there were instances where you found that you had delayed in handing down the judgment. Now, the question which arises from your response is that May you then tell us what is your turnaround time to hand down judgment ever since then?
It's difficult to say what the turnaround is, because now what I've tried to do, we get allocated, for example, I'll talk about what happens in the SCA. You get an allocation of 2 judgments in a term, and you write those judgments, and in the next term, like that. So you'd find that some of the judgments entail quite intricate issues, and they take longer to write. So in some terms, you will find that there's a judgment that I can hand down within 4 weeks. For example, there's one that I'm going to hand down that was heard now in October. Now it's ready to be finalized. But there are judgments that take longer, and whilst you're writing them, there are other responsibilities that you attend to which sort of tend to interfere with your writing, your thought processes. The difficult judgments, if I could have my way, you wish you could just have 3 weeks of not doing anything but writing that judgments, but you don't get that kind of leeway. You've got to help your colleagues as well at the SCA, and also you've got to do your reading during the recess in preparation for the next term. So it does happen that judgments get delayed in that fashion. I will admit that. But one thing I can guarantee you, Commissioner, is that there is no time that I'm not working on a judgment. No time, no night, no day, no weekend. I mean, I think most of us work like that in that court. If you go on Saturdays, you'll find there's everybody there. We work on these judgments, but you'll find that we're still struggling to get to hand down judgments at the end of term. I've almost given up on doing that, something that I used to be able to do from 2014 when I started in that court until 2022. It was a given that all my judgments would be out, or if not out at the end of the term, they would be out during the course of the recess. But I do find that I am struggling to handle that, and it is a matter that we have been trying to resolve and find ways around. But if you were to take the judgments that I hand down very quickly, the low-hanging fruit judgments, and the long ones, I would say average 3 to 6 months.
Thank you, Sajai.
Good morning, Judge.
Good morning, Commissioner.
Judge Dambuza, in the questionnaire, you are asked at 16.4, and it is this discussion that you are having now, at 16.4 to list the reserved judgments and the dates on which the judgments were reserved. You listed the judgments, and I note that you say 2 have already been delivered, but you don't say when the date when they were reserved, but also from your discussion, one doesn't get an explanation to where are things with these judgments as matters stand, and is it a function of you delaying, or is it because you sat as part of a bench, and it's somewhere in the system, it's off your hands, but it's somewhere in the system of getting the judgments finalized? If you would just say more about that, and I guess it's a topic of interest because the court to which you are applying increasingly is getting criticized for delays or is the subject of comment about delays in judgment, recognizing that the workload of that court has exponentially increased. So if you would just give us a sense of contributing factors here, but perhaps looking forward, what it is that you would suggest should happen in the Constitutional Court to assist with reducing the lag in the periods for delivery of judgments. Thank you.
Starting with the last point, Commissioner, thank you. I am aware that the Chief Justice and the judges of that court are in a process of facilitating an amendment to the Constitution that would enable the judges of that court to deal with matters not en banc necessarily, particularly the applications. I am not privy to the extent of to which the amendment is likely to also impact on the workings of the court, of the sittings in open court. I think that that initiative is likely to release the working capital of the court and release the pressure of having the decisions made by all the judges and have two courts, parallel benches, working at the same time and making decisions at the same time. That is what happens in the SCA in relation to applications for leave to appeal, and it works fantastically. It is difficult to make a suggestion, Commissioner, on generally how the other decision-making processes in judgment production should be streamlined. And I'll make you an example that sometimes, from my experience, even when judgments are ready, or well, a draft has been produced and colleagues have commented to it, and the judgment is almost finalized, it happens that it takes one comment to sort of deconstruct the whole process and the judgment writing process has got to start again. I think it is a function of a decision to which many people contribute. As long as that decision-making process in that court has to consist of 11 judges all the time, I think it's going to be difficult to get things to run faster. But I know that there are attempts to do so, and perhaps some of the pre-writing processes could also be sort of jettisoned, or looking into whether all the contribution, the process of contributing to a person's judgment have to, be kept in the fashion that they are now. I am not able to contribute further than that in regard to the Constitutional Court. Regarding my note, you are right, and I apologize to commissioners for that. I did realize that I hadn't put, when I was revising my form, that I hadn't put the dates of these judgments that were reserved when I put the reserved judgments on my on the form. I was just remiss in doing that. But in as far as where they are, as I said to Commissioner, I think Commissioner Moiman, I am working on them. It's quite a challenging situation because I'm working on the Constitutional Court judgment, one of which I thought I had finished, and then some comments came through again. So they are all on my desk. I am working on them all the time.
And perhaps just to add to Justice Dambuza's response on the delays, especially at the Apex Court, and the proposed constitutional amendment that will allow the court to hear other matters not sitting on bank, which it's been discussed at this forum many times. We've heard over and over how that just bogs down the systems. The constitutional amendment is in the pipeline, and we rely on the minister to ensure that it is fast-tracked. It was delayed by the elections and the change in administration last year, so we had to wait. And we are in the hands of those that process these things. But then that constitutional amendment, when it does happen soon, hopefully, will not be the be and all. It won't be the complete answer. Challenges with expeditious administration of justice, they exist across the board, from the Apex Court down to the high courts. And one of the key reasons is that there's been an explosion of litigation in the recent while. There is just too much work. And unfortunately, the number of judges remain the same as it was 15 years ago. We had Justice Dambuza explain that at the SCA, they work all the time. Judges work extremely hard every day. We don't sleep. I'm exhausted sitting here. But there's just too much work. And in many courts, there's inadequate support. We've been saying these things publicly, and hopefully now that there's going to be institutional independence and the judiciary will manage its own budget and hopefully get a bigger slice from national treasury, we'll be able to prioritize the necessary support measures, such as researchers, which the SCA has been fighting for, and essential staff. So it's very complex, but judges, and I've no doubt, Judge Dambuza included, work very hard. They don't delay judgments deliberately. It's because there just is too much work. I'm sorry for that emotional outburst, but that's just how it is. Minister, then Commissioner Pillay.
Thank you very much, Sajai. I will not be tempted to get into that discussion. But let me just ask Judge Dambuza, during your interviews for the SCA position, it was seen that the judgments that were reserved almost around between 7 to 10 months, and this was raised during your interviews. So roughly how long does it take for you to deliver in your work judgments?
After that long explanation, thank you, Minister, I'm sorry. The explanation that I gave to the commissioners, Commissioner Nkonyane and Commissioner Moiman, I have come to rest at 3 to 6 months. I'm not sure that that's accurate, really, because there are judgments that I hand down in a period that is much shorter than that. But there are judgments that indeed exceed the 6-month period to 7, 8 months. And I have had a judgment that went to a year and 2 months. But that comment that you're referring to, Minister, referred to high court judgments. The working system is different in the SCA, where I am now. And the judgments that are, I've explained how the intervening responsibilities affect the judgment writing problem. If you look at the profile of the judgments that take long, you will see that it's judgments that are really complicated, that involve many different issues that one has to determine. It's not an issue that is limited. Those are the judgments in which there's one issue that arises. I definitely hand down within no time, even ahead of the set periods. But we have been finding it increasingly difficult to finalize those judgments that entail many issues, particularly if you are in a position where you have to look at other people's judgment and try, to assist. For example, acting judges that come through the court would often ask you as a presider to look at their judgments before they circulate. And then that process on its own sort of derails you from your own judgments. And it is a responsibility that we have to do. It's a practice that we found there that has happened. However, if you remember, during the period 2020, 21, 22 even, we lost a lot of experience in the court through attrition, retirements, and elevation to the Constitutional Court. And therefore, there had to be a lot of, quite a bit of complementing the complement of the court. So we are not as fast as we used to be in handing down the judgments. And for some of us like me, if there are these other responsibilities, they impact on the rate, on your output of your work. I honestly, Minister, can tell you that, speaking for myself, there's absolutely nothing else that I can do. I mean, the President can bear me out. We work all the time in that court. And we work on weekends. But somehow we are battling to hand down the judgments as soon as we would also like to. And believe you me, this is something that, as a judge, you would want to do. You would want to hand down your judgments. It is a matter that sits heavily in your head and in your heart if you've got outstanding work and you know that more work is coming in. But we're doing our best. That's the best I can say.
Follow-up, Sajai.
Then Commissioner Matolo Dlepu, followed by Commissioner Steinbeck.
Thank you, Sajai, and good morning, Judge Dambuza Mayusi. I'm here.
Oh, yes.
Okay. Mine is not a question. I'm just trying to find out. I want your input, so to say. It's a lot of litigants are now coming to the Concourt for direct access, right? And most of the matters are dismissed. And I always wonder when seeing all these matters going directly to the Concourt being dismissed, is it because the practitioners or litigants don't understand what needs to go to the Concourt, or what can be done? Because I think maybe it adds up to the judgments being delayed because we have to deal with this. direct access to court. What's your opinion?
Commissioner, I think it is an incident of opening up courts to people. They will use the opportunity to see whether they can get a different outcome from a different court. When I was serving in the Judicial Conduct Committee, Commissioner Matolojepu, you'd be surprised that forum is used sort of as an appeal court as well. And that's one of the burdens that increased our work, people that were serving in the Judicial Conduct Committee, because when people don't get the outcome that they want, they will go look for another avenue. And in instances where one does not necessarily have to go through an attorney, you will get more and more of those kinds of litigants wanting to have a rehearing of the matter. It's got nothing, I don't think it's got anything to do with the practitioners. Practitioners know what the law is, what the chances of success are. But when you have a desperate litigant where a decision is a matter of life and death, I mean one way or the other, there will be a push to have another bite at the cherry. It's just an incidence of having a forum to go to. That's my thoughts.
Thank you.
Commissioner Mangena, followed by Inkosi Longonyana.
On the contrary, I'm one of those who think that your work rate at the SCA is impressive.
Thank you.
I've commented to the president that I don't know what she has done, but we are seeing an improvement in terms of the turnaround time regarding the delivery of judgments. Thank you for that work output. But then I've got a question for you regarding the court that you want to be elevated to. There is generally an outcry or a perception, if you may call it that, wrong or right, that the Constitution has not been interpreted in a way that advances the interest of the previously disadvantaged people in our country, more especially in relations to issues of land and BEE. Firstly, do you agree with that perception? And if you agree and you are to be elevated, are we likely to see some change in that approach?
Thanks, Commissioner. I would not quite agree. And the court has done quite a significant, the judgments of the court have resulted in a significant change in the lives of people. What I would say is that there is always more that can be done. I mean, the court has protected the right to life. It has afforded medicines to the TAC judgment, Treatment Action Campaign, and other similar judgments. The court has interpreted the Constitution to affirm the right to children at schools to have sustenance. There's many of cases where the courts have affirmed rights and advanced the rights of people. I know there is a contention on the minimum core that the courts should provide for. The Constitutional Court should sort of stipulate that a right to a house, for example, means a right to a 4-bedroom house or 2-bedroom house or whatever. And that is one of the areas that the court has refrained from doing so. And I suspect that when a proper case supported by a proper, the necessary substance, the court doesn't know what the budgets of the government are. So there's a level, there's an extent to which the court cannot go, and I think that's where the controversy is. But to say that blanketly the court has done nothing to advance, to improve the lives of people, I think is an overstatement. I don't think that that's right at all, that's correct at all.
Perfect. My second and last question. You were in the Constitutional Court in 2014, round about there. And when I looked at the judges that you worked with in 2014, there appears to be only one remaining now, Justice Mhlanhla. Mm-hmm. The rest of the judges have retired. And now in 2024, 10 years later, you found a new crop of judges.
Just pull the mic closer to you.
Now in 2024, you found a new crop of judges. Given that time lapse and the way the Constitutional Court worked then and it's working now, do you see a change in approach on issues of interpretation in relation to issues of precedents and the commitment to depart from certain judgments to give effect to the Bill of Rights?
Starting with commitment, the commitment is the same. It's the same, if not more. The change that is significant is in as far as the work of the court is impacted by the extended jurisdiction, because when I was there, the Superior Courts Act had just been passed, and therefore the general jurisdiction effects had not yet come through to the court. So the variety of work was more limited than there is now. But the level of commitment to the Constitution, to the Bill of Rights, is the same. And I would say even more improved, because like in any job, your thinking processes, your reasoning processes and other avenues become enriched by the experience that you've had, by further inputs that counsel that appear in that court have had. Because I think from the level of the side of the practitioners as well, they are constantly seeking and ways to enhance their input to the constitutional project. So in that sense, that work filters through to the courts, and the court has now, I think, ventured into other areas, dug deeper into the issues than it would have 10, 15 years ago. So, in a nutshell, the level of commitment is the same.
Thank you, Chief Justice.
Commissioner Kotsa.
Thank you, Chief Justice, and good morning, Judge.
Morning, Commissioner.
Judge, during the induction of the Judicial Services Commission, retired Judge President Ngwepe reflected on how judges were appointed prior to 1994 and why the creation of the Judicial Services Commission was such a vital constitutional reform. Now, the Commission's responsibility to protect the independence and also the integrity of the judiciary is a duty that obviously cannot be overstated. Over the years, however, there has been litigation concerning the processes, but also the composition of the Judicial Services Commission, the Judicial Service Commission, raising questions about its conduct and that of its individual commissioners. So, to what extent does the Constitution or other legislation speak to the conduct of the JSC and its members or its commissioners, and how, in your view, should concerns about the behavior of the Commission or its commissioners, particularly, or how should it be addressed, particularly when such conduct might place the protection or the credibility of the judiciary itself at risk?
Okay, Commissioner, I'm not sure I understand the question. So how you would like my views on how the JSC should conduct the disciplinary discipline its members?
No. So the JSC obviously has its conduct committee. I'm talking about the JSC as a body, as an institution itself, in protecting the credibility of the judiciary. And in the past, as I've said, there have been complaints about the procedures followed by the JSC or by maybe some utterances by some of its members or some of the commissioners. And there's also been very recent litigation about its composition. Now, how in your view, and particularly when the conduct of commissioners might place the protection or the credibility of the judiciary itself at risk, how should concerns about this body be addressed?
Commissioner, I'm not sure whether the JSC has a code of conduct, which I would say it should just enforce its code of conduct on its members. If there isn't one, one be put in place that is made known to everybody, so that when there is a transgression, it can immediately be identified and pigeonholed to the particular provision in the code of ethics or some ethical regulatory framework that the JSC sets up for itself. I say so because what constitutes conduct that may be reprehensible may not be uniformly understood by members of the JSC itself, the committee, and just members of the public. So I would say it would be important that, first of all, the do's and don'ts are sort of set out in an understandable way. I know it can't be a comprehensive and all-inclusive, but there must be upfront, like we do in all laws, that people must know how they are supposed to behave. And when you don't regulate a conduct, it becomes very difficult to do it sort of pay as you go.
Inkosi Nonkonyan.
Thank you. Good morning, Sajai, again. Good morning, Judge.
Good morning, Commissioner.
It's one question from me. I have had a look in your impressive CV as well as all your judgments, particularly your expertise and your passion in commercial as well as in environmental law. But I may have missed it. I have not come across the other aspect of the law that the majority of South Africans live under. That is African law, customary law, indigenous law, call as it may. But I was impressed when you indicated that you served in the African Judicial Body. Now my question is, in that body, did you acquire anything that will be of value if you are appointed to the position you aspire to be appointed by us? Thank you, Sajai.
Commissioner, I would only say, in as far as we shared our jurisprudence in that forum, then pertaining to matters of the environment, I did learn how they approach their cases, and in most of the countries, the right to a healthy environment is also enshrined in their constitutions. But I would say that the rate of litigation and how the extent to which issues that pertain to the right have not been as litigated as they have been in this country. Nevertheless, you become aware of what are the issues that are occupying the courts in other countries within the continent, and the approach to their jurisprudence, what that is. So that's what I would say I came up with. Thanks, Commissioner.
Thank you, Sajai.
Thank you, Chief Justice. Good morning, Judge Dambuza.
Morning, Commissioner.
Judge Dambuza, I know that you've written extensively on the right to a clean, healthy environment, and you've also presented papers on the topic. In the South African context, do you see that right as being a constitutional law right or an international law right?
It is, I think, a bit of both, in the sense that what impacts on that right can be a matter of domestic, but largely a domestic right, in the sense that the Section 24 imposes a particular duty on this state, our country, our government, to ensure that the right to a clean environment is protected, which obligation is not there in as far as a neighboring state might be engaged in harmful practices that impact similarly or to the same extent or even more on citizens within the country. So it is a right that straddles domestic but lies in the main, and the justiciability thereof lies within the country.
You see, Judge Dambuza, I was more interested in probing the extent to which the specific formulation of Section 24A and B, the extent to which that recognizes the right to a clean, healthy environment.
You are interested in the extent to which the right is protected in Section 24.
The extent to which the right to a clean, healthy environment is reflected in exactly how Section 24A and B is formulated. Because you would know that it's a very specific formulation for 24A. It imposes an obligation on the state which is not subject to reasonable measures. And 24B, which is the sustainability aspect, is subject to reasonable legislative measures.
Yes.
Now, I just want to understand, and because you've repeatedly referred to your expertise on the right to a clean, healthy environment, how does that interface with how our Section 24 is formulated? and the differing obligations on the state under 24A and 24B?
Well, 24A establishes the right that is not harmful to the health, and B is the portion that then provides for how that right can be asserted. I'm not sure whether I'm quite getting the nub of your question. How that right can be enforced vis-a-vis the government.
And in terms of the content of the right, do you
Yes.
see a difference between 24A and 24B?
24A establishes the content of the right, that you have a right to this, a clean environment. 24B provides a method of enforcing the procedural aspect of the right. I see I'm not getting to where you want me to get,
Not
Commissioner. I'm so sorry.
No, I just want to, the last follow-up, and then I'll leave this topic, Judge Dambuza. When 24A protects the right of everyone to an environment that is not harmful,
Yes.
and not harmful to their health and well-being, so it's framed in the negative. Do you equate that with the right to a clean, healthy environment? And the reason I ask you this was during the drafting of the Constitution, this was a very live issue, whether or not the Constitution should protect the right to a clean, healthy environment in a positively framed, but what you eventually ended up with was one that is negatively framed. Is there a difference in the two formulations?
In the way, there might be a difference, Commissioner, but I think in the way that our courts are interpreting the right, the difference between, it's sort of an interpretation that translates to a right that acts that are harmful to the health and well-being because of the manner in which the environment is treated, are not. You see, a right to a clean environment goes beyond, further than a right that is, because the non-harmful aspect of the provision means that you've got to show that there's harmful, but how the courts interpret it is that not only show overt harmfulness or harm, but also the potential of harm. So you get closer to the right to a clean environment. A clean environment or a non-clean environment could be not justiciable because there's no, it's not provided for, in the Constitution. Then one would go to other acts, the talks that regulate, perhaps, for example, pollution and the Climate Change Act to sort of get to the right to a clean environment. In other words, the legislation that has been enacted to advance this right go further than not harmful, to require a right that, to regulate a right that is close to a clean environment.
Just in the interest of time, I'll step off that question, Justice Dabuza, and just go on to my second question. You'll know that on the 9th of August this year, something very significant happened in our country, in that the judiciary adopted its sexual harassment policy. And the JSC just yesterday established a subcommittee which will focus on sexual harassment and on addressing any issues that flow from the implementation of the policy. Now, in your view, what do you think the stumbling blocks to implementation of the sexual harassment policy are?
The biggest stumbling block is people not coming forward to report incidents of sexual harassment, in my experience. That is what causes this practice to be more and more pervasive and just to go unchecked. I suspect we need to do more in supporting victims or survivors of sexual harassment to come forward. Because until the perpetrators actually see people being held accountable, it will, we're still going to struggle to make a significant impact on the scourge.
And if one considers that the new sexual harassment policy is a break from the past, what do you say should be done to encourage more people to come forward to report incidents of sexual harassment?
I think the policy does have provisions that provide for communication that would be protected, that would then encourage victims to come forward. But I'm afraid, Commissioner, I'm a bit tentative because from other initiatives that I have been involved in, particularly with the universities, it is very difficult to get the victims to come out one way or the other. So it's difficult to say any one measure is sure to result in a visible improvement. But we've got to keep on trying. We've got to keep on pushing. It's going to be interesting what the sexual harassment policy yields, because there hasn't been one before. And I'm optimistic that it will result in some measure. And then we can improve from there, a measure of confidence by the victims in the system, in the platforms that it provides for. And then it can keep on being strengthened. But it is a huge development in that sphere.
Follow-up, Sajai?
Yes.
Judge Tambuza, what are the structural issues that you attribute? I mean, the policy is new, but the issue of sexual harassment is a question that has engaged the sector, the judiciary. And you speak to the reluctance of those who are offended or the victims to come forward and the difficulty with getting them to come forward. But I would be interested in understanding what are the structural, institutional issues that make it difficult for people to come forward? And having considered the policy, the newly launched policy, do you find that it seeks, and how does it do that to address those structural issues?
Structurally, there was no defined avenue of making a report that one is sure will be taken forward. So you depended on, I think, the informal reports that you would make to your colleagues. You depended on how that report would be accepted, and there was no pathway to getting that is open and known to everybody, that is designed to take people's experiences through. The hope of knowing that now there is a procedure that I can follow up, and if there isn't progress, I can go to a particular person to make a report, is a significant enabler to a person who has experienced sexual harassment, I think. So structurally, the policy itself puts in place a structure that is designed to ensure accountability to people who perpetrate the sexual harassment, I think.
And ensure accountability and put in place measures that will reassure complainants, victims of this sketch to come forward.
Yes.
We're not going to get into the fine detail of that now.
Yes.
So it's a very complainant user-friendly instrument.
Yes, yes, yes.
Guy Toby, followed by Commissioner Steinberg.
Do you want to go first? Commissioner Steinberg has been itching to speak many minutes.
I'm assuming that from your enthusiastic raising of your hands that these are follow-up questions.
No. They're not,
Oh.
not,
In that case, you have to join the queue. I'm sorry. Is yours a follow-up? We can go back because your hand was up. Put it, please, Commissioner Steinberg.
Good morning, Justice Tambuza.
Morning.
Just before I ask my question, which is a follow-up on Commissioner Singh's question about Section 24 of the Constitution. Certainly from my experience at the bar, it seems one of the more elusive problems we have to deal with to encourage women to lay their complaints and come forward and see them through is the fear that, for example, at the bar, that they will no longer be briefed, that senior male advocates will choose not to work with them. And I think there's real reason for that fear. And I find it quite perplexing as to how we solve that problem, how we create an environment in our spaces where that wouldn't be a normal response and an acceptable response to a woman who's had the courage to speak out. I don't know if you have any ideas or response to that.
Providing a platform to talk, I think could be one of the ways. In other words, providing a platform that potential victims, and normally its entrance into the profession. I know that because when I was a practitioner and wanted work, there were advances like those. Creating a sort of, I'm talking about a start. Creating an environment where people can be open and talk about their experiences, I think, would be a start. An environment which would include senior members of the profession, some of which would share their own experiences and enable people to talk, and also letting it be known that this is what we are doing, I think would be a way of discouraging the practice and doing it as a forum that is openly known that there is this project of enabling people to talk, because we would really talk about amongst ourselves, and then that would dissipate until you have another experience, and then, you know. But where there is a structured, even if informally, where people can talk, and so that one, first of all, I think there is the affirmation in numbers, knowing that I'm not the only one, because one might be thinking that I'm the only one who is subjected to this kind of behavior, and often there would be known common perpetrators. But if there's not a concerted, if there is no concerted platform, people can know, but people don't feel that affirmed to talk openly. And then the next step is to hold people accountable, knowing that I'm not the only one who has named this person or has named my person. There's another one who will be held accountable as well. Trust is a big issue in these processes as well, because I may talk to you, I have to trust you to be able to know that you're not going to go and tell the very perpetrator that this is what I'm saying about them, because you know the perpetrator in a different light, and you might not believe me. So, you know, we've got to create trust platforms, or platforms of trust.
Thank you.
As one way, you know.
Just to follow up then on Commissioner Singh's, excuse me, Commissioner Pillay's question. This is the second time I've called her Commissioner Singh. Do you think Section 24 gives a litigant space to come to court and ask the court to oblige the state to take positive steps towards creating a clean environment?
I think so. I think it does. I mean, when the Section 24B imposes an obligation on the state to ensure that the right is enjoyed, it creates, I think, in my view, that kind of space. Although as a society we haven't used it as much as we could, seeing what is around us. But I think the section creates space for that right to be enforced.
Where do you see that? Where do you see that in the section, Justice Tambuza?
I see it in Section 24B, that everyone has a right to have the environment protected, and then it goes on. And that the environment is protected for the benefit of the present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, and then it goes on. I cannot see why that is not an enforceable right.
I believe the Constitutional Court has held that that is an enforceable right. And I think that's possibly the difference between the first and second subsections.
Yeah.
Thank you.
Thanks.
Commissioner Shabangu Ndawe.
Thank you, Sajai. Good morning, Justice.
Morning, Commissioner.
How are you?
I'm well, thank you. I hope you are too.
My one question has been covered, but I'm interested to get your thinking on this one. There's a perception out there, wrong or right, that seems to doubt the independence of the judiciary. Do you think the impartiality and independence of the judiciary still exists, and how important it is to have an independent judiciary?
Well, Commissioner, I would say judging from the number of cases that continue to flow in our courts, I would say that is a strong demonstration of independence in the judiciary. And also, perhaps it depends on where that general statement comes from and what inspires it. It is, however, still a responsibility of the judiciary as such to ensure that it conducts itself in a way that engenders trust in the judiciary, because that is the big basis of our legitimacy as the judiciary. So I think the statement that there's no trust in the judiciary is not accurate. But I think we still have to keep ourselves, check and balance ourselves to ensure that the trust that is still demonstrated in us endures. I do not get the sense that people come to our courts because of nowhere else to go. I get the sense that they, by and large, I'm not saying that there are no exceptions, by and large, they approach the courts because they trust that that is the best place to have their disputes resolved, their rights protected. That's my view.
Thank you, Justice. Thank you, Sajai.
And it's quite interesting to sometimes see the most vociferous critics of the judiciary, when they have their own trouble, speak on public platforms threatening to come to these very courts. So I would say, by and large, confidence in the judiciary is still intact.
I agree, Chief Justice. If you remember, in the late 2000s, the sentiments, or maybe, in the 2000s, at some point, the sentiment comes in waves depending on, what has happened in a particular time. But I was pleasantly surprised after some period of hostile statements towards the judiciary having been made, and after some judgments, when the court leaders walked into parliament and they got a standing ovation, and it was patently from some of the quarters that had been feeling very strongly that the judiciary is not worth the country's respect. So it changes from time to time.
Commissioner Ngqoito.
Thank you, Chief Justice. Look, on this last point, Justice Dambuza, I think one must distinguish between a popular view and a populist view. I think for the most part, it's the populist views that say we must close down the judiciary and run everything by parliament.
Yes.
But so far, most of the legal questions have focused on Section 24, but I just want to shift the focus maybe to Section 26 and 27, which are the socioeconomic rights provisions, where I suppose some people say also Section 25 is a socioeconomic right, and Section 28 and Section 29. But the core of it is 26 and 27. Now, bearing in mind that we don't have an economic clause in the Constitution, do you think that these sections can anchor an argument in favor of economic equality? And how can you do that as a judge of the Constitutional Court? What are the sort of creative interpretation lens that you can put on that to move beyond the stalemate of an apartheid economy that we've inherited?
Section 26 and 27 anchoring
a right to economic equality.
Well, the right to housing and the right to health care.
Well, I mean, they would say it's
economic
access to
in
housing.
what sense?
They won't say it's a right to housing. They would say it's access to housing, the conservative readers of the Constitution.
But what do you mean when you say right to economic activity?
Well, to economic equality, and what role a court can use those sections to ensure that we have economic equality in the country. In other words, we end inequality. You don't have to confine yourself to 26 and 27.
Yeah, because I was thinking of the equality clause itself as to why it can't anchor any articulated right in that direction.
All right, well,
Why-
let's work on Section 9 then. How can it anchor a right to economic equality?
Well, given that it won't be brought to the court on its own, on a particular context in which it is brought, I do not see why it cannot, and it will be brought for the purpose of advancing the right to economy. I do not see why it would not do so successfully in a given context.
Yes. So you see the right to economic equality as implicit in the Constitution?
I think equality cuts across the board. It could be in the housing, it could be healthcare, it could be in other amenities. It could be in business, it could be in economic. I think Section 22, what does Section 22 talk to?
Section 22.
Freedom of trade,
That's the trade,
occupation and profession. Yeah, I remember that there's some. You know, that's an illustration. This Section 22 already goes towards affirming the right to equal access to economic activity.
Yes, yes, yes. I mean, you don't have to bind yourself on this, but I am trying to answer many critiques about the economic poverty of the Constitution and ask whether or not in other sections of the Constitution it's not implicit that there is a right to economic equality. And so you would say there is, or you would say there isn't?
There is.
Yes.
There is. There is.
Yes, thank you. Well, I'm bringing the next case then, as soon as you are appointed.
Okay.
Then there is the question that has been discussed about delays in judgments. I just don't want to leave that discussion in an unhappy place, that the judge couldn't explain her delays in judgments, and therefore is not giving us an optimistic view of what she will do when she's a judge of the Constitutional Court. So can you just clear up that issue? This is a future-looking appointment, not necessarily a past-looking appointment. In terms of explaining the constraints, I understand there are constraints generally that the Chief Justice was talking about, but maybe there are more specific constraints that you've encountered and how you are going to deal with those, because I don't think the litigants will accept an argument that delays in judgment is an integral part of appellate practice. I think that answer won't cut it among the litigants. It might cut it among the lawyers and the judges who work in the system, but I think the litigants will say, but that's unacceptable. So I just want you to give us a more optimistic note about the future, what kind of measures you are putting in place to solve that problem.
At a personal level, Commissioner, my first step was to be asked to be excused from extrajudicial responsibilities, which has happened, but it did not immediately happen. For example, with my work in the Judicial Education Institute, I could only be released in 2023. And also with the Judicial Conduct Committee, whilst I had been released, I had huge mountains of the judicial judgments that I had to write in the Conduct Committee. So releasing oneself from such commitment does leave room. I had asked to be released from the Rules Board as well, and the process was in the way, but the person who was my deputy, who was supposed to take over from me, assumed duty as the head of court in the Western Cape. But structurally, that at a personal level, that is what one needs to do, particularly when one becomes a senior member of the court and is expected to perform extra duties. Structurally, in the SCA, President Mulimelai has said on many occasions that we need researchers. There's 26, 27 judges in that court that have had to share 7 researchers. It is something that she has been trying to get a headway on. To some measure, she's managed to get more, and from, I think, next term, we're going to have 17. But when a judge has to do all that work, and even the small things like proofreading and no support whatsoever regarding research work, things take longer.
And I suppose it's 7 researchers shared among 27 judges.
Yes.
Versus, I think, 3 researchers for 1 judge in the Constitutional Court.
I don't want to go that far.
2, Commissioner.
2. Oh, I thought
but still,
okay.
A judge gets their own researcher.
Yes, or 2 for the Concourt. So
yes.
at least you'll get someone to do the side checking and stuff.
Yes.
Yes, all right. Then finally, you were asked earlier about whether you introduced any improvements when you were chairperson of the Council of UNITRA. I can confirm, given that I am the current chairman, that you did improve
Thank you.
The standing of the university.
Thank
So
you.
it's much better than it was when you were, well, I don't know. When you left it, it was stable and financially stable.
Yes.
I think for the last 4 years, have had good audit outcomes, and it's thanks to the foundation you laid.
Thank you.
Just one quick question from me. I hope it will be the last one. You're running way behind time. It's an issue that's gnawing away at us. There's a strong push from linguistic communities for the heads of court to revoke their resolution to have English only as the language of record in South African superior courts. And I pose this issue to you as someone who's sat in leadership, in judicial education, and most importantly, someone who's actually sat in a matter in which a bilingual judgment was, English is a closer judgment was produced at appellate level at the SCA, and you actively, but we all participated in that, and so you know how difficult an exercise that can be. I just want your view on how, firstly, important and feasible it would be to accord all our official languages the status and respect which Section 6 of the Constitution enjoins, they should enjoy.
Chief Justice, I think feasibility in context, I think it can be done. I don't see why we can't, if for example, it starts regionally with provision of for official languages in a particular, say, providing for 2 languages per region for use in court. All that I think is required is resources, and I think it would be huge resources. Presently, or the last I knew, I was aware of, our high courts have not enough interpreters, number one. And then, if that is the case, then one anticipates that there would be a bigger challenge with resources that would enable the court and the judgment to be expressed in a particular language, indigenous language, and then translated for the appeal courts, to be given that the judges of those courts come from different language-speaking backgrounds. But if one looks at the international courts, one sees that this can be done. People coming from different countries and witnesses as well that sit and give judgment that is immediately translated for each of the judges to be able to understand it. It can be done and should be done. The challenge is the resources to do it. And it can be done incrementally from the regions until there's a widespread of the practice, I think.
Yeah, you're quite right. It boils down to resources ultimately. the issue of AI was discussed at the recent J20 summit late last month, and it arose during the discussions on that aspect that actually with court online, it would be eminently possible to have automatic translations into as many languages as the user chose. So it appears that it's something that is quite possible, but then we're still taking very small baby steps, literally, as we venture into the age of technology. So one hopes that in that
I suppose
area,
it also goes back to Commissioner Hassan's question on the use of technology.
Yeah.
See, yes.
But something worth thinking about. Hopefully we'll discuss it more at length with more thoughtfulness and solutions when we have the judges' conference next year. Any more questions for Justice Dambuza, colleagues? No? All right. Well, that's the end of your torture. Thank you for a thoughtful interview and for making yourself available for this, Justice Dambuza.
Thank you, Chief Justice.
Free to go.
Thank you, Commissioners.
Colleagues, we are running seriously behind schedule. We are going to have to be creative on how we do things from this point onwards. I propose that we take our short tea break, 10 minutes, stretch our legs, grab a cup of tea, and maybe a bite. There are eats out there. Because I want us to push, we still have 4 candidates to go through. Have tea and then come back and do the 3. Just sit right through and take a late lunch and then come back later for the last one. How do you feel about that? All right. 10 minutes, we'll come back at 12:05. Shall we settle down, colleagues? The candidate has been patiently waiting for us for a while now. Good day, Advocate Dodson.
Good afternoon, Chief Justice.
Are you well?
I'm well, thank you, and how are you?
Good, thank you. It's good to see you. It's been a while. Okay. Oh, firstly, apologies for keeping you waiting now. We can be an unruly bunch, as you would have experienced previously. It's not your first rodeo here. You were born in not far from here in Swaziland.
In Eswatini, yes.
Yeah. But you are a South African.
I am?
You are South African.
I'm indeed a South African, yes. Yes.
You are a holder of 4 legal qualifications.
Yes.
What are they?
BCom, LLB,
cum laude,
LLM, and a diploma in tax law.
All right. Where did you obtain each of these qualifications?
So my first 2 were at University of KwaZulu-Natal, Pietermaritzburg. The LLM was at Cambridge University in the United Kingdom, and the tax diploma was at the University of Cape Town.
All right. Your career didn't start at the bar. You started out as an attorney. Did your articles in 1985 and managed to rise very quickly, I see, in that law firm to head of public interest law, then public interest law department, then later director, partner. How long were you at this law firm, Malinix Incorporated?
I started articles there at the beginning of 1985, and I stayed there until I was appointed to the Land Claims Court in 1995, minus a year spent studying overseas.
And from there you joined the bench at the Land Claims Court?
Indeed, it was a 5-year fixed-term appointment, yes.
How did you find that experience?
I beg your pardon?
How did you find that experience, judicial experience?
It was an extraordinary experience. I was appointed quite young.
Yeah.
I was 35 years old at the time, and it wasn't as though I was fitting into a well-established track that one might have with an appointment to the High Court, for example. It was a brand new court. We had to do everything. We had to find premises, we had to start libraries, we had to draft rules, we had to get a judgment writing style done, and then we had to hear cases that were very novel and under a brand new set of statutes. But I think I took to it like a duck to water. I really enjoyed my time there. The only downside, if I call it that, at the time, there were the circumstances relating to land claims. I was appointed for a 5-year period in anticipation of all land claims being completed within 5 years, but that unfortunately didn't happen.
Is that why you left to do other things?
It was in part, yes. I was a little bit frustrated at the extent to which we weren't dealing with land claims, which seemed to me to be the most pressing item and the reason for my appointment. It was the end of my term. I was a bit worried about what the direction of the court was going to be, and I was young and I felt that there were things that I could do in practice.
Yeah, but then your next area of interest was not far removed from what you had been doing at the Land Claims Court, I would imagine, is UN Housing and Property Claims Commission. What kind of work did you do there?
So that was also an adjudicative body set up by the United Nations to deal with the massive property dispossessions that came partially from the discriminatory regime that was applied by President Milosevic against Albanians, which led to people losing property rights. And then there was a whole range of loss of property rights arising out of the armed conflict. And we had to try to we did successfully set up a process for people to be able to claim restoration of their property rights and a return, to try and promote a return of the rule of law to the property sector in Kosovo. So yes, it was related to obviously what I'd done in South Africa, but we applied different methods. I had some forewarning from what had happened in South Africa about the need to apply different methods to the processing of claims to try and get them done quickly. And we managed to get the job done. We dealt with 30,000 claims in 7 years.
All right. Your stint at the Legal Resources Center as its Director of Litigation, Constitutional Litigation Unit between 2004 and 2006 falls smack bang within your time in that UN engagement. How did that work? How were you at both places at the same time?
The way it worked was this: my initial engagement there for the UN was for a 6-month period, starting from August 2020, when I finished on the Land Claims Court. And then after that, we would have claims prepared for us for decision making, and we would go for a week every second month to process and adjudicate the claims. So that gave me time to establish a career also at the bar at the same time.
Right. And in 2001, you had made the decision to join the bar?
Yes.
Okay. And practiced as a junior until 2011? So says your CV, until you took silk in 2011?
That's correct. September 2011, Chief Justice.
Okay. And how does your practice, what does it look like? What kind of work do you do? Do you have an area of specialty, or you take everything that comes through your door?
I can't say I do everything, but I do a fairly wide range of work. Obviously, my predominant areas of work have been in public law and constitutional law, but I have also done work in the areas of labor law. I do quite a lot of work in the personal injury field, mostly representing, in fact, entirely representing the state in those cases. I have, over the years, developed a reasonable amount of commercial work, but it's not the main part of my practice. And then, as time has gone by, I've done a couple of different areas. I've done a small bit of matrimonial work, and a few things like that. Yes.
Okay. I see from your questionnaire that once upon a time you were a member of the African National Congress. Those ties are no longer existing,
yes,
according to this information. All right.
Yes, I was a member of the Salt River branch of the ANC, and I resigned when I was appointed to the Land Claims Court.
All right. And it is mentioned somewhere that you were once court-martialed. Would you want to tell us a little bit about that during a touchy period in our history?
Yes.
Yeah.
Yes,
refusing
as I
to
disclosed,
do something.
I don't mind talking about it. I have a military criminal record. I was ordered during a military camp to do armed patrols of the townships around the south of Durban, and that would have required me to act completely against my conscience, against my moral perspectives, and against my political perspectives, and I refused to do it. It in fact happened twice. On the one army camp, they accommodated my refusal and they made me stand as a guard somewhere. And then on the second one, they weren't willing to accommodate me, and they said, if you continue your stance, we're going to order you, and if you don't do it, we're going to court-martial you, and that is what happened. So I said, I'm not willing to bend, and I was then court-martialed in the Natal Command, as it was called, in Durban.
Well, you have had an opportunity to act at the Constitutional Court. When was this, and how long was your stint or stints there?
I acted for 2 terms. The first was in the last term of 2023, and the second was in the first term of 2024.
And you wrote judgments during that stint, which have since been delivered?
Yes.
How many?
I scribed, I think I scribed 3 judgments, and I wrote a dissenting judgment.
And you would have penned judgments during your time in the Land Claims Court as well?
Yes, yes, indeed. And there's a list of those attached to my CV where they have been reported.
Yeah.
Yes.
All right. And in the middle of everything else, you've managed to write articles on legal issues, published articles.
Yes, I have written a few published articles, and they've tended mostly to focus on my area of expertise, which is one of my areas of expertise, which is in the area of land reform, obviously arising from my experience both on the Land Claims Court and in Kosovo.
Yeah. You have mentioned that you once had health issues which has since resolved.
Yes, I had a form of leukemia. It had no consequential symptoms. It was discovered by chance, and I've had chemotherapy, and the result of the chemotherapy was completely successful.
And you managed to lead a healthy, active life.
And I managed to lead a healthy, active life. Yes, I try and do a couple of bicycle races each year. I also try not to fall off the bicycle, which is also not good for one's health. But yes, I do lead an active life. Thank you.
I raise this for the large part because of your age. You are 65 this year.
Yes.
How long does that leave you to serve on the bench if you are appointed?
It gives me just short of 10 years. And
another 10 years?
Yes, and that's the combination of Section 176(1) of the Constitution, read with Section 4(2) of the Judges' Remuneration and Conditions of Employment Act.
All right. Okay, I will leave things here for now and hand over to the commissioners to put questions to you.
Thank you, Chief Justice.
Starting with Judge President Lalezi.
Thank you, Chief Justice, and good day, Advocate Dodson.
Good day, Judge President.
Yes, just a quick one. Given your practice in the Constitutional Court, where you appeared and having acted there, is there any special skill that you would say is lacking, that you would have identified that we need to build on at the Constitutional Court?
Sorry, I didn't hear the last part of your sentence. Any special skill that is lacking that?
On that bench, that you would say it needs some attention.
I would not say that there is any lack of skill at the Constitutional Court. Having worked there, I worked together with an extraordinary group of permanent colleagues there who were deeply impressive, quite apart from the fact that they were extremely welcoming and wonderful colleagues to work with. Rather, what I would say is that what is lacking is resources. I think that the Constitutional Court was unfairly allocated a massive expansion of their jurisdiction when they were given a general jurisdiction on non-constitutional issues, with absolutely no increase, it seems to me, in the resources that were made available to them to deal with that additional surge of work which has most certainly come. And there I believe, while I was there, I was able to play something of a role. I became involved in discussions about what might be done in that regard. I wrote a memorandum at the request of the other judges, giving some ideas about how the workload there may be able to be addressed through a constitutional amendment. And in fact, as part of that process, just to try and assist in discussions, I prepared a draft amendment to the Constitution that might cater for panel decision-making, similar to what takes place in the Supreme Court of Appeal, where applications for leave to appeal are dealt with by a panel of 2 judges, or if they disagree, a panel of 3 judges, something which I think could make an enormous difference to the workload of the Constitutional Court.
You say the panel will work well for the apex court, which is the court that's got the last say, where you reduce it only to a few judges to decide an issue.
Sorry, I'm really battling to hear you, Judge President. If you wouldn't mind repeating the question.
Okay, sorry. You said you supported the idea that there should be panels,
yes,
like the SCA. But isn't the difference that the Constitutional Court is the apex court, and you'll be reducing decisions to only a few judges, whereas every judge of that court is expected to have a say on any decision, as the law as it stands?
Yes, no, that I agree with you. That certainly is, in terms of Section 167(2), that certainly is the law as it stands. But unfortunately, there has been a surge, I think, as a result of that expansion of their jurisdiction. There's been a surge in applications for leave to appeal and applications for reconsideration. And some mechanism is going to have to be found to deal with that. While I was serving on the court, Chief Justice Zondo, on a trial basis, brought in 2 retired justices of the court to assist with applications for leave to appeal, but for various reasons that wasn't followed through and wasn't found to be an optimal solution. But some solution does need to be found to assist in that process. For example, if one looks at the Supreme Court of Canada, they have an entire branch of permanent career lawyers within the Supreme Court that provide ongoing assistance to judges with dealing with things like applications for leave to appeal, obviously preparing memoranda and that kind of thing. And there needs to be something that has to be done to assist the apex court as far as that's concerned.
I see. Would you agree that the development and quality of jurisprudence does not lie solely at the apex court? The other courts have got a role to play, and strengthening those courts would go a long way to address even the problem that you have identified.
I would absolutely agree with that, Judge President, 100%.
Yes. And one has noted that it's not every case that goes to the apex court. You might have bad decisions, especially of those who cannot afford to take matters on appeal, having to comply with bad decisions which remain unchallenged.
Indeed. And as you point out, for many litigants, it's a luxury to be able to go all the way through the court system up to the apex court. And that's why the jurisprudence at high court level is so exceptionally important.
Yeah. Given your enviable CV and experience, I would have loved to have seen you maybe attempting to make yourself available starting at the High Court, and maybe also improve the jurisprudence at the SCA level. What's your view? Or is it with you, it has to be at the Concourt?
Thank you for the compliment in relation to my CV. I appreciate that. I have followed a route towards the Constitutional Court that is recognized in terms of Section 174(5) of the Constitution. I have certainly acted fairly frequently in the High Court. I have also seen my time during practice as an opportunity to use my position as counsel to try to also there bring about aspects of transformation. I've tended to focus on cases that make a difference. And I think that in that role, I have been helpful to the high courts. All of those cases have to make their way up through the court system. So, for example, I've litigated quite extensively around the issue of how you deal with compensation for medical negligence claims, and have put a lot of work into presenting cases to the High Court there to give the judges there the opportunity to consider the evidence and arguments we present and to take those forward. So, yes, I started off as a judge in the Land Claims Court. It was a court of equal status to the High Court. I left for the reasons that I left. I've then had a spell in practice. The nature of my practice and the cases I have done, I think, means that I can be of assistance to the Constitutional Court. My experience when I acted there was confirmatory of that, and that is the reason that I followed the route that I have done, and the slightly unusual career path that I have done.
Yes. Thank you, CJ.
Thank you, Judge President.
Commissioner Marumagay.
Thank you very much, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
I have two questions for you. The first question is in relation to Section 167, subsection 6 of the Constitution, direct access. It appears to me that that particular provision is quite clear. The circumstances that can lead to that court attaining direct access to a matter are quite clear. But in practice, it does not seem as if the Constitutional Court has provided clear guidelines as to when a matter will be ripe for it to be heard by that court on a direct access route. I'm not really sure, what is your view in relation to the jurisprudence surrounding Section 167?
I mean, the criteria that it ultimately always comes back to is whether it's in the interests of justice to allow direct access. And my sense is that that's going to be a very fact-driven inquiry as to whether in a particular circumstances something is in the interests of justice. And I think that may lead to a perception of unpredictability about it. But I think there are some principles that are established there. And perhaps the most important one is the principle that's been well established by the Constitutional Court, that their preference is to hear the views of other courts rather than litigants approaching them directly. Obviously, there are cases where the urgency of the circumstances prevent that. But speaking as a practitioner and speaking as somebody who has acted there, I think that it would be something that, as a practitioner, I would always advise a client to be very cautious about. One accepts also from having practiced there that there's a huge workload. One accepts also from having acted there that it's not a court that's designed to deal with urgent applications, because at least 8 of the judges have to participate in the decision-making. It's going to be difficult. So I think, yes, potential applicants do need to accept that their chances are limited of being able to get direct access. The court is going to be slow to accept direct access cases. And I think, with respect, rightly so from the court's perspective.
Thank you very much. My second question is in relation to a case that dealt with the intersection between labor law and competition law, where the court had to consider whether the retrenchment of workers violated conditions attached to a measure approval. That is Coca-Cola Beverages versus Competition Commission. Do you remember that case?
Yes, it's one of the ones that I described.
My sense was there was a need to strike a balance between the expansion and sustainability of corporations in an open market and the need to protect employment. And that case traveled from the tribunal, where the tribunal used the so-called but-for test, the causation test. And then it went to the CAC, which developed a test that one can describe as some nexus sort of test. And when it eventually came to the Constitutional Court, it appears to me that you advocated for what can be described as a true reason test, which was, it appears, might have been crafted somehow by the tribunal in some ways. Now, there has been some criticism that the test that the Constitutional Court has adopted here potentially destroyed the protection given by the Competition Act to employees likely to be retrenched for reasons related to mergers, and to also allow firms to avoid merger protections merely by indicating that there are other reasons for retrenchment, and that the merger played a marginal role in the retrenchment. Based on what I've just said, one, do you think the criticism is fair? Secondly, is there a scope to really use the test that has been advocated for by the CIC? Because there are people who are saying that perhaps that is the test that seems to be protecting employment more than the one that is adopted by the Constitution, by the Constitutional Court.
I obviously reread the judgment in preparation for this hearing, and would also, as with any judgment, read it with an open mind and one that is open to criticism. But I think that if one looks both at the content of the agreements that were reached with the trade unions, in that case in relation to the conditions and the way that they were worded, particularly using the words "as a result of," and if one looks at the statute and applies statutory interpretation principles to it, I think there's a difficulty with a standard that simply is as low, as it were, as some nexus, because it contemplates the possibility that, yes, the retrenchments were not as a result of the merger, but there is some nexus. And I think that would lead to the potential for injustices. The legislation is clear, and I think that the scope is still certainly there for anybody in a future case, provided they're able to prove the necessary causal links as far as merger and retrenchment are concerned, to be able to prevent retrenchments which are truly retrenchments that are as a result of the merger.
Thank you very much, CJ.
Commissioner Nzukai, to be followed by Minister.
I suppose I could waive my right to the Minister, given her proximity to power.
Thank you very much, CJ, and good afternoon, Advocate Judge. Is it Meki? I must make it.
Good afternoon, Minister. Yes,
Dodson.
advocate at this stage.
Advocate Dodson. Thanks a lot. You've done a lot of work around what I would call issues that deal with, or you have been advancing socioeconomic rights in communities, especially the poor and the vulnerable, looking at the work that you have done in NHI land claims and others, and also the work that you've done on class action, especially in the mining space. Do you think that in the manner that our current court rules, and also in the manner that our courts are structured, are conducive enough to be able to assist, especially dealing with class action for communities and in contributing to access to justice?
My short answer is no. There isn't there's a lot that has been done, but there isn't nearly enough that has been done as far as access to justice by all South Africans who want to make use of the court system is concerned. The reason for that is that our system is based on an adversarial system. An adversarial system works well when you have parties on each side that have legal representation, number one, and number two, that have legal representation that is of more or less equal skill and resources and so on. And unfortunately, there are many times where that is not the case. The worst case scenario being when a person is completely unrepresented against somebody who is indeed represented. Of course, there are many things that have been done to address that, and we must acknowledge what has been done since 1994. For example, during my time as a lawyer before being appointed to the Land Claims Court, the legal aid system was hopelessly inadequate. There is a lot of work that has been done to improve the legal aid system under the guidance of some of our leading judges as well. And I think we now have a system where, from a criminal point of view, I think legal aid has done exceptionally well in ensuring that people have the possibility of being legally represented in a criminal trial. Where legal aid hasn't yet come up to scratch is in the area of human rights law and civil law. And there it's a real resources problem. Legal aid needs more funding. We also have an exceptionally vibrant NGO law clinic culture in South Africa, and one has to take one's hat off to the work that they have done in advancing representation of people in South Africa. And extraordinary achievements that they have done. One must also acknowledge the work of the drafters of the Legal Practice Act, who did a great job in recognizing law clinics, creating a proper space for them in the regulatory setup for the legal profession, and also giving them special privileges in terms of the recovery of costs. So I think that has gone a long way in terms of helping people. And Minister, finally, as you pointed out, the introduction by the Constitution of the class action mechanism does provide a very important mechanism for extending justice. In the silicosis litigation, for example, we were able to extend justice to people who'd worked as miners in South Africa but came from countries outside of South Africa's borders. So that does present opportunities. But I come back to my original answer. Sorry, the answer was long. No, I agree with you. There's not adequate access to justice.
And just to follow on that, thanks a lot. And what do you think we should be able to do? Because if we acknowledge that definitely there are challenges, and in terms of what our forebear envisioned in the right to access to justice and for all of us to be equal, but to have equal access to justice, what are the areas you think that you should be paying attention to? But also, you're coming to the Constitutional Court, should you be considered? What role and what input would you make to ensure that such communities that you're talking about would be able to have this right that we talk about, which is fundamental in our Constitution?
In addressing it, obviously, legal aid needs more money. That's the first and a very clear thing. Another mechanism that we had available to us on the Land Claims Court and that has been carried over into the Land Court Act is a provision that says that the court may, in its discretion, act inquisitorially. And when I was on the Land Claims Court, I and other judges were able to use that position when we perceived that there was an inequality of arms between the different parties that might result in an injustice, to see if we could find ways of ensuring that an injustice didn't result. And I think that provision could be extended to other courts. It could be introduced into the rules of court, and I think that perhaps also with an element of training, judicial training, around limited possibilities for inquisitorial intervention, a significant difference could be made. As far as the Constitutional Court is concerned, my experience when I was there is that the Constitutional Court is quite spoilt in the sense that when there was a situation where somebody wasn't represented or there were problems in that regard, there were a range of organizations that were willing to step in and assist, including PABASA, AFT, the Bar Council, and I was impressed at how readily advocates would make themselves available and attorneys would make themselves available at short notice to come and assist and present argument on behalf of parties at the Constitutional Court.
Thank you. Thank you.
Thank you, Chief Justice. Advocate Dodson, I just have two questions. The first one, I suppose, because you are a land specialist, is to ask you whether Section 25 of the Constitution is capable of being interpreted to include a requirement that there should be a right to property equality.
To property equality?
Yes. Or to land equality.
Well, as I read Section 25, that is ultimately its driving force, is to strive to achieve land equality.
Yes.
And I think its beauty, in a way, is it doesn't just say it doesn't just say that there's a right to property, for example. It goes on to give us very specific mechanisms to strive to achieve land equality.
So there is a constitutional right to land equality. That's your starting point.
Yes, I would say so, as interpreted through the redistributive security tenure and restitutionary components of Section 25.
Yes. Now, and at the moment, in the context where we have land injustice and land inequality, we are probably in breach of that section. The government is in breach of that section.
I would be slow as somebody who is a candidate for sitting on a court when an argument like that might come before it,
but I mean, I suppose
to declare the government in breach. And let me also say, in fairness to the state, bearing in mind, in my practice, I act for all sides. I've acted mostly for communities and claimants, but I also act quite substantially for the state, particularly the Commission on Restitution of Land Rights. And I've also, on occasion, acted for property owners as well. I would be slow to simply say that the government was in breach, and I think one would have to, before coming to any conclusion, look at things a lot more carefully and closely. And it's in the kind of specifics where I think you would get answers. So, for example, I was involved in the Lamosa litigation and the Speaker of Parliament litigation, which looked at new claims and their impact on old claims. So it seems to me it's a kind of question that only develops answers in specific contexts. So in that particular context, yes, you had a situation where old claimants, as we call them, people who claimed before 1998, were confronted with not being able to get land justice, many of them because they're old, and it really remains a very big problem. So a solution was found, the government was there found to be in breach, and a solution was found.
Yes, no, I perfectly appreciate that you don't want to commit yourself to the question of breach, but you can commit yourself to the question of principle. But then the second issue that arises from the first answer, which is there is a right to land equality. Is there a right to property equality?
I mean, what's difficult about that is that that's a completely novel area as to what is property. mean, I know, for example, in your judgment in Sibanyoni, you pointed out very correctly and forcefully that cattle constitute property and a very, very valuable and important part of property.
Yes.
But I'm not sure that one could simply at this stage say that there's a right to equality of property. The reality is we live in a country that has inherited a particular economic system. We live in a country that also comes from an era when there was very aggressive efforts at disadvantaging the majority of South Africans, which have left them in a lasting unequal position. But we didn't have a complete revolution when democracy came in. It was a negotiated solution, and that was based on its own choices, policy choices, and has had its own consequences. It's an argument I'd like to leave open for somebody to come and argue were I to be appointed as a judge.
All right, okay. You'll also leave that question open. All right, fine, no problem. Then the second question, the real second question, is around the answer you gave on the mechanisms of the Constitutional Court and why there are delays. I'm not sure if there are delays. I think many judgments are given on time. There are probably one or two that delay. But nevertheless, the real issue I want to explore with you is whether you've done some research with comparable courts. I was looking yesterday in preparation for this interview at the US Supreme Court. They have, for what they call a writ of certiorari, a rule of 4. They get 10,000 applications every year. They hear about 80, but every judge reads every application. Of course, through clerks, and I mean not necessarily personally, you put your eyes over the piece of paper, but through systems in place. But the rule is that every judge must read every application, and if 4 of them want it set down, it will be set down. And once it's set down, if 5 of them agree, that will be the outcome of the court. I don't think the court receives 10,000 applications, the Constitutional Court. I don't know how many cases it has per annum. I'm not sure if it's 70 or 80, which is the same as the American Supreme Court. So somehow you have a system there that is capable of managing large volumes of work, because it's also a court of general jurisdiction. And so there's something else that perhaps still needs to be accounted for to explain the delays or to explain the structural inefficiency. And the question is, what is it? Because it does not seem to be the volumes only. It's something else that we are still yet to point our fingers at. And what do you think that may be?
Sorry, I didn't hear the last part. What do I think?
What do you think that may be the distinction between why the US Supreme Court is able to read 10,000 applications, certify about 80 of them for hearing, and dispose of them quickly? And our Constitutional Court, which does not have a comparable volume.
Your question started with whether I've done research. The only research that I have done was a little bit of reading on how the United States Supreme Court controls their docket and how that came about. But if you read about what happened is a statute was passed. I can't remember which year it was. I think in the last century, early in the last century, a statute was passed which gave the court specifically the power to control its docket. So expressly to exercise the discretion to limit, possibly even justifiable cases from coming before the court to manage its caseload. And if you look at the complaints that came from the judges before that statute was passed, it has a resonance with what I was hearing and seeing when I was acting in the Constitutional Court. The judges in the Constitutional Court work exceptionally hard. They work exceptionally long hours, and there is no shortage of industry on their part to try and get through what they get through. But to me, it seems that one needs to sit down and analyze the problem. And I'm sure that there are ways in which one can work out mechanisms for resolving, getting through the large volumes of applications for leave to appeal. But the reality is that the applications for leave to appeal are taking up, as I saw it, time that should really belong to thinking about and preparing judgments. And yes, I think that when the court needs an opportunity to sit back, analyze where it's going wrong, analyze what can be achieved through a constitutional amendment, and analyze what can be achieved through an increase in person power. When we spoke, while I was there was a visit from the Supreme Court of Canada, and they've got this echelon called the Law Branch, which, as I said, was a group of professional lawyers who have full-time careers there. And I think they play a huge role in getting these applications for leave to appeal ready for consideration by the judges. But they do operate in panels. They're the highest court in the land, and they do operate in panels, both panels in terms of, as I understood it, applications for leave to appeal, but also panels in terms of the actual adjudication of cases. So you can have cases where I think it was 5 judges sit to hear a case and would be recognized as a quorum. And one of the thoughts that I had, I haven't taken it any way down the road, but maybe one could have a system where when the Constitutional Court acts under its constitutional jurisdiction, under that provision, even if only partly, one sticks to the en banc decision-making, the full bench decision-making requirement. But maybe for consideration is when one is dealing with its general jurisdiction, one allows, for example, for a 5-person panel. As I say, I haven't thought it through carefully, but I think there needs to be the opportunity for sitting back, reflecting, and seeing what can be done to manage that caseload.
Thank you, Chief Justice. Thank you, Mr. Dodson.
Just to add to what you said about Canada, I don't know about the U.S. Supreme Court. It probably has the same systems, but most apex courts have sifting measures so that not all process that comes to the court has to have 11 minds of the justices bear, upon each and everyone, even the unmeritorious ones. And this constitutional court is in the process of trying to get a professional body of lawyers, similarly to other apex courts elsewhere, to assist it with these problems. So that's just one measure, and it will be interesting to hear the views from people such as yourselves, Advocate Dodson, on how we can resolve our issues. But I just want to endorse what you said, that justices in that court work extremely, extremely hard. We exchange emails at all sorts of hours on the daily for little or no pay, I may add.
It was really to deal with the concern raised by J.P. Tlalezi, that at the apex court, the litigants expect the benefit of having all of the eyes reading their petitions, but then that's not practical.
Yeah. Okay, it's Commissioner Mangena.
Thank you, CJ. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner.
Can't hear you, Commissioner.
Oh, I don't know what's happening with this. Is it better?
Yes.
Advocate Dodson, I've got one question, depending on the answer that comes. It may be 2. A precedent is an incident of the rule of law. Precedent, stare decisis, right? Now, you are going to, if you are elevated, if you become successful, you'll be elevated to the Constitutional Court, which is the apex court in the country. Can the Constitutional Court depart from its own judgments? And if so, under what circumstances?
yes, it can, but only where it finds that its previous decision was clearly wrong.
In the period that you have been there, and from your reading as well, have we had a situation wherein the Constitutional Court had departed from its own judgment?
Not while I was there, no.
Thank you, CJ.
Any further questions? President, followed by Commissioner Hassan.
Good afternoon, Mr. Dodson.
Good afternoon, President Moremela.
How are you?
I'm well, thank you, and how are you?
I'm well, thank you. My question relates to the provisions of Section 167, subsection 3 of the Constitution, and I confine it only to the general jurisdiction of the Constitutional Court. Now, that provision states that the Constitutional Court has jurisdiction to hear matters that raise an arguable point of law of general importance, which ought to be considered by that court. What, in your view, would be relevant factors for purposes of determining whether a matter raises arguable points of law of general public importance?
If I can just get a moment to have it open in front of me, if you'll just bear with me. But essentially, the court has laid down what its approach will be to the interpretation of that particular provision, and it's really determined with reference to the wording of the particular, the components of the wording of the particular section 167 3B2. So first of all, there's a requirement that leave to appeal must be granted, which immediately brings into play the requirements of interests of justice, prospects of success, amongst others. Then, on the grounds that the matter raises an arguable point of law, and that obviously is quite a well-established test that ties in with that ties in with the reasonable prospects of success criterion. Probably a pithy way of asking, are there reasonable prospects of success in this particular case? And then of general public importance, obviously that brings into play the criterion that the determination of the particular issue in respect of which jurisdiction is sought must extend beyond the interests of the immediate parties to the dispute and have a potentially broader impact for the rest of society.
Yes. So, sorry, if I may come in, just to qualify the question. Leaving aside prospects of success and confining yourself to to arguable points of law of general public importance, can you maybe give one or two examples of what you consider to be such a matter? In other words, a matter that raises important points of law of general public importance. One or two examples.
Yes, I think the example that immediately springs to mind is the judgment that I wrote in the Huntrex case, which related to a servitude to cultivate a garden on a neighbor's property. And that was a case where the respondent specifically said, this is not an issue that deserves the attention of this particular court. It's a fight between two neighbors and doesn't go beyond that. But once one looked at it a lot more carefully, it fell quite neatly within this particular category of jurisdiction, because it impacted not only on the immediate parties to the dispute, but if it was a predial servitude, it would carry on ad infinitum in respect of all future owners. It also emerged on the evidence that registrars of deeds were registering similar servitudes without having regard to whether or not they were indeed lawfully registrable. So yes, that I think would be for me the clearest example that I came across in my experience while acting there.
Yes, thank you, Chief Justice. The second question. So the question, it's actually a follow-up on your previous response, but I want to pose it having given you a preamble of what the Constitutional Court said in two matters. And the question that I'm going to ask thereafter is, under what circumstances should the Constitutional Court consider it not to be in the interest of justice to decide factual issues that pertain to the merits so as to correct the erroneous evaluation of facts by a lower court? And now, in one judgment, the Constitutional said the following, and I quote, "If it emerges from the record that the trial court misdirected itself on the facts or that it came to a wrong conclusion, the appellate court is duty-bound to overrule factual findings of the trial court so as to do justice to the case," unquote, meaning interest of justice. In the interest of justice, then they have to do that. And then in a second judgment, the Constitutional Court said the following: "The public interest will be best served by prompt resolution. Such resolution will help to correct the wrong decision before it has further consequences on one hand, and to avoid delay and inconvenience resulting from the failure of this court to hear the appeal on the other hand. The evidence is sufficient to enable this court to deal with and dispose of the matter without referring it back to the Supreme Court of Appeal for reconsideration. It goes without saying that the interests of justice require this court to entertain the matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment and administration of justice." And it went on to say, "It seems that in the circumstances of the case, we should not follow that route," in other words, the route of remitting, "but we should determine the appeal ourselves. This is because this court does entertain direct access appeals from the High Court in appropriate cases. The matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us." It goes without saying that the interests of justice require this court to entertain this matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment of the administration of justice. And then they went on to say, "The matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us again in any event. We have already heard full argument, and we should avoid having to hear the matter for the second time. The route I propose to follow will avoid a duplication of costs," unquote. I then pose this question: when will it not be in the interests of justice for the Constitutional Court to decide a matter where factual issues have been raised, but there was an erroneous evaluation of facts by a lower court? So remember, at first I said you must give examples of when it would be in the interest of justice to consider those aspects, and now the question is, When is it not in the interest of justice to deal with matters that are raised in a particular case that are considered to be raising important aspects, points of law of public importance that pertain to factual issues? I hope you understand the question. Thank you.
My understanding of the issue in relation to factual issues is essentially that has been laid down since S versus Bosak by the Constitutional Court, and that is to see factual disputes as issues that actually fall outside of its jurisdiction. As I recall, and I can't immediately think of the cases, there may have been exceptions made in particular circumstances, but the basic rule, and the rule that was applied while I was acting in that court, was that we do not have jurisdiction in respect of purely factual disputes. That, along with a related category, which is where there is a well-established rule or principle, and the lower court gets that rule or principle right in terms of its articulation, but doesn't correctly apply it to the facts, there too the court will not assume jurisdiction in those cases. So it seems to me that unless there's a particularly unusual circumstance, that is the way that the Constitutional Court would deal with those factual matters. They would see them as jurisdictional, and they would decline jurisdiction in them. As I understand the other part of your question, it relates more to when will the court simply go ahead and decide the issue itself, or when will it remit to the Supreme Court of Appeal. And my sense is that the main criterion that would be applied in those circumstances is to ask, do we need the input of the Supreme Court of Appeal on this issue, having corrected whatever the Constitutional Court has corrected? Do we need the input of the Supreme Court of Appeal on this issue before we come to a final conclusion, if it were to be sent back to us again following the SCA's adjudication, or it might end at the SCA if there weren't any further appeals? And to give a particular example is the Supreme Court of Appeal, they're the experts on the common law. So it seems to me that where there's a tricky issue pertaining to the determination of the common law, that might very well be an example of something that they would be inclined to remit to the Supreme Court of Appeal so that they get the benefit of their views, either by way of that presenting a final solution of the case in the SCA, or by way of, if it were to come back to them, they would then have the benefit of the SCA's expertise in that area.
Thank you very much, Mr. Dodson. Thank you, CJ.
Follow up? Thank you, Chief Justice. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner Pillay.
Just in relation to the question posed by President Molamela, how would the Constitutional Court's recent judgment in the Vodacom matter make a difference to your answer, where the court upheld an appeal based on the failure of the duty of proper consideration, and held that in limited instances where there's been a failure of justice, that would constitute a ground of appeal because it's a failure of Section 34, fair hearing right?
So, unfortunately, I read the judgment on the day that it was handed down, and I haven't looked at it since then. But my sense is that the reasoning, if my recollection is right, that the reasoning is related to the point that I was making in relation to hearing the views of the next court down in the hierarchy on the issue. And the concern that was expressed in the Vodacom case was that there was no clearly discernible path of reasoning in the judgment of the Supreme Court of Appeal, and that for that reason, in a sense, they hadn't actually used the opportunity when it was in front of them to give a clear legal answer to the issue. And my understanding is, for that reason, it was sent back, for consideration by a differently constituted bench, so that the court could express itself with a clear path of reasoning that would allow either the matter to be resolved there on the basis of a clear path of reasoning, or come back potentially to the Constitutional Court, but in circumstances where the Constitutional Court could see more clearly with respect why the Supreme Court of Appeal had arrived at a particular conclusion.
Chief Justice, I have a second question. May I place it now and then I'm done? Thank you. Advocate Dodson, your application was made in June 2025. And in August, the judiciary adopted its sexual harassment policy. Just to check firstly that wouldn't in any way have deterred you from applying, had the policy been adopted prior to you bringing the application?
Not at all. I've read the policy. It is an exceptionally well drafted, well thought out document, extremely impressive. It puts in place sensitive mechanisms for dealing with the issues. It hearkens to the rights in the Bill of Rights as a guiding criterion in the way that it is laid down. It creates a special office to deal with these issues. Extremely impressive document, and I would not just not have an objection, I would fully support it.
Now, Section 5.1 of the policy states that sexual harassment violates, amongst others, Articles 5 and 6 of the Judicial Code of Conduct. Article 5 refers to the duty to act honorably, in a general sense, not confined to your judicial tasks. And that's reaffirmed by Article 6, which says that a judge must at all times, even in relation to extrajudicial conduct, comply with the law. Now, do you believe that the policy should apply to extrajudicial conduct?
Yes, absolutely. Absolutely. The reputation of, the starting point is the victim. No person should be the victim of sexual harassment in any circumstances, at court or away from a court by a judge. So I have no hesitation in endorsing that. And from the point of view also, secondarily to the victim's rights, the reputation of the judiciary. The reputation of the judiciary is done irreparable harm if somebody were to be involved in sexual harassment, even away from the court, as it were.
Thank you, Advocate. Thank you, Chief Justice.
Commissioner Son?
Thank you very much, Chief Justice. Advocate Dodson over here, thank you. I wanted to ask a question as one of the younger commissioners currently sitting on the JSC. Many young South Africans, they're sort of increasingly questioning whether the Constitution still works for them. And of course, this is born from a number of different socioeconomic issues. But from your vantage point, what must the Constitutional Court do differently to regain the trust of a disillusioned generation?
I'm not sure that I can accept the premise, which is that the Constitutional Court as an institution has lost the trust of the younger generation of South Africans. But I have three adult children, so that's my feed-in, as it were, perhaps to that generation. What I can certainly understand is a potential loss of faith in the Constitution itself because of the...
That's actually what I meant, in the actual Constitution and the delivery thereof. So you're not wrong in your first assertions.
That I can understand. The particularly the rights from Section 23 through to Section 28 are rights in the Bill of Rights that embraced a unique promise to South Africans. yes, a number of those rights come with a built-in reality check in the form of progressive realization, but still they hold a promise. And if you drive through any informal settlement or something like that in South Africa, you can see starkly and in your face that we're still a good distance off realizing those rights. So yes, I can understand that the loss of trust in the Constitution, and yes, it must automatically follow from that the courts, all of them, including the constitutional courts, must be mindful of that, and mindful of the need to keep faith in constitutional democracy and a society regulated on the basis of the rule of law. The best I think I can say is that those rights set a standard for adjudication which must be taken into account, and the concern you've raised must also be considered in that decision-making process.
I think just related to that, you've mentored quite a number of younger advocates. And so my next question, or sort of related to this on young people and youth, is what would that mentorship for your element look like inside the Constitutional Court, but more particularly, how can the court become an active incubator of diverse judicial talent as opposed to just a recipient of it?
I believe the court has done exceptionally well through its clerks program. It's been there for a long time. It takes place under a system of mentorship and supervision with 2 clerks allocated to each of the judges, and it presents an extraordinary opportunity for them to learn and grow through the process. I was blown away by the level of responsibility that is given to the clerks. I was blown away by the level of access that is given to the clerks to the decision-making process. Pretty much every email that you send in the course of deliberations copies in the clerks. So that was certainly something I didn't anticipate, but it's what is there. And I see the product of that approach on the part of the judges of the Constitutional Court in some of the attorneys and advocates that I work with in the course of my practice. It has produced and continues to produce the most exceptional and talented lawyers in this country. So, yes, I think substantially through the clerks program they're getting it right, but there's always more that you can do. And I don't know if having spent 2 terms there provides me with a sufficient basis to critique the court, but it has an open day in which there's an accountability to the public. And it also seems to me that if one is to accept that there could be an echelon of permanent career lawyers within the administration of the court to assist the judges, that would also provide exceptional opportunities for developing people in constitutional law.
Last question, CJ. You've chosen, advocate, to stay largely in practice and in public interest work. Why do you think it's important that the Apex Court also includes voices from outside the bench or this permanent sort of judicial seat? And what perspective do you believe that brings yourself in interpreting the Constitution in a very rapidly changing society?
So just to make sure I'm understanding your question correctly, you're talking about people who come something along the lines of the route that I've followed into the court and what they can bring to bear in the court's decision-making.
So traditionally, people who apply for a position at the CC, of course, have been sitting judges for a very long time. So I'm interested in your perspective as somebody who's chosen to stay in practice in that way, dealing with public interest work. What benefits, what disadvantages, et cetera, et cetera?
Thank you. I believe that, number one, the Constitution is designed to accept people with other career paths through the provisions of Section 174(5), which allows for up to 7 of the judges not to be serving judges at the time that they're appointed. And I think that that isn't a fossil from days gone by. I think that there's a reason behind it. And that is that in your apex court deciding such important issues, you want ranges of diverse experience influencing your decision-making process. And I think that the reality is if you accept people who might come from academia, for example, perhaps also having been given the opportunity to act as judges as well to round off their academic experience, if they've perhaps acted in the high courts, you can bring important influences to bear. Also, from the point of view of practice, I don't think should be seen as something that is a zero or a negative in terms of what your credits, as it were, are for an appointment to the apex court. I think it is helpful for the court to have somebody there who's argued through all of the different levels of court. And there are interesting parallels and differences in the kind of mental processes that go on. For example, in the preparation of heads of argument. Preparation of heads of argument and the presentation of argument. Preparing heads of argument follows a very similar intellectual process to preparing a judgment. And I think is important experience for the purposes of drafting judgments. One's heads of argument are there to persuade the court to decide in your client's favor. When you write a judgment, what you're doing is seeking to explain, give it another word, persuade, the party that you're deciding in favor of, that the correct decision has been arrived at. So there are similar trends. There is also sometimes, and I say it a little bit tongue-in-cheek, a propensity on the part of judges who've been judges for a very long time to forget how tough it is out there arguing cases as counsel. And maybe having somebody who's been counsel more recently amongst you is something that brings a different perspective. But that's not obviously my main submission. My main submission is allowing people who followed a different path enriches the decision-making process of the apex court.
Commissioner Moimong.
Thank you, Sajai. Good afternoon, Advocate Dodson.
Good afternoon.
Let me just build on the first question posed by Commissioner Hassan, but it will be also in relation to one of the judgments that you have raised in your questionnaire, Lamosa judgment.
Sorry, which judgment, Commissioner, if I may ask?
Lamosa judgment.
Lamosa judgment, yes.
Yes. The question posed by Commissioner Hassan in relation to the confidence of young people in the ability of Concourt to dispense justice for all and the values as enshrined in the Constitution. In that judgment, the setting aside of restitution of land rights Amendment Act of 2014. In response to the question posed by Commissioner Nkaitobi on the property equality and the referral to the government being in breach of promotion of property equality. Don't you think that because the government, through that act, wanted to go further in relation to the Restitution of Land Rights Act of 1994 by reopening the land claims from 2014, to 2019 was an attempt on the part of government to bridge the deficiencies in expediting land claims. And don't you think that those land claimants that lodged their claims between the 1st of July 2014 and July 2016 would then, in the face of that act being set aside, lose confidence in the ability of the Concourt to promote justice for all, because the claims that they lodged were set aside because of the Concourt judgment on Lamosa? Thank you.
Just, Commissioner, respectfully to start with the correction. The claims that were lodged were not set aside. They were recognized as having been validly lodged. And what the court did, though, is that they put them on ice. They said, we're going to hit the pause button, as the Commission must hit the pause button as far as those claims are concerned. And the reason that they did that is the terrible situation that we have in South Africa, where people who lodged their claims by the 31st of December 1998 were promised a right of restoration of their land. And tragically, the vast majority of those people are elderly people. The impact of intruding into the process, the 2014 now to 2016 claims, was to present the potential for still further delay. People have waited for close on 30 years to have their claims adjudicated. And I speak obviously in a partisan way because I was effectively representing those elderly claimants whose right to have their claims processed before they died was prejudiced by those new claims, as we called them. So I don't see that court judgment, if there's a proper understanding of what the court was trying to achieve, I don't see it as a basis for a loss of trust in the court. It was really an act to try and come to the assistance of realizing elderly people's constitutional rights, and to make sure that things were done in an appropriate sequence. They'd gone to the trouble of lodging their claims before the 31st of December 1998. They were elderly. They were entitled to be first in line. But the court didn't knock out the claims that had been lodged. No. It said the moment that the processing of the elderly claims has been completed, then processing can start. And there were also exception clauses in the order that the Constitutional Court formulated that said there's a particularly justifiable reason for somebody in that part category to come to court. You can approach the court and ask for relief.
Thank you, Advocate.
Thank you, Commissioner.
Thank you. No further questions. All right. We have reached the end of your interview, Advocate Dodson. Thank you very much for making yourself available and not giving up on us. Wishing you all the best.
Thank you, Chief Justice, and thank you to all of the commissioners for the hearing you gave me.
point of general public importance. And I take the point that there have been judgments that have tried to give an indication that perhaps maybe if the issue is only fact-related and does not raise points of law, I understand that. But I think between me and you, we know that sometimes there can be a conflation between facts and law. And it's not a really clear-cut situation as to say the factual issues. What is the actual criteria that the Constitutional Court actually uses to determine that this particular case can be entertained because it engages this leg of the jurisdiction?
You ask a difficult question because you're quite correct, I think, Professor, that the jurisprudence is perhaps still developing. One can read some of the judgments, Paulson, Slipknot, that judgment, which is really the one that sets it out most clearly. But in subsequent judgments, I do think that the criteria haven't always strictly been spelt out as to what would constitute completely an arguable point of law. And there is a measure of flexibility in the application of that test, which does make it difficult from time to time to follow exactly what the basis is. I think it is often also the case that it's difficult to distinguish a matter that would be purely and simply a matter of general jurisdiction, as opposed to, and having absolutely no constitutional implications whatsoever. Because matters of general public importance, where interests of justice come into play, may touch upon, and in fact at times do impinge upon, broader questions of the application of the court's constitutional jurisdiction. So I agree with you that I think it's not an area that is yet finally clarified. And it's an area where there is certainly scope for, if you like, more nuanced development.
Thank you, Judge Goosen. My actual second question is, there is a written case that was heard. You know, the beauty about the Constitutional Court nowadays is that most of the hearings appear on social media, so you can follow them in real time, right? There is a written case that was heard by the Constitutional Court. It's the rent manipulation case. That's what I call it, where there was issues about rent manipulation, cartels, and all those kind of things. But I'm not going to ask you about the actual case. What came out from that case? It painted a very unfortunate picture, in my view, which is still persisting even today. It appeared to me that most of the counsel that appear in the Constitutional Court are actually white, and white males in particular. And you'll find sometimes white females, and you'll find the usual black counsel that appear in that court. And it seems to me that the issue of briefing, it keeps on recycling itself. The bench is black, the bar is white, perpetually. Is the Constitutional Court as an institution, or does the Constitutional Court as an institution have a role to play in trying to change these briefing patterns where black, and we have a lot of black competent advocates who are not given a chance to appear in the Constitutional Court? What can be done to change the mindset and to say, can we please be in South Africa and grant opportunities to these competent black people?
Yes, thank you. Again, it's a difficult question. Difficult because I think generally the courts, whether in the High Court, Supreme Court of Appeal, or at the Constitutional Court, the courts really have a limited role, or there's limited scope for the courts directly to impact changes or required changes in briefing patterns. And that's simply because the courts, they are engaged by the parties at a stage when attorneys or counsel have already been briefed. They're the ones that bring the court. So engagement at that level, I think there's possibly limited scope. There's undoubtedly scope for, if you like, at the level of public expression of the need for thoroughgoing transformation within the legal profession, for judges in their public presentations, whether it's by way of lectures or talks or elsewhere, to offer and lend their voices in support of that process. As far as the Constitutional Court is concerned, I think slightly different. It's not an immediate direct impact on those briefing patterns, but I think if you look carefully at the contribution that the Constitutional Court has made to the empowerment of young practitioners, the clerking system has been an enormous fillip for transformation within the profession. By far the majority of clerks, certainly that's been my experience, most recently seeing who was there, but certainly over the years, the clerks who've been appointed, many women, many black practitioners who have gone on to make significant contributions within the profession. And I think that's a direct contribution that the Constitutional Court does make. So it's that training, mentoring, making available skills, if you like, ultimately. But it remains a difficult challenge, where, if you like, a particular expertise is still within the control of maybe a relatively few practitioners.
Thank you very much, Judge Kutzen. Thank you, CJ.
You keep... That's not how it works, though. I pick the first hand I see. It has nothing to do with seniority. But go ahead, Minister. And thanks, Advocate Ngoto. Yeah, we seem to have correlated. Thank you very much. Good afternoon, Judge Hossan.
Good afternoon.
And thank you very much for your reflection. And if I can correctly, and you'll correct me if I'm wrong, what you just reflected now, you gave an indication that in relation to transformation, because you speak into briefing patterns and others, that you acknowledging that we not have done so much that we should have, and I hope I'm correct in listening to how you just summarized. And this brings me to your article that you wrote, I think in 1989, the debate over Africanism, Africanization and the position of women. And I can hear those articulations still coming through, because in terms of the issues that you are reflecting, yes, noting that the court might not have a direct impact and work to do, or even the Constitutional Court in terms of transformation, but given your views then and what you are reflecting today, What do you think we need to do to change the status quo? Because you're clearly saying to us that if we could have different briefing patterns, we'll see. I think if I heard you correctly, and if maybe I did, you'll correct me. The issues even how the SOC comes through in terms of previously disadvantaged individuals from where we're sitting. Maybe if you can share some views and ideas, what is it that we need to do? Because as much as you'd be a constitutional court judge, we do not want to see the values and the principles of the Constitution that we so follow and believe in not being reflective of our society. And therefore, those who appear before you as a judge would definitely have to reflect what we have as a South African society and actually show that equality within our courts.
Yes, indeed. Some of the suggestions I would put up, or views I would express, are of course, and they must be read against the fact that I've not, been a judge now for a number of years, and so I'm not engaged, if you like, in the hurly-burly of practice and at the bar, where I think that's really where the primary responsibility would need to rest. That professional bodies like the bar, Advocates for Transformation, the BLA, General Council of the Bar, and other organizations are engaging in, if you like, far more practical steps. I'm not suggesting they're not, but very practical steps to build a culture of mentoring amongst practitioners, and to ensure that those skills transfers are happening effectively. That's on the one hand. But in terms of briefing patterns, that's the decision that's generally taken by an attorney or a firm of attorneys to brief particular counsel involved in arguing a matter. And I think those briefing patterns, really there we need to be addressing those firms and in ways that are that may be more persuasive, more direct in a way. So you have to engage in a programmatic commitment to shifting patterns of briefing. Because if you don't do that, really what you're doing is you're limiting the scope for the reproduction of a effective, independent bar that can thrive in this constitutional democracy. So we really need to be placing that emphasis on where those decisions are taken. I know, for example, and this is just that within the state attorney, there are, really from when I was practicing, quite different briefing systems that now apply. My impression from the outside is that it is having a positive effect. It may not be enough, but there's undoubtedly a need to strengthen those initiatives as far as we possibly can within the profession.
So in terms of within the judiciary itself, having been the judge, the acting appointments of judges, in my view, does provide an opportunity as part of those who would gain experience as we talk about skills transfer, access to opportunity to be able to be sitting on the bench and deal with complex matters that might not come to you as an advocate. What do you think should be done within that system to be able to increase the opportunities for those who are previously disadvantaged to be able to have access to those opportunities as part of transformation? Should we have a framework that needs to be coming into place, or should we be just continue? So I'm trying to see whether you think that could be another tool that we utilize, and how effective can we utilize that tool?
Yes. Well, I think there's no doubt that giving practitioners the opportunity to serve as acting judges it does an enormous amount for the development of those practitioners. My own experience, and I think this is probably true of most acting appointments, is that you come away from a period on the bench with perhaps a slightly different view of how matters are run, and your level of experience, because you're exposed to a range of different matters which you may not have been in practice, that certainly is a positive thing. Largely, acting appointments really fall within the ambit of authority of the head of that court, and I'm not aware of how those systems always work. Sometimes they work slightly differently in different divisions. But it does seem to me that the judges president of the divisions are very conscious about the fact that they're needing to find and develop talent that can be appointed to the bench. Having said that, I think it is also important to understand that, I mean, the primary responsibility when one's dealing with filling temporary vacancies on the bench is that the judicial work is done, so that it may not be a primary function of mentoring and training practitioners. It has that spin-off effect. I don't know whether a framework. I know that there have been discussions at in some divisions, for example, about trying to work out what types of criteria should apply in inviting people to act. I'm not aware of any developed framework at this stage, and it may be that that's something that the heads of court could pay some attention to.
Commissioner Trolley?
Sajai, can I make a follow-up on this question?
Sorry, is that you?
Yes.
All right.
Justice, how are you?
I'm fine, thank you.
I don't know whether I missed it somewhere, Justice. I didn't get you exactly as to you as an individual.
Yes.
During your time as a legal practitioner and even now, what is it exactly that you have done to support the cause of transformation?
Yes, thank you for the question. I think it's clarified in point form the sorts of roles that I fulfilled when I was at the bar. I was very directly involved in the pupillage program, and both at the local bar in the Eastern Cape, ultimately was involved in directing the national pupillage program for the bar, and that involved trying to get a standardized system of tutoring and lecturing and so on happening at each of the bars. We had a very full curriculum and material to go along with it to assist pupils. I was also involved in advocacy training, again through the General Council of the Bar, so specifically running programs for teaching advocacy skills to pupils and young practitioners, and even at an advanced level. Within my practice, I tried to engage young practitioners as juniors, assisting them as far as possible. So I think that, I think if you read the Advocates for Transformation comment, which was submitted, it highlights a range of that type of activity that I committed to throughout my time at the bar.
And perhaps I should just go back one step and do something I omitted to do when I was leading you earlier, that your work towards transforming South African society is said to go back to your early days, and one guest is from Nadel, which one of your nominees, and former President Mpati, and the GCB, which has commented on your candidature, and they tell a story of a young man, a young white man who was a vigorous political activist. Among his exploits, defying his military call to serve up in the defense force of the apartheid regime, campaigning against compulsory military conscription during apartheid, representing activists who were prosecuted for their opposition to the apartheid regime, communicating with communities about the state of emergency while representing detainees, and that you were involved in the ANC, you were in the executive committee of the United Democratic Front, and you represented the widows of the Craddock Four. You were deeply involved in the work of the liberation movement, and that spilled over to your legal career. Yes. I should have done that earlier.
Thank you.
So your stripes in that respect are unquestionable.
Thank you, Chief Justice.
Commissioner Jivan.
Thank you, Chief Justice. Judge Gust,
sorry.
As practitioners, we are faced with time constraints all the time. Even before we instituted action, we've got to see whether we actually have met any time constraints prior to instituting the action. I see that the judgment that you've attached to your papers on page 104 was heard on the 23rd of November and was delivered on the 27th of May the next year, which is a lapse of some 7 months. That's a concern to me as a practitioner. And what's the average period of your handing on your judgments, and how do you think that we can better the situation to get courts to hand down judgments more speedily for the betterment of the litigants and all concerned?
Yes.
Thank you.
Yes, thank you for the question. I've not worked out what the average period is. I'm pretty diligent. I think the comments of the law bodies too point to that. I try to get my judgments out as rapidly as I possibly can. It's not always possible to do that, but I do think I am relatively prompt in getting judgments out. I think in the case of Buerta, yes, I think the judgment was delivered in May. It was heard in November, but and I mean, there was in fact in that judgment a dissenting judgment, former Justice Deputy President Petse at the time. So, and I, the procedure is that the scribe, the scribe, you will write your judgment, circulate it, and there will be an engagement. Obviously, if there's going to be a dissent or a concurrence, then one has to wait until that concurrence comes through. And only once it comes through can you finalize the delivery of the judgment. And again, I really don't want to criticize Justice Petse at all, not at all. He was, as Deputy President, extremely busy. But that would have been a reason for the slightly longer period that it would have taken, the time to get the dissent in and finalize and then hand it on.
I understand. Thank you. Just the second part of my question,
yes,
then is that we as practitioners, and we've got a public, remember, we've got a public that's well educated because of all the technology tools that are available to them. It's a different public compared to when we didn't have this wide internet dispensation of information. Now, as practitioners, we've got to tell them that, look, why is it taking, the questions we usually face is, why is our case taking so long? Why is my case, why aren't you progressing my case? So we are in the situation where all we can say is it's in court and we're waiting for judgments or something like that.
Yes.
So the second part of my question is,
yes,
how can we streamline judges and all the courts for that matter, all the high courts,
yes,
and goes down even to the magistrate court level,
yeah,
where we can get them to deliver judgments speedily, and hence create a better impression of the law to the public we serve.
Yes, thank you. Forgive me for not answering the second part of the question initially, and for drawing that to my attention. Practitioners, I think, are in an invidious position. Your hands are tied in the sense when you're having to deal with the court respectfully. You're not wanting to be perceived in any way to be badgering the court, considering a judgment and handing it down. So I fully understand the dilemma that practitioners face, because you've got to answer to your client. I think the broad framework of the Code of Conduct and requiring that judgments are delivered within a period of 3 months at the latest is an attempt to deal with that difficulty. But the mechanism, I think, and maybe this is the thrust of the question and the suggestion from my side, is that it may be necessary to develop a protocol by which practitioners can engage with the bench that heard the matter, possibly even prior to the 3-month period, to obtain a clearer idea of when the judgment is likely to happen. And I say a protocol or a framework because you as practitioners might need to be protected from the accusation that you're badgering the bench unnecessarily. Again, that may be something that, as between the practitioners and the heads of court, is something that might be considered a way in which you can obtain better feedback, more valuable feedback about the process by which a judgment is being prepared and what might be reasons for a delay. For instance, in this instance, I mean, we would generally not disclose to the public out there, well, there's a difference of opinion in this matter, and that's why it's taking a bit longer, because I don't think that that's appropriate. But at least you could get some indication that there is a delay for ABC reason. That may be something to consider.
Thank you, Judge.
Apologies to you, Commissioner Trollip. I mistook his hand as a follow-up question. I do have follow-up questions, though, from Sesi, Commissioner Baloyi and Commissioners Baloyi and Kaitobi. You pass? Okay. Commissioner Trollip.
Okay, what about, all right. Anyway, carry on, Commissioner Trollip. I don't think you've spoken for the whole morning.
No, I haven't spoken once this morning. It must be my turn. Thank you very much, Chief Justice. Thank you, Judge Wilson. I'm partly covered by Commissioner Shabangu and what the Chief Justice mentioned around your commitment to transformation. It's generally agreed and accepted that you and I come from advantaged backgrounds. And some people are often blind to that. And I noted in your application that the extensive commendations, individual and from organizations, around your commitment to transformation in word and deed. And I was just wondering whether you could tell us where that commitment comes from, what incubated it and what has sustained it.
Yes, thank you, Commissioner Trollip. So I grew up in first formative years in a sort of working class suburb of Port Elizabeth. My family, my parents weren't particularly well off, but I was fortunate, despite that, to attend a private Catholic school, Marist Brothers College in Port Elizabeth, which is now since closed down. And my parents struggled to keep me in the school just because it was a private school. The fees were different to those that applied at the time to public schools. But I was able to access that education precisely because I was growing up in a white, privileged society where access to education was skewed, subsidies were provided to schools on an entirely different basis. So, I'm very conscious that that's the case. But it was at that school where I was exposed to, and very fortunate to be exposed to, I suppose, more progressive way of looking at the world. I mean, two things happened in 1977, when Steve Biko was murdered in detention. He had been held at the Warmer police station. The Warmer police station was directly alongside a supermarket, OK Bazaars, where my mother worked. I used to go there afternoons after school to wait to get a lift home. So I was very familiar with that area. I'd spend a lot of time, in fact, at the library, which was directly opposite Warmer police station. So when news broke about Biko's murder in detention and the fact that he'd been held at Warmer police station, I mean, that was, for me, that was like a profound shock to my system. That this could be happening literally across the road from where I spent quite a lot of time in the library. I was fortunate at the school to have a history teacher who gave me a copy of the Freedom Charter when I was 15 years old, told me about the Congress of the People. Also told me I should not tell anyone else about it for good reason. So, those sort of things change your life in a way. You begin to get a sense that different things are happening all around you that you are not necessarily immediately aware of. In 1978, I was taken by I would call him a radical priest. He was involved in young Christian workers in Port Elizabeth. Himself had been detained several times. But he took me into the townships of Port Elizabeth, into New Brighton, Zwede, to the northern areas. I met young activists. I met some of the activists who, in 1979, a year later, established COSAS. So, that was the privilege that I had, and it came from where I was in my circumstances. So that was the incubation. I was never going to not be concerned with social justice, having had that experience. And so I tried when I went to university, and subsequently have tried to apply my the privilege of a good education to make a difference as far as I could.
Thank you.
Okay. Commissioner Mokgweethu?
Thank you, Chief Justice. Well, you will be glad, Judge Khosa, to know that Steve Biko's inquest has been reopened by this minister sitting here. I wanted to ask you about the question on transformation and what role judges might play. Your answer, as I understand, is that your hands are tied as a judge.
Not quite. Yes, partly. But let me hear the rest of the question.
Yeah. All right. I want to give you one example. The Chief Justice of England and Wales issued a practice directive in 2023. I'm not sure if you're familiar with it, in which she specifically said women advocates or barristers do not appear frequently in the Supreme Court. Yet they play a meaningful role in the preparation of argument and papers. But the glory as such is taken by the men who appear in court. And in that practice directive, she said that when a female candidate, a female barrister, has been intimately involved in the matter, they should be given a portion to argue, and gave the rights to the judges to issue their own practice directive on a matter-by-matter basis, in which they make a similar directive. Now it's 2025, I don't know the impact of that directive, but that came from the Chief Justice of England and Wales, illustrating that we sometimes complicate the problem of transformation and the role that judges can play. One of the unique features of the Supreme Court of Appeal is that most of the people who speak there, who open their mouths, are men.
Yes.
And the president of that court could issue a directive saying, I want to see more women speaking. If you are arguing a matter on eviction, I want maybe Section 4 to be addressed by a female junior who is there sitting in court and watching. So what is the reason why our judges have taken such a conservative view on intervening to redress the problem of transformation? I mean, Judge Mota has been sort of seen as an outlier when he said, I refuse to have white men speak in my court. I want to see more diversity.
Thank you. Thank you for the question. Yes, just to correct, you're right when I answered the question that I was suggesting that perhaps there's limited intervention that we can make as judges. But the example that you give, I think, is a good one. There is no reason why, and maybe this is particularly in appellate courts, where one often has more than one counsel involved in matters for the parties. There is no reason why something along the lines of a practice directive, which requires that the parties make use, if you like, of the full panoply of counsel in the presentation of argument. That certainly, I think, is something that one can look at. Why are judges reluctant to do that? It's difficult for me to answer that question in this sense. That yes, we can, when you're presiding in a matter, particularly at a trial court level, you are the the director of the process and proceedings. So from a high court level, yes, perhaps there is a need for judges to be a little bit more interventionist in how the presentation of matters is dealt with. Presiding judges in the appellate courts, of course, could do similarly. But at a systemic level, I think the idea that one could regulate the presentation of argument in the appellate courts is certainly something that one can look at. I'm not sure, and I haven't considered whether it's the sort of directive that would fit in with the sort of general powers of issuing directives as far as the Superior Courts Act is concerned. Offhand, I can't think of a reason why not.
Yes, and it might be better for the judges that the person who drafted the papers argues the case.
Yes.
So that when you ask, where is point X, they know exactly where to find it.
Yeah.
They don't look back.
No, correct.
Yes. Now, I want to ask you about your philosophy, because you are now going to the Constitutional Court. In a sense, I'm familiar with your philosophy, having appeared a number of times in your court. If you recall the case of Mazodzo versus MEC for Education, yes, in which you interpreted Section 29(1)A of the Constitution as imposing a directly enforceable right on the part of parents of children to demand the delivery of textbooks. Sorry, it was desks and chairs there. Yes, but following from the Section 27 case on textbooks.
Yes.
Do you think that approach should apply also to Section 26 and Section 27, and that we should perhaps jettison the reasonableness approach in the light of the prevailing levels of inequality, despite a constitution that promises to end inequality?
Yeah, I suppose the first challenge there is that one would have to deal with sort of jurisprudentially, philosophically, if you like, is the way in which those sections are framed, the sort of more, you know, that they're, it is less about the imposition of an immediate and as opposed to the education requirement. But notionally, no. I think that there is no reason why one could not adopt a more robust approach to those sections. I mean, that's certainly been the case as far as housing is concerned, and you will know the sort of arguments that occurred following the Grootboom judgment as to whether it had gone far enough and how that should be interpreted. There is undoubtedly scope for that development. I mean, this is the beauty about the Constitution, is that it is not fixed in its interpretation and application. It deals with context, and this is social and economic context is always relevant. So notionally, yes.
Yes, I'm glad you're mentioning Grootboom. If you ran a case today against the city of Cape Town on the same facts, do you think you would give the same judgment, or would you now tell them it's actually time to put houses?
Well, I think that there's certainly been some jurisprudential development around those issues since Grootboom. And I think that, you know, it's difficult to say whether I would adopt a different approach. Quite possibly.
No, I mean, my problem, Judge, is this. If you told the city of Cape Town in 2000, which is when Grootboom was decided, that they need a plan that would withstand reasonableness. And then you came back to court in 2025 against the same city, and they still haven't delivered houses because Mrs. Grootboom died without a house.
Yes.
I mean, surely the Constitution doesn't mean you must now tell them, develop another plan, a second plan.
No, that I accept. Yeah.
Thank you, Chief Justice.
Commissioners Baloyi and Pillay.
Thank you,
Your
CJ.
follow-up questions?
Yes. Good afternoon, Judge Kusan. This is it's really a follow-up on the first point, and that's the transformation conversation. And I guess intervening at this point now, it's more hopefully to encourage, hoping that it encourages less reticence on the part of the judiciary, this intervention that I'm making now. And it's really this, that the idea, perhaps what we need to do is to reframe as the judiciary, to reframe the conversation about the lack of transformation and the change of briefing patterns, and see it as an issue about the future bench, because and less about changing briefing patterns for Commissioner Ngcukaitobi's economic equality concerns, but about the future of the bench, because you are going to retire, and I would like to know that the sitting judges today are concerned about who replaces them. And as matters stand now, with the briefing patterns as they are, you look at the bench in maybe even the Constitutional Court, the Competition Appeal Court. You look at those courts, it's pretty much predictable what it looks like 5 years hence, what it looks like 10 years hence. It will still be populated by the same demographic, because it is the demographic that keeps reproducing through experience in that court. So I make this intervention to urge that perhaps the judiciary needs to look at this question of transformation and changing briefing patterns differently from their perspective. What bench do you want to see 10 years hence? Thank you.
Yes, thank you, Commissioner Baloyi. I think you raise a very important point about how one begins to frame and reframe the discussion about transformation of both the profession and the judiciary. When you refer to, if you like, the future composition of the bench, I think what we need to grapple with is that there are systemic challenges that I think beset the judiciary still. Judges who are appointed to the Supreme Court of Appeal are judges who come from the High Court. It's not always the case, but judges who are appointed to the Constitutional Court, certainly over recent years, for the most part, have been judges who've come from the Supreme Court of Appeal. So if one is struggling with demographic transformation of the judiciary at those levels, that speaks to a systemic problem in the appointment of judges to those courts. So yes, I think the judiciary needs to be conceptualizing where it wants to be, what it wants to be in the future, and how it wants to get there. I think that's important. But equally, I think this commission it needs to be examining, perhaps reviewing and evaluating how it has succeeded, the extent to which it succeeded in providing for systemic transformation of the judiciary through the appointments that it has made. Of course, you can only appoint people who make themselves available and maybe are judged to have sufficient experience or exposure or the like. And that's where the responsibility then, primary responsibility would fall on the profession. I think increasingly the profession needs to be saying what type of judiciary do we want for a democratic South Africa, and how do we get there, and what do we need to do to get there.
Commissioner Pillay. Thank you, Chief Justice. Good afternoon, Judge Goosen.
Good afternoon.
In the latter part of your answer, Judge Goosen, you went exactly where I wanted to take you, which is to shift the focus from judiciary-driven transformation and take it back to the professions. You very usefully said earlier in your interview that we needed tools or methods of persuasion to try and get the firms to improve their briefing patterns. And I wanted just to understand your assessment of the situation. Why is it that you think the firms are resistant to briefing black and women advocates?
Look, that's very difficult to, it's really a broad speculation, but I think we can't deny the fact that deep, ingrained, socialized perceptions that come out of a gendered and patriarchal society permeate every level of the society. So, you know, whether that's the main driver, I can't say, but my guess is that that's what we're looking at. And how one changes those attitudes, how one deals with that. I mean, I think we know that that's it's a very substantial social transformation challenge that we face. But you know, I mean, there is an elephant in the room in those circumstances that needs to be addressed. How precisely one does that, that's difficult. I don't have a ready answer, but I think that's what we're looking at there. I mean, we come from a deeply gendered and patriarchal cultural milieu that persists.
And it's only once we grapple with the elephant in the room that we can arrive at the tools of persuasion.
Sorry, could you repeat that? I didn't.
No, I'm saying it's only once we grapple with what you described as the elephant in the room that we can then try and identify what are the available tools of persuasion.
Yes, I agree. Yeah.
Thank you, Judge Wilson.
Thank you.
Commissioner Matulodleku.
Thank you, Sajai. I just want to follow up on what Advocate Pillay is raising. You know, Judge Goosen, we have a legal sector code now, but we still have the very resistant when people don't want, they're actually challenging it. But sadly, we tend to look at government only, but the main culprit is being the private sector. And one of the issues that I always ask myself is that because this is where complex work comes from the private sector. And the same government is doing work with the private sector. Surely there must be a stick from government to say, if you are not going to transform, we won't be doing business with you. Don't you think it's a fair assessment?
Yes, the precise mechanism by which that occurs, of course, is may give rise to all sorts of probably quite difficult questions to address. But I certainly agree that this is not a problem confined to the public sector by no means. And getting buy-in and getting into the private sector and commitment from business and various other private sector entities is really where some focus would need to be applied. How one does that, of course, again, these are not they're not necessarily simple interventions that can be made. I firmly believe in the transformative power of law. Well, I wouldn't be sitting here if I didn't believe that. So legal frameworks, regulation, those sort of things are clearly those are mechanisms by which one can achieve a process of change. But the key, I think, is to work towards, if you like, compliance, self-driven commitment to that process of transformation, rather than solely relying on external regulated enforcement. I hope that answers your question in part. If not, please let me try again.
Thank you.
All right, we will close off on that note. Justice Hussein, thank you very much for making yourself available for this interview.
Thank you, Chief Justice. Thank you for the opportunity. It's a great privilege to be here. Thank you.
Best of luck. We adjourn for lunch. Can we make it 30 minutes? All right. There's a strong lobby for a 30-minute lunch. It's 15:04. We can come back at 25 to 4, colleagues. All right. Good afternoon, Dr. Malepe. I'm just checking if, are you ready?
Yes, I'm ready.
All right, thank you.
Good afternoon.
How are you?
I'm fine.
Good.
Yes.
I'm fine too, even if you don't ask. You have how many degrees? Quite a number of law degrees.
4.
Mm-hmm. What are they and where did you obtain them?
The first one is my BUris. The second one is my LLB. The third one is LLM. The fourth one is PhD.
Mm-hmm. And I see that your thesis for your PhD is a topic that interests me, but maybe we'll talk a little about that later. All right, let's do it this way. You are retired as of now.
Yes.
And let's take it backwards.
Yes, Chief Justice.
You retired from the Department of Justice.
Yes, Chief Justice.
You were employed in the Bridget Mabandla College.
Yes, Chief Justice.
What were you doing there?
I was the director in legal learning. I was responsible for training.
Mm-hmm. And you just retired this year?
Yeah,
in June?
June, yes.
Okay. And before that, what did you do?
I was the lecturer at the University of Venda.
Mm-hmm. For how long?
For 25 years.
Sorry?
For 25 years.
25 years. So your entire academic career was spent there?
Yes.
All right. What did you teach? Which subjects?
I was actually an expert in labor law, and I taught law of contract, I taught civil procedure, I taught criminal law, I taught interpretation of statute. Yeah, most of them across the LLB program.
Okay. And you did other work in between your stint at the University of Venda. For a period, you worked for the Electoral Commission. That was for the first elections.
Yes, but it was before I joined...
In democratic South Africa.
Yes, but it was before I joined University of Venda. I was still at a Center for Legal Studies at Wits. I was still an intern.
Oh, I see.
Yes.
Okay. You have registered that you are an admitted advocate of the High Court of South Africa since 1997.
Correct, Chief Justice.
Do you practice as an advocate? Have you practiced as an advocate?
I practiced as an advocate until actually 2012.
Starting when?
From 1997 up to 2012, when I was busy with my PhD studies.
Mm-hmm. Where did you run your practice from? Where was your practice based?
It was mostly based in the High Court of Twando, but I as well appeared in magistrate courts and other courts in Limpopo, in Phalaborwa, Zanedi. I appeared there.
All right. You have also sat as an assessor, and you've listed a couple of cases in which you, high-profile cases in which you sat as an assessor.
Yes, I sat as an assessor mostly in Twando between 1997 and 1999.
I was an assessor in Toronto High Court. And later in 2005, I assessed that case in Palamura Mera case.
All right. And you have listed 4 articles, 2 peer-reviewed and 2 from, I imagine, from papers you delivered at conferences. Are these the only articles you had published during your academic career?
Yes.
Okay. Right. All right. I'm going to stop here for now and give the other commissioners a chance to put questions to you. Professor Marumachai?
Thank you very much, CJ. Good afternoon, Memolepo.
Good afternoon.
I have 2 questions for you, but perhaps maybe let me start with what appears in page 23 of your documents. Page 23.
Of my documents?
Yes.
I don't know which one you're referring to.
Where you listed accredited journals that are under review, and you listed the SAJAL and JSR. Can you please tell me the full names of these journals? Are they accredited?
Oh, you mean on my CV?
Yes, on your
page
CV.
23 of my CV.
Page 23 on your
Okay.
CV. Paginated page 23, then on the actual document is typed page 7.
I'm a little bit confused, Prof, because according to the Bogo, on this document, my documents end with page 14.
Yes, the pack that I have, it has 48 pages. And the document that I'm looking at, it's paginated page 23. It's paginated with a marker at the bottom, unless I'm looking at the wrong document. I don't know.
Sorry? Oh, 7. Okay. Thank you.
Oh, I'm told then it will be page 7 of the questionnaire.
Questionnaire or CV?
I really don't know.
Question.
It should be the CV, I guess, with written employment history.
Page 7 of my CV. My questionnaire. This is not my questionnaire. No, this is not my CV. This is the documents from law bodies, yeah. Yes. What is my questionnaire?
Yeah, it should be typed page 7, but it's paginated page 23, nonetheless. Okay, let's try to save time. Let me just ask you, in terms of the information that is provided here, there are 2 articles that you are saying are under review.
Yes.
Yes. And what my question is, the journals that you are referring to, I could not locate them, so I just want the names of them. It's SAJAL. I'm just wondering what that particular journal, that acronym stands for. The second one is JSR.
Oh, I got it.
Oh, you have it, yes.
It's on page 23.
Yes.
Yes. Your first question goes to articles in accredited journals under review.
I beg your pardon?
Your first question
is
with regard to articles in accredited journals.
Yes, I'm just asking what is the name of those two journals?
Dr. Malepe, may I ask you to please speak into the mic? The acoustics are very bad in this room. We can't hear you.
The first one's SAJAL.
Yes, I'm asking what does that stand for? What is the actual journal? What does that acronym stand for? Because I could not locate the actual journal.
It's South African Journal on administrative and the South African Journal on I can't remember the name of this journal because it's long that I've submitted these articles.
Okay.
But you say it's an article. Sorry, it's a journal at UNISA.
Journal at
UNISA
UNISA.
journal.
Okay, and the second one?
The second one is a journal again on I can't remember the journal as well.
I also don't remember seeing these journals.
Yeah.
But obviously I don't know all the journals. Then I see that you presented papers in quite a number of conferences. If I may just ask, were any of these papers developed into actual articles that were submitted? And
yes, the one from Portugal, I wouldn't know the number. Let me go through it. The second one, law and language. Yeah, it's been, uplifted to a published article. It's a conference article.
Oh, it's conference proceedings, perhaps?
Good.
Oh, okay. Was it published?
Yeah, it's published.
Okay. My last question to you would be, what were the challenges, if any, while you were an academic, in publishing in accredited journals by the Department of Higher Education? Because there are different lists. For instance, there will be a list of journals by the department, and then you'll have sort of foreign lists like your IBSS, your Scopus, your Norwegian, and all those, which in the academic language we call them accredited. Was there any challenges for you as an academic to write and publish in those kinds of journals, like your South African Law Journal, your Journal on Human Rights, your Stellenbosch, those kinds of journals? Was there any challenge for you to publish there?
Thank you, Prof. It's true, there were a lot of challenges. Of course, sometimes you follow the publication requirements, you adopt them, but unfortunately, sometimes they don't even respond. They don't tell you where you have a problem. Unlike the one that we were talking about that is being managed by UNISA, the first one on exploring the interplay. No. The second one where I said submitted for peer review. There, the reviewers managed to come back to me, and I responded, and I'm still waiting for their response. And it's quite long. It's quite long.
Sorry.
So that is why I say it's not easy. You submit articles, you felt that you have done everything that they wanted, but they don't come back.
Sorry, CJ, just one follow-up question on this question. How will the experiences of you as a law teacher and as a law researcher who was able to go to various conferences and present the outcome of your research going to assist you should you be successful and be appointed in the Constitutional Court? How will that experience assist you to contribute meaningfully in that court?
Thank you. The content is quite vast because I touched on many aspects of law, and for that reason, assist me in terms of how I write, how I articulate problems, and then how I, finally give conclusions.
Thank you, CJ.
Lemon.
Good afternoon, Dr. Malepi.
Good afternoon.
I'm over here. How are you?
I'm well, and you?
I'm well, thank you. I think just as a preamble, I want to assure you that we are conversant with the provisions of Section 174, subsection 5, and so that's how I want to preface my question, because I want to ask you about your, I want you to assure us that you will be able to hand down, to pen and hand down judgments within acceptable time periods if you are appointed at the Constitutional Court. And the reason why I'm posing this question is because you have not acted, and mind you, I've already said we fully accept that that doesn't preclude anyone from being appointed as a judge of the Constitutional Court. But the reason why I'm asking this question, and this is a question that has been posed to all the candidates, not only in this interview, but in previous interviews as well, the assurance that they will be able to hand down judgments expeditiously. Now, considering that you have not at this stage penned any judgment, what should we use as a tool of assessing whether you'll be apt to this task? Because you will be, once you are appointed, if you are appointed, you will be expected to write judgments, and you'll be expected to hand them down expeditiously. So what should we use as a tool of assessing your work ethic in terms of, one, working under pressure, and secondly, not only working under pressure, but being productive under pressure in terms of delivering your judgments timelessly? So far you have been a lecturer for a long time, 25 years. So in your case, how should we measure or assess your track record in terms of your ability to be up to the task of being a judge of the Constitutional Court, especially considering the fact that since 2013, its jurisdiction has now increased. It's got general jurisdiction, and it's not confined only to the determination of constitutional matters. Thank you.
Thank you very much. To answer the first leg of your question, When I was still a lecturer at University of Venda, at the beginning, or somewhere during my employment, we were working under pressure. We were working under pressure because the number of lecturers in the Faculty of Law was quite, it was a shortage of lecturers, and we had to lecture as many courses as we could. And at that time, the number of students was increasing at the university. So the pressure that I was working under, it meant that I had to go to class, teach, give tests, and give assignments when I was teaching so many courses. At one stage, I think I was teaching 5 to 6 courses. And then during exam, it was quite, hectic and quite busy, to an extent that you are required to produce results at that time. The other instance is when I was still practicing as an advocate in the High Court. Remember, I practiced while I was still a lecturer at that time. For that reason, I would manage my, my practice as an advocate, as well as my lecturing duties, and then I managed to balance both of them. Let me assure you that I am quite efficient in what I am doing. So what I try to say here is that I want to see fruits with whatever I'm doing, and for that reason, I will manage my work in such a way that everything is up to date. When I joined Department of Justice at Bridget Mabandla Justice College, I was alone in that office without a secretary, without anyone. So, and I was managing about, 17 people under my supervision. And remember the overflow of the training needs from the department on its own, and as well as other stakeholders. We were not only training DOJ employees, we were as well training other departments' employees. So for that reason, I was compelled to make sure that every stakeholder receives the training as they are required. And at the same time, every lecturer is doing his job as expected. And again, I would require them to update their training material in order to align them with the needs of the stakeholders' training requirements. So at the same time, I'll be attending meetings as the director for the DOJ, and my work was up to scratch. The other thing that I almost forgot to mention is the fact that when I was still practicing as an advocate, I would prepare heads of arguments for the judges, and I would make sure that clients are well represented in terms of what I do in court or how I present their cases in court. So I am very efficient and I'm result-driven. But coming back to Bridget Mabandla Justice College, the other thing that I want to indicate that I achieved a lot since I joined the college. I managed to complete an installed learnership which had some public interest on interpretation in court. There was a learnership for learners who were DOJ interpreters. So that project, when I joined the college, it was installed. I made sure that that program is finalized under very, very compelling circumstances, because some of the files were lost, some of them were damaged. I had to work very hard so that I see to it that that program is a success. And indeed, students were exited and they graduated in 2024.
My second question, CJ. So you would have heard, if you were following previous interviews, that candidates are also asked about the number of judgments that they have penned. In your instance, you have not written any judgment, and that cannot be held against you because you are a lecturer. But the impression that we get, because I think you mentioned that you have 2 peer-reviewed articles. 2 peer-reviewed articles over a period of 25 years, would it be a fair comment to say that they are very few, and as such, it is difficult to assess your writing abilities, and one must not minimize your achievements. I mean, you have a PhD, but in terms of the number of articles that you have written, would you say that they are sufficient for one to, on the basis thereof, say that you will be able to write good judgments that you will be able to circulate to your colleagues timeously? And maybe on the last point, just to note that there's a concern also, you would have read it, that has been raised by the General Counsel of the Bar, in terms of which they state that your academic publications cannot be considered as having made substantial contributions to judicial precedent in South Africa. Your comment about that. Thank you.
Thank you. If I understood you, let me start with the last one. On the judicial capabilities, as to whether I'll be able to produce judgments that will be, in terms of the standards of the judiciary, I would say yes, I can do that. My 2 articles that I speak about, my conference publications, remember, conference publications go under a review before you present them in the conference. So the other issue is that, of course, you are right when you say only 2 published articles are not sufficient. But I think I've already explained sometimes before that it wasn't really easy to publish in accredited journals. It wasn't just easy. My LLM project, my PhD project, my supervision of LLM students on their dissertation, my supervision of our LLB research component. Like I mentioned before, I still feel that my practice, when I was still an advocate, for me to be able to make presentations before before the judges. I think I'm ready to produce judgments that will really define what judges are.
Thank you, Chief Justice.
Chief Justice, can I just follow up?
Sorry, where's that voice coming from?
It's here.
Oh, Commissioner Magere, sorry. You sounded disembodied.
I just need to follow up on the question relating to the publications. Advocate Choshi, it is one thing to have articles published by accredited journals, and it is another to write articles but have them rejected. As I understand the President's question, it's your output, your writing output, it's low as an academic. With 25 years in practice as an academic, how many articles did you write, let alone how many were published?
Okay, according to my recollection, I have a diary where I was noting all the articles that I sent for publications. I think there were about 9. Yes, and then most of them were not published, and I submitted them to accredited journals. The other thing is that, like I said, remember I was practicing as an advocate at one stage, and I was quite busy in court because I was trying to uplift my profession as a legal practitioner. So, on the other hand, remember I said it wasn't sometimes easy to publish where you are, you are teaching so many courses at a time. Remember, in our own disadvantaged universities, we give tests every time, we give examinations, throughout the year. At the same time, I was practicing and I was trying to publish as well.
Thank you, Sajai.
Is it a follow-up, Commissioner Motolo?
It's partly a follow-up, but I'll take it as a separate.
Okay, go ahead.
Okay, thank you, Sajai. Dr. Maip, I heard you saying that you are a practicing advocate. Are you a practicing advocate?
I was practicing.
So
I practiced from 1997 up to 2012.
So you are no longer practicing at all?
No, not now.
Okay, thanks.
All right. Commissioner Pillay? No, I thought.
Yes, thank you, Chief Justice. Dr. Malepe, can we just ascertain a few facts? The General Counsel of the Bar says that you stated in your CV that you were involved in the case of S versus Sithole. They looked at the case and they couldn't find it. And you've also not submitted it. What is the position?
I tried, thank you for the question. I tried to get the cases, more especially those that I submitted in my questionnaire, where the General Counsel of the Bar inquired about them. And S versus Sithole was throughout my diary for 2002, where I indicated that I was going to court on those days. Again,
So where's the judgment?
The problem was that I could not get the case number, and for you to get the judgment in court, you need to have the case number. With the names, they are not able to get the case.
No, but they say you've stated that it's reported, and then it's nowhere reported.
I did not say it's reported. I said it was reportable.
Reportable?
Mm.
Well, then it would be at least on SAFLI. Then another case they cite is Gudluza versus University of Venda, which they say you've also claimed that it was your case and they couldn't find it anywhere.
With Gudluza, as I was perusing my archives, I managed to get it. I think it was last week, because my archive is very huge. Yes. And I was looking for cases that I handled throughout my practice. And yes. Then I managed to get Gudluza.
Yes. In the letter you sent to the Secretariat of the JSC, this is what you stated. I think this was 2 days ago. Mode Gudluza, University of Venda. The university file was found, the court file was not found, no document that provides at least a case number. So was that correct?
Yeah, it was correct then. Remember I said my archive was very big. And then after I did my research, or after I tried to locate these cases, I kept on and on looking for those cases. Right now I have a copy of Gudluza in the High Court of Venda, Tuendo.
Yes, they also say you said it was reported.
Yes, that one was written reportable.
Yes, so it was also not on SAFLI.
Yes.
And the third one is a case called State versus Kavadi, which they also say they couldn't find.
Kavadi is a little bit strange because I appeared on behalf of those three accused throughout the case, like in Sitole, like in any other cases. I appeared throughout the cases. I never shared those cases with anyone. It was only me. And the Kabadi one, I took it on appeal. And then, if you would remember, when I responded, I said, I indeed prepared a petition to the High Court, to Supreme Court of Appeal, and then I was successful in getting the leave to appeal. Unfortunately, I could not continue with the case, though I wanted to continue pro bono because it was my case, but unfortunately, the Legal Aid Board said my mandate ended with High Court appearance. And if you can check again there, I even indicated from the judgment, remember they gave a paragraph from the appeal court judgment. And I said, if you look at this paragraph, where accused number 1 and accused number 3 were granted leave to appeal, it was through my leave to appeal that I've done. And then what I think what happened later is that the second accused was as well granted appeal to.
Yes. No, I think the point I was making is you said it was reported, and then they couldn't find it anywhere.
Okay. With the Kabadi one, I think my mistake there was just to generalize about the reportability of those cases. But with Kabadi, there was nothing that was written in the judgment to show that it's reportable.
Well, they say that in fact, they found Kavadi, and then they said it's actually marked not reportable. and it doesn't reflect your name at all.
The fact that it doesn't reflect my name, surely it can be my mistake because I appeared. Remember those criminal cases where you take, so many days in court appearing on behalf of these accused people. So I think I even responded to say I wouldn't know why my name does not appear in those cases.
Do you know why you marked it? You said in your CV it was reportable, but in the judgment it says not reportable.
In my CV, you mean in my questionnaire?
Yes.
Like I said from the beginning that where I made a mistake is that after I have listed all those cases, I generalized that this is reportable. Cavade was never a reportable case.
The second thing they raise is that in 2023, you've disclosed in your CV that you were accused of theft of church funds, but you did not, and then you also said that you were not found guilty, but you did not attach the finding of the Board of Inquiry that acquitted you.
I requested the church to provide me with a little bit of testimonial that shows that I was not found guilty in that case. Unfortunately, due to the nature of the organization, I only managed to get it this last weekend because the people who are responsible for the, those tribunals are not always at church. So they only come to church during our monthly ceremonies, like last weekend. Now I have that document, but I don't have the proceedings. And then
Sorry, just repeat that. Do you have it or don't you have it?
Yeah, I have it. I have the testimonial.
You have what?
From the church chairperson.
No. I'm not asking for the testimonial. I'm asking. The GCB is saying you did not attach the proceedings and the judgment that said you were not guilty. That's what they were complaining about.
But I think in their questions, I don't remember where they say I should attach proceedings. They said, actually they compared that with my debt review to say that it might affect my integrity or it might, lure me into receiving bribes. And I think I made my point in that one. I don't remember where they said I must produce the proceedings of those hearings. Had they done so, I think the church would have been willing to provide those proceedings.
All right, but your point is that you have the judgment with you.
I never said I have the judgment. I said I was not found guilty.
It was not found.
Are we speaking about the church issue?
Yes, I'm talking about the finding that you are not guilty. It would be written down in the form of an outcome of a disciplinary process.
Yes. Yes.
Do you have that? That's what I'm asking.
I don't have that. I have the testimonial where they said they want they actually.
Sorry, what is it that you have?
Is the testimonial from the church.
Testimonial?
Yes. Where they indicate, because I requested them that I applied for this position, and there is an inquiry about whether I was not found guilty or not. That was the point of contention. Then that is why I requested for this testimonial, and in this testimonial, it was written by the chairperson of that committee, and then I have it with me today.
All right.
Because I only managed to obtain it this weekend, last minute.
Yes, no, I understand. Do you not have the findings?
Let him run.
Or not?
In the testimonial, there is the finding. He mentioned the finding.
No, you see, the problem, this is what they say. It is unclear from this whether the Board of Inquiry positively found that the candidate was not guilty, or whether it took no decision on the matter on account of the candidate having vacated her position and possibly having left the church, The position is unclear and warrants probing as it may bear on the candidate's integrity in making a full and honest disclosure. So what they want is the ruling of the inquiry.
The ruling of the inquiry is there at the church, and even in this testimonial, CJ, the chairperson of that committee indicated that I was not found guilty. Well, it was on the 16th June 2023. And again, according to the questions that they imposed onto me, I said, I am still the church member. I never left the church after I relinquished my leadership positions after this case.
Yes.
That one I think I responded as well.
Thank you very much. Then the last issue they have raised is that you are currently under debt review under Section 86 of the National Credit Act. Is that correct?
Yes.
Now, they say that concerns them because if you are under debt review, you are either going to be lifted from debt review or you are going to be declared to be insolvent. If you are insolvent, you will not qualify to hold the position of a judge.
Yes, that situation has not yet arrived.
They also say...
I'm not insolvent.
Sorry, carry on. Yes, but the problem is that once you are under debt review, the debt review is instigated if you are over-indebted and unable to pay your creditors.
Yes, correct.
And there are only two options. It's either you are lifted from it or you are declared insolvent. And at the moment, you have not been lifted, you have not been declared insolvent, but the risk is there.
According to me, there is no risk because the indebtedness is going down. It's coming to an end as we speak right now.
Sorry,
Hear that? Just repeat yourself, ma'am.
I said, I don't think I will reach that stage because
You don't think you will reach that stage?
Yeah,
Because?
Because the indebtedness is coming down. Those loans that I had are now at a very, very low balances.
Yes. They also raise another problem that when you are under debt review, you are effectively at the mercy of the creditors. And it's bad for the judiciary to have judges that are at the mercy of creditors.
I believe a judge should be an independent person altogether.
Yes, that's exactly the point I'm making.
And a judge should consider and judge any case without any prejudice. So I don't see where the creditors will appear before me if I'm a judge, and perhaps I become, conflicted in such cases.
They say this problem of you being under Section 86 also reflects poorly on you because it shows your inability to handle your finances.
I think I responded to that one. I said the fact that I'm under debt review is because I was over indebted, and that does not necessarily mean that I am not able to handle my finances. I was the budget controller when I was the HOD at the University of Venda. I was the budget controller when I was the director. I controlled my own budget.
And yes, these are your personal finances, not the finances of a department.
Yes, I understand, yeah.
Yes, but what is your answer to the point made by the GCB that it's a poor reflection on a potential judge because it shows they cannot manage their finances?
Yes, in terms of the debt review, I cannot be discriminated based on my financial status, that yes. I cannot do 1, 2, 3 because of my financial status. That does not mean that I cannot do my work.
Yes. And then the final point under this topic of debt review is that you will be lifted, you may be lifted by a magistrate, which means that although you are at the Constitutional Court, you are subject to the control of a magistrate, which is also bad for the judiciary.
Can I get the question again, sorry?
So under Section 86 of the National Credit Act of 2006, the debt review will be ended by a decision of a magistrate, which means it's bad for the judiciary to have a judge of the Constitutional Court that is subject to control by magistrates who in hierarchy are below him or her. They say that's also bad for the judiciary.
Oh, that is a perception that, you say it's a perception that I can't do anything about it.
I'm sorry, it's a perception.
Just repeat the last answer.
I said it's a perception that I cannot really deny or
you cannot
accept.
deny?
Yeah.
Okay.
Thank you, Chief Justice.
All right. You have
sorry, deny or accept?
All right. Just to round off on these issues raised by Commissioner Ngugaitobi, in your questionnaire, you said you appeared in so many cases as an assessor and defense counsel. However, you could not remember the particulars of the cases because your archives were elsewhere where you were not. And then you undertook to avail these judgments to this body during this interview or before this interview. Have you done that? Have you provided us with copies of these judgments you claim to have been involved in?
Yes, I did.
Did you submit them to the Secretariat?
I sent them to the Secretariat.
Oh, they are not part of my bundle, at least. Including the ones about which you were asked, the Sitole, Kavadi, Gotlusa?
Yes, all of them, including the ones. Remember, in terms of the questionnaire, I had to submit at least 10 cases where I appeared. And then I submitted supplementary document to that effect. And I have it with me here as well. It's in my files. But I sent it to the Secretariat.
Well, they say they didn't receive it. When did you submit it?
I think it's the beginning of last week. If it's not Monday, it's Tuesday.
Would you be able to provide us with, I understand that would be burdening you, but would you be able to give us further copies, because the Secretariat says they didn't receive anything
Justice,
from you?
I have the copy here with me.
You have them with you?
Yeah.
Oh, good. All right.
Sorry, Chief Justice. On this point, we did discuss this at length with the Secretariat. I need to come to their assistance. The candidate did submit a document, but it said the court files could not be found in relation to any of the cases. S versus Sitole, the case number could not be found. Gudluza versus University of Venda, the file could not be found. S versus Kavadi, no documentation is found. The case numbers above was included to show the breadth of my experience in practice. Unfortunately, no document indicating any information was found. Should any other information regarding these cases provided, it will be presented at the interview. So when she communicated with the Secretariat, she said the documents couldn't be found. She will bring them at the interview.
All right. Well, and she says now that she actually has them with her. What exactly did you send to the Secretariat last week? Was it this explanation being read out by Advocate Ngugaitobi?
Yes.
That you could not find,
could
not trace them?
Yes.
Not the actual judgments?
Not the actual judgments.
What do you have with you now? Is it the actual judgments?
What I have now
is
the supplementary to my questionnaire. Remember, in my questionnaire, Chief Justice, I promised that I will try to locate these cases and then I will submit them at a later stage. Indeed, I did that. And then when I responded,
you did what?
Yeah, when I responded to the General Counsel of the Bar, I have not yet received some of them. And later, after I received, I tabulated them, and then I indicated that I did not get the case numbers. That is why I could not go to the High Court to look for them, because they want case numbers. In this document that I have, that I sent last week to the Secretariat, I indicated that.
Indicated what?
I indicated the fact that I found some of them, some of the cases. Remember, I was supposed to submit 10, and then I added on that list. And again, under my notes, I indicated that I cannot get the case of Kabati, I cannot get the case of Gutluza, I could not get the case of Tataisa and Sitole. And then after that, I sent a further document to the Secretariat on the supplementary information that I promised the Judicial Commission.
What is in that orange or red file you have in your hand now? That's what I want to find out.
It's my own file that I prepared for this.
Is it the judgments? Is it any judgment in which you have been involved during your career?
Yes,
what is it exactly?
Yes, like I said to him, I said, when I perused
what is in the file? I just want you to explain what those papers, that shape of papers is.
In this file are my documents for this interview.
Do they include a judgment?
They don't include a judgment.
Okay. Thank you. You also mentioned a health condition in your questionnaire from which you suffer. Is it under control?
Yes.
Okay, so it would not interfere with the execution of your duties as a judge?
No.
No?
No.
Okay.
No, Chief Justice.
Thank you. Any questions, colleagues? Okay, Commissioner Shivan?
Thank you, Chief Justice. Dr. Malepe, you're applying for the vacancy in the Constitutional Court. Have you followed Constitutional Court judgments, and are there any judgments? Have you followed the thinking in the judgments, and have you written any articles for or against any of the judgments that have been handed down? And have you followed the ethos of the Constitutional Court?
Yes.
Have you found any judgments that you found that you want to write about, or have you written any article that inspired you to say, this is I see linguistics is your forte, following from your PhD?
Yes.
So, did you find any judgment can you tell us any judgment that struck a chord with you, or you felt was in the right direction, or did you find any judgments that you had discord with? And you would have perhaps criticized the court on its decision? Thank you.
I'm only conversant with the judgments from the Constitutional Court, the issues involved, the criticism that I may level against those judgments. I never thought of them, or I didn't find anything that I could say, this is what I think should have been decided the other way around. I didn't come to that conclusion.
You haven't published any article on any of the judgments that you found either for or against, that you would found in favor or against? That's the second part of my question.
Except from my except from my PhD, where sometimes I have gone through certain, judgments. For example, but I don't remember any case in the Constitutional Court on the issue of language in court, because I concentrated on that one, but I know I managed to analyze most of the cases in terms of my PhD and in terms of my LLB dissertation. But from the cases that I've gone through, I didn't think about anything that I could say I'm against the judgment of the Constitutional Court.
Thank you, Chief Justice.
Thank you, Chair. Good afternoon, Dr. Malepe.
Good afternoon.
Yes. Dr. Malepe, it's really about the judgments, and to just try and make sure that you understand the significance of us having sight of your judgments when you apply, especially when you're applying to the appeal courts. Now, we don't have a single copy of your judgment to evaluate your writing, your reasoning, and your comprehension. You've just said that you are conversant with Constitutional Court judgments and issues involved, but you must accept that without evidence of it before us, we have no way of agreeing with you for purposes of recommending an appointment. You must be able to accept that. It's a proposition I'm making to you
yes,
that we won't be able to evaluate that.
I understand your point of contention,
Yes.
But like I said earlier, that I was a practicing advocate for a long time. I wrote, I prepared heads of argument in court.
Yes, please allow me to interrupt you without being rude. I don't mean to be rude. I'm just making the simple proposition to you that all of us around this room who are engaging with you, we do not have copies of your judgments, which are and judgments are an important tool. You must have watched other interviews. That judgments are an important part of our important tool of assessment. And the simple proposition I'm making to you is, without those, you do accept that we are not in a position to evaluate your writing of judgments, your reasoning in judgments, when you're dealing with difficult questions of fact and law, and what you say you're conversant with, because we have absolutely no way of evaluating that. It's that simple proposition, that's all I'm asking, that you must accept that as a fact.
That one is a fact, that you cannot assess me on the previous judgments that I would have had, because I don't have that one. I accept. And in terms of the requirements for the Constitutional Court Justice,
I am answered.
I applied on the basis that I am an academic with this experience that I have, and my writing skills were well exposed in my research projects that I had, and yes. I think that is my point of contention.
Thank you very much. Thank you, Sajai.
We've reached the end of your interview, Dr. Malepe. Thank you for making the time. You're excused. Good afternoon, Justice Savage.
Good afternoon, Chief Justice. How are you?
I must apologize that we kept you waiting for, what, 3 hours?
Not a problem at all.
Well, that's the nature of the game, but that still doesn't make it right. So do forgive us, please. I must first place on record that you were not particularly keen, and perhaps that's an understatement. You were not so keen on applying for this position, and were it not for the fact that you were asked by a number of colleagues, including this one, you would not be sitting there. And I just want to thank you for coming here today. Yeah.
Thank you, Chief Justice.
All right. You have how many degrees under your belt? 3?
I have 3 degrees, yes.
A BA, LLB, and LLM, summa cum laude.
That's correct.
LLM obtained from the University of Notre Dame in Indiana, US, of A, and the others from the University of Cape Town.
At the University of Cape Town, yes.
All right. Your legal career starts in 1992 when you did your articles at Channel's Albertine. Was that in Cape Town?
It's in Stellenbosch.
Stellenbosch,
yes.
All right.
I had chosen that firm because I wanted to do basically political work. That was the reason I'd done law.
And that is evidenced by what you did thereafter. You worked at the IEC, but then went to Parliament. What did you do in Parliament?
I was working for the ANC's Constitutional Commission in Parliament during the final negotiations towards the Constitution. So I reported to President Ramaphosa. I was the person who kept the list of all of the issues that needed to be negotiated with the National Party and with the Democratic Party. And I attended all of the bilateral and trilateral negotiations held offline between the political parties with the list of issues that needed to be resolved. And as they got reduced, the issues became narrower and narrower. We came to the end of the process, and we were left then, as everyone knows, with 3 issues, and that was the 3 issues in the Bill of Rights, which we spent some time negotiating. And then almost at the end of the whole process, President Ramaphosa said to me, "But where's the preamble?" And I said, "I don't know." And so what I did was I went and looked at all of the proposals of all of the parties, made a document, drew up what the different parties' proposals were, and then met with Joel Netshitenze in the presidency. And he and I then worked on the preamble, and I basically came up with the idea that we would use verbs to say where we were coming from, and then verbs in the preamble to determine where we were going to, so that we would, as the people, recognize the injustices of our past, honor, respect, believe, and then move towards healing and establishing, laying the foundation for a democratic and open society, and then improving the quality of life of all citizens. That then was, and building a united and democratic South Africa. That was then what we came up with, and it was left pretty intact. Joel Netshitenze is a very gifted writer, and it was a very easy process. I'd done a draft. He and I sat on a couch in the presidency, and we really worked on it together. And then the only issue that stood out afterwards, to the extent that the commissioners are interested, is that there was a very strong belief that we should make reference to God in the preamble. And so what I suggested to the National Party person I was liaising with was that we use the national anthem and make reference to that at the end of the preamble. And that's how we came to the preamble. So that's just one of the clauses I was involved in.
I didn't know this. You don't talk about it at all.
No, I don't.
So, in a word, you are one of the midwives of the Constitution.
Yes, in many ways, yes.
Yeah.
But there are a lot of those, a lot of midwives.
Of course. Yeah, that's pretty impressive. Okay. So, after that monumental work, you joined the LRC, the Constitutional Litigation Unit.
Yes, I was then involved in the certification of the Constitution. So at the LRC's Constitutional Litigation Unit, I was an attorney, and at that stage I was involved in that phase of the certification proceedings and then in other of the early litigation in the Constitutional Court.
All right. That was until
that was
1997.
Yeah, I had broken my master's degree, much to the dissatisfaction of my father, who was an academic and thought such things were utterly unacceptable. And I'd come back to work for the ANC in Parliament. And then I had, after that, decided I needed to finish my degree. So I left the LRC to finish my degree and came back for a short while.
All right. But then you left all that exciting stuff and went to the CCMA. I'm not saying it's not exciting work.
I started arbitrating, actually, and while I was at the LRC, I started arbitrating, and in a way I had a bug, I was bitten by that bug, and I quite enjoyed adjudication. And then I was phoned one day and asked by somebody looking to employ people at the CCMA whether I wouldn't be interested, and I said no, I didn't think so, but they said come along for an interview, and it sounded like I'd do a lot more arbitration, and I was quite keen at that stage in getting into arbitration, which I hadn't previously. It gave me an opportunity to get into essentially decision making, and I was quite keen on that as an area of law. I'd also wanted, by the way, to be a soccer referee, but I was told that women couldn't be soccer referees because during my time at university I was involved in non-racial sport through Satisco and so on. Yeah.
All right. Well, you lived before your time, ma'am. Okay. Then you started your own law firm in your own account.
That's correct.
For 5 years?
That's correct.
What happened in 2005?
In 2005...
You became partner at a certain law firm?
I think at that stage I went to Bowman's, did I? Yes, I went to Bowman's.
No. Before Bowman's.
I then joined... I'm forgetting my own CV.
You became a partner at a certain law firm, and I'm trying to figure out if it was that with your husband?
That was with my husband, yes. So that was with my husband, and then then I left that and went to my
to Bowman's.
To Bowman's, and I was then in their public law and employment law area.
And you were director there for a few years.
Yes, I was.
Then you appeared to have returned to your law firm with your husband for a brief spell, but you became appointed as a judge.
Yes, I then was acting. I acted in the Labour Court in Joburg in 2011, and then in 2012, and from 2012, I have pretty much consistently been in the High Court. So I was acting as a judge in the High Court, and then applied in 2013, and my colleague and friend, Judge Bokwana, was appointed, and then I was asked if I didn't want to be in the Labour Court, and decided not. I'd prefer to stick around and apply for the High Court if there was a position available thereafter. And in 2014, I came before the JSC again, and was at that stage then I applied for the High Court, and I was appointed following that interview in 2014.
And then you made your way up to the Labour Appeal Court, in the Labour Courts.
Yes, I acted
by 2023.
Yes, I'd acted for 23 terms in the Labour Appeal Court from 2015 until my interview in 2023. Yeah. And then I was appointed to the Labour Appeal Court with effect from 2024. Perhaps I've got the date. I might have the dates wrong.
Yeah, in 2024, you acted there.
Yeah.
So I've been until very recently, until your stint at the Constitutional Court started, not so?
That's correct.
Just now?
That is correct. I started at the Constitutional Court from the 1st of June.
Yes. All right. So, but before that, you had a longish stint at the Competition Appeal Court.
I was acting. I didn't do very many cases, and I haven't written a judgment. And I then also acted in the Supreme Court of Appeal in 2022.
All right. You were at the Competition Appeal Court for 3 terms. How did it come about that you couldn't get a single judgment to write?
I don't know.
It didn't
I think it
happen.
might have also been that I was busy with the LAC and had obligations in the Western Cape, and so it's, as an appeal court, you kind of fit that work in, so it could have been something to do with that.
Then in 2024, last year, you acted as the Deputy Judge President at the LCs, the Labour Courts.
Yeah, I was the Labour Courts. I was the Deputy Judge President for the whole of last year. I acted in that position, and then I acted as Judge President for the first term of this year.
And then we asked to bring you over before the court was ready to release you.
Yes, that's right.
Right.
Then I started at the Constitutional Court here.
How have you been finding your time at the Constitutional Court?
It's been very stimulating. I've enjoyed it a lot. It's a lot of work, but it's really very interesting work, and it's right up my street.
Yeah, that's what I thought. You seem to be reveling in the whole thing that drags some of us down. All right. You have written many judgments in your lifespan as a judge. Has it been 13 years?
Yeah, that's correct. From 2012, I've been writing judgments. Yeah.
How many would you say you have in your pocket?
I think there's something like 220 on SAFLI, or 215 on SAFLI, and then there are, of course, all the criminal appeals and reviews and criminal trials that are not obviously on SAFLI either.
That are not reported on. Well, in addition to all this work and the administrative experience you have from having acted in the leadership positions of the judiciary, there are other administrative leadership positions and administrative positions that you've held in other extrajudicial bodies. You were a trustee of the Constitutional Court Trust for a long time.
Yes, I was. That's correct.
And a member of the Hemophilia Foundation of South Africa since 2001.
Excuse me, I missed that.
Sorry?
I missed the question. Please, I couldn't hear it. Sorry.
It says here, member Hemophilia Foundation of South Africa.
Yes. I have 2 children who have hemophilia, which is a bleeding disorder.
All right.
Yes.
And more related to our work, you have long involvement with SAFLI, the Southern African Legal Information Institute. What exactly have you been doing there?
Yeah, I think with Judge Cato Regan, the two of us have really been the driving force behind SAFLI. I mean, we took it over from Wits, and it's very little. It was an infant organization of with a few judgments, and we had it based at the Constitutional Court in the library with the help of Cheryl Latuli, and it was a project of the Constitutional Court Trust, and we built it up into what it is today over a period of 20 years, getting the IT tech support that we needed, getting the staff employed that we needed, building the relationships with the courts around the country, and really trying to ensure that everybody, all of us, as South Africans, as non-South Africans, as students, as members of the public, have access to judgments, access to law, access, increasingly, we hope, to legislation, and we'd like to see more journals. At the moment, I'm the board chair of SAFLI.
Yeah.
And then I've also been on the United Nations Appeals Tribunal. I was appointed in 2022 I was elected by the General Assembly. I was asked to apply, wrote an exam, and then was elected by the General Assembly onto the United Nations Appeals Tribunal.
So what kind of work goes on there?
It's essentially an employment tribunal within the UN system, so it's their labour appeal court, and they were looking for women. They're short of women around the world in this kind of capacity with those kinds of skills, and there is no other woman from Africa on the court, and there has not been previously on the court, and there are 7 judges from around the world who serve on the court on an ad hoc basis.
All right. You also have quite a few publications to your name?
Not as many as I would have hoped, but I have had 3 kids and tried to be an active parent.
Yeah, I'm just trying to figure out in my head how you managed to do all this, write the number of judgments you've written and do everything else and still produce articles in accredited publications.
I think some of those were really before I actually had 3 kids. They might have been when I had 1 child.
Yeah. All right. I think I'll stop there, Justice Savage, and let my colleagues put questions to you, starting with President Molemela.
Good afternoon, Justice Savage.
Good afternoon, President.
How are you?
Very well, and yourself?
I'm well, thank you very much. My first question pertains to the provisions of Section 174(2), which states the need for the judiciary to reflect broadly the racial and gender composition of South Africa. And my question to you, no right or wrong answer, but I want you to motivate your answer either way, whether you think it is essential for the Constitutional Court in particular, as the apex court, to have gender parity on its bench.
Without a doubt. I think that women bring a completely new and different perspective to the area, to the judiciary, and to the task of judging. I think it's very important for teams of judges, as they sit in benches in appeal courts, to be diverse, that there are different perspectives that are brought to bear when diverse people sit together. And I think it would be an amazing feat if this court were to be the first national apex court that, like the SCA, reflected a very strong gender representativity. The Constitutional Court were to become the first national apex court in the world to have a majority of women.
And my second question pertains to 167(3), I think it's 2B2 of the Constitution, which gave the Constitutional Court general jurisdiction. Do you want to tell us a bit about the provisions, about the general jurisdiction of the Constitutional Court, and in particular, under what circumstances would it not be in the interests of justice for that court to entertain a matter that raises an arguable point of law that is of general public importance?
The difficulty that I have with this section, and it's a difficulty that I've experienced while being at the court, is that an arguable point of law of general public importance can almost be everything and anything. There is really only the mundane areas that don't fall within that category. And so it does seem to be posing, in my limited experience of the course, some difficulty as to what cases should, in fact, what leaves to appeal should be granted and which should not be. I also think that it's posing some difficulties in relation to the role of the specialist tribunals. So, President Molemela, you were, I think, the 3rd woman, or perhaps even the 2nd woman appointed to the Labour Appeal Court. And you will know that acutely that what the role of the Labour Appeal Court is. And increasingly we're seeing a leave to appeal granted to the Constitutional Court on issues that arise out of the areas of these these courts of specialist jurisdiction, that is causing some consternation certainly in the labour fraternity as to what matters are coming before the court and why. That there needs to be some greater thought given to what is a matter that falls within this definition of 167(3)(b), because otherwise it's really just up to a sort of luck of the draw situation that somebody once applied didn't get leave, and then a year later somebody else applies and on precisely the same issue gets leave. And I think those are some of the difficulties that are arising. I've certainly found it quite difficult to ascertain on what principled basis the court is proceeding to grant leave to appeal in this area, and I think it's an area that needs further clarification. I also think, finally, just that the role of the SCA, like and of course quite different to the specialist tribunals, to specialist courts, I mean, is that the role of the SCA is an important one, and that it has over the years developed the law it's got a far greater number of judges in important areas, a wide spectrum of the law, and that we shouldn't very quickly be intervening where we don't need to as the Constitutional Court in issues that can be left at the level of the SCA or the LAC or the CAC.
Thank you, Justice Savage. Thank you, CJ.
Thank you very much, CJ. Good afternoon, Judge Savage.
Good afternoon, Professor.
I came across one of your judgments that I think stood the test of time. It was a minority judgment.
It was, excuse me, I couldn't hear?
It was a minority judgment.
Oh, yes.
It is the judgment of National Union of Metal Workers of South Africa versus Dunlop. It subsequently found itself in the Constitutional Court.
That's correct.
In that judgment, that judgment rather dealt with the concept of derivative misconduct. And you deviated from what the majority judgment at the time tried to encapsulate what this particular phrase should be understood as in the context of collective wrongdoing, in the context of a strike. I just want to find out as to what is your sense of the development of this derivative misconduct in South Africa, and whether the manner in which the Constitutional Court, to the extent to which you might remember, has done justice to where perhaps your minority judgment wanted to take the concept.
I mean, I would think it has, because I think increasingly we're not seeing derivative misconduct cases easily coming through. That what we're seeing really is cases where there's direct evidence of misconduct, but that this notion that you must have some obligation to rat on your fellow employees and tell on them to your employer is in our country, I think, a complicated notion and doesn't take, as I tried to canvass in my minority judgment, doesn't take account of the situations under which people live. It doesn't take the workplace and the complex dynamics of our workplaces into account, and it doesn't deal with issues of danger for particularly female employees, which in this case was exactly the point that you were asking female employees living in a violent situation, in a very dysfunctional and violent strike, to come up and, as my colleagues would have had it, and I'm friends with all my colleagues, so they won't take offense to me referring to this, but rat on other employees, because I simply couldn't agree with that. I mean, I've tended to take the view that where I have a principled difference, I will dissent. And I've done that meaningfully, I think, in that case, and I think it has put paid to this unruly horse of derivative misconduct, I hope.
No, it was a powerful dissent. And one perhaps hope that when you're going to, should you be successful, you'll continue to dissent where there is a need, because it appears to me that most of the judgments that are coming out of late in the Constitutional Court, they are more on a consensus base, and for me it's quite worrying. But nonetheless, I want to ask you about something. I'm not sure if you were sitting on the panel that dealt with the competition law case.
Yes, at the Constitutional.
Yes.
I was.
Before that case was heard, there is a pension law death benefit case that was delivered by the Constitutional Court. Mutsila.
Yes.
And what appeared in Mutsila, you found that the Constitutional Court was able to overturn Guneri that was delivered by the Supreme Court of Appeal on how death benefits should actually be dealt with, because Guneri was saying you need to determine at the time when the member actually, when the fund is actually making the distribution of death benefit. And now the new position is that you need to do that at the time when the member actually dies. But what came out was, under what circumstances would the Constitutional Court or any other court overturn a decision of a lower court even though that particular decision is not necessarily before the court. In other words, you don't have an appeal from that particular case. You are dealing with a completely different case. But it so happens that the principle that was enunciated in that particular case is found to be absolutely wrong. And now the court is faced with a position whereby it needs to charter a different view. What motivates that? What are the parameters of actually overturning a judgment that you are not actually dealing with?
Well, I mean, I wasn't in the panel in Mozilla, and I haven't looked at it that carefully, but I would have some reservations. And my reservations, just hearing you, Prof, is that we bind the parties to their pleadings. We say that you can't come along to court and present a case completely different to the case that you pleaded, even if you suddenly wake up at the 11th hour and realize that you've got a great point that you should bring. And I'm not necessarily sure that courts shouldn't be bound by that same rule. Is that we should decide what's before us, unless we're going to take quite a different approach to judging and the process of judging and call for submissions on cases that we decide are important to hear. So I haven't looked at it. It's subject to the qualification of Mozilla. I haven't looked at it I did look at it during the course of the hearing very briefly because a reference was made to it on SAFLI, but then I haven't actually engaged with it carefully. But I would think it's an area that I'd have some caution, certainly from my perspective, as to how we should deal with these issues. I'm, by the way, not necessarily averse to the court expanding how cases come to it, because I think sometimes we're very hamstrung by the fact that we are only hearing those cases that are brought to us. And if you look at other jurisdictions, and I might be considered to be being way out in saying, like the epistolary jurisdiction in the Indian Supreme Court, where the court can say on pavement dwellers or something else, that this is the type of issue we should be deciding, and then call for submissions on that issue. But that might take certainly might be some years, and it might take some further developments in our law to allow that.
Yeah, thank you very much for that answer. Thank you very much, CJ.
Right. Commissioner Dodson.
Thank you, Chief Justice, and good afternoon, Judge Savage.
Good afternoon.
I just wanted to follow up on the comment that the Chief Justice made at the start of your interview. If I understand correctly, I believe you were reluctant or not so keen to apply. Perhaps just advise the Commission why this is and what persuaded you to apply.
I had not completed a term acting, as I said to the Chief Justice. I had not as yet completed a term acting in the Constitutional Court, although I had extensive years of experience from 2015 in appeal courts. I had not written a judgment as yet in the Constitutional Court, and I had alerted the Chief Justice to this and said that I thought perhaps that I should not apply for those reasons, and the Chief Justice indicated to me that she thought that neither of those should prevent me from applying. I then said to the Chief Justice that my position unfortunately remained no, and that I would discuss it with my family. And I did discuss it with my family, and they were more enthusiastic for me applying than I was. And this is a nerve-wracking process to come to this commission. And this is my 4th time here, and I'm the mother of 3 kids. I'm a wife. I'm a sister. I'm a daughter. I don't really want to come here and then be criticized deeply for pushing myself ahead in circumstances where it was premature. And I think that was my reluctance. Of course, when the parties who did talk me around to it told me to do this, they indicated, well, I could serve 12 years, that I'm exactly the age to serve 12 years, that I have the experience, that I was an activist in my past life, that I did law for the reasons that I did it, and this is the court I should be in. And I then said, well, I haven't got a nominee. And then other people got a number of nominees for me.
Follow up? All right, you then, Commissioner Steinberg.
Good afternoon, Judge Savage.
Good afternoon, Commissioner.
I'm over here. You've given your reason why you were reluctant to put yourself up at this point. You've had time to reflect on it, and in particular, your reason that you had given yourself, that you thought it's premature at this point. You've now had time to reflect, and what is your view about your readiness and ability to, if you were appointed, to assume that position and to function optimally from the outset?
I have had time to reconsider my position. I've also had further time in the Constitutional Court. I've also been involved in a judgment that I'm writing, and in fact I have written my draft of the judgment, although I'm waiting for my colleagues to comment on my post-hearing note. I feel far more ready than I did at the point that the nomination went in, and in fact that was something the Chief Justice had said to me, that it would be easier, because by the time I was here in October, she was asking me in August, and so it would be a bit easier, and it's much easier. I think as far as my readiness in other ways, I am very deeply committed, and it is the reason that I studied law, to the transformation of this incredible country of ours, which has so very many problems. I think that we can use law constructively to achieve social justice and the kind of change that we want to see, all of us, as South Africans. We have a very young population. 60% of people under 30 are unemployed in this country. 95% of people who grow up in poverty don't break out of it in this country. Those are the stats that we're dealing with. We have 10% of people who still suffer from food insecurity. We've got very, very many and fundamental problems. And I see, having been involved in the drafting of the Constitution, I see incredible opportunity in the Constitutional Court to work on each of these and other issues. And I do see a role for myself in doing so if I'm wanted. If I'm not wanted, I'm equally happy to remain in the area of labor and in other courts to do what I can there in those courts in furthering what I believe are the needs of our society and assisting the judiciary in doing that.
Well, I do know that President Bulemela is waiting to pounce on you. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Judge Savage.
Good afternoon, Commissioner.
Before we read too much, Judge Savage, into what you've just said, which is that you didn't consider yourself worthy of the position, isn't that classic imposter syndrome that you've described?
Absolutely. And if I may, I'll use this as an opportunity, because I know you've been canvassing the sexual harassment policy, and I think that I've been in the judiciary from 2012. I was very early on asking why we didn't have a sexual harassment policy in the judiciary, and it took our Chief Justice now to, within minutes of being in her role, to ensure that we have a sexual harassment policy in place. Equally, and that is such an important step forward in terms of setting the tone of zero tolerance to conduct that takes any form of a harassment in the workplace. But equally, I would like to say that many of us as women, and particularly some of the trailblazers, have faced an enormous amount of bullying in the judiciary. And I would like to see increasingly that a policy be developed which deals with harassment more holistically than sexual harassment. That's not to say that we shouldn't start with sexual harassment. In the labor sphere, we started with a code on sexual harassment. And recently, that was in 2005, in 2022, following South Africa's ratification of the ILO's Convention on Violence and Harassment, we then amended our code, and we put in place a code that is we as in the country. The code was amended to include harassment and all sorts of other workplace misconducts relating to harassment, but also including bullying. And I would just like to speak briefly to what the difficulty of breaking through glass ceilings sometimes is. When you break through a glass ceiling, you are accused of putting yourself ahead of yourself. So you're often treated very poorly in doing that. When I went to the SCA, I was treated very poorly by certain colleagues for doing that, for apparently jumping ahead of myself, although I had nothing to do with putting myself at the SCA. And those are very damaging experiences for people, because you do not want to be accused of such behavior when all you are doing is doing your job to the best of your ability. And of course, it's easy for people who don't experience that level of bullying in the workplace or generally in our society to say, oh, but come on, you're overreacting. Of course, you might think one's overreacting. It's a bit like white people saying that black people must get ahead in this country, get out of poverty. Well, it's a little bit more difficult. And if you have actually lived through it, you might have some personal experience that would allow you to then consider where one stands in it. So as far as putting myself further forward, I have been very concerned about the haters. And I have to say that I listened to the Taylor Swift song of, I'm not in the Swifties, because I'm probably 25 years older than a Swiftie, but I listened to that song about the haters are going to hate, hate, hate. And I think women need to do that. I think sometimes women need to push themselves forward, but they also need to be supported in doing so. I thank very much my colleagues in the judiciary who, certainly on this decision, and I include the Chief Justice in that, who have unequivocally expressed support for me and pushed me forward to do so, despite my own hesitations, which I've described.
You mentioned the sexual harassment policy, and having worked through the policy, do you see any pros and cons to the creation of the gender desk in the office of the CJ?
I think that any advance is a good one. And so if the gender desk is going to help us, that's a good thing to do. I also think compulsory training and not voluntary training is a very important thing, and that's also included in the policy. So yes, I think the policy as it stands, yes, is a very good step forward. And we need to set a zero tolerance tone. When I wrote the judgment in Simmers in the Labour Appeal Court, I was criticized by academics for setting the bar too low, but on sexual harassment. And my response when I read those articles was, it can't be set too low. It's an abuse of power in the workplace, and so is bullying. And just to move back into the bullying issue, in the judiciary, of course, one of the difficulties is we're A, not employees, B, we're appointed for life, C, it's a flat organizational structure until you are promoted to the next position. So whether you came in on day one or you're there in day one of year one or you're there on day one of your 20th year, you are earning the same salary in the same court. And that does have some difficulties and does pose issues. And I think raises important questions around the circumstances under which people dissent, when they're brave enough to dissent, and particularly for people who feel that they may be not supported in the environment, or B, that they will be criticized or that they won't be advantaged in any way further in the environment. So if there's an external structure such as a gender desk, that might be a useful way forward.
And finally, while the sexual harassment policy is very strong, comes down very strongly in favor of victims of harassment, it does also seek to balance that by focusing on the rights of people accused of harassment. Now, in an instant where we opt for an adversarial system to investigate complaints, do you think there's more that we can do to protect the rights of victims?
Well, I think it's important to protect the rights of everybody. I mean, we must make sure that if there are false complaints, that they are properly investigated and that they're properly... The difficulties often in these issues is it's a one-on-one, so that one is dealing with one person's version versus another. But so I think the first step is, yes, we need to protect the rights of victims. We must also protect the rights of those who may also be wrongly or falsely accused. At the same time, I think that part of a gender desk's role could be, in fact, to provide that sort of support, the kinds of support that perhaps I've received in proceeding with this application. and that the kinds of support that are needed so that people stand up and say, I have been the victim of sexual harassment. And I think that could be usefully done through that sort of a structure.
Thank you, Judge Sarich. Thank you, Chief Justice.
Thank you, Commissioner Pillay. Is it follow-up? Okay. Commissioner Trollip, he raised his hand a long time ago. We've just been dealing with follow-ups.
Thank you very much, Chief Justice. Good afternoon, Judge
Good
Savage.
afternoon, Commissioner.
I noted the comments of the Chief Justice about your reticence to apply, and I'm sure you read the documentation related to your application.
I did.
Including the Law Society of South Africa's comments.
Yes.
And their perplexing recommendation that they are unable to recommend you. I just want to make a few comments before you respond. They go on to say that you had a record number of nominations, and I'm paraphrasing, and this doesn't reflect fairly on the nominee who seemingly might be a person who's supportive of social cohesion, and I think your role in the drafting of the Constitution and the preamble confirms this. Yet they say that those who rush to nominate their own judge seem to have an advantage over advocates who might appear, black advocates who might appear before you. Then the LSA goes on to say that you were previously nominated by a black female deputy judge president in one of your previous appearances. And they go on to say you are acting in the Constitutional Court, you're a judge in the Western Cape High Court, acting judge president of the Labour Appeal Court, and you have no reserved judgments and no part heard matters. Now, all of that would normally go with a ringing endorsement. I am concerned, and taking into account what you said about glass ceilings, about what your sentiments might be to that report.
I have to say, thank you for raising it, because I was absolutely amazed when I read it. I was also amazed to see the exclamation marks and etc. I didn't ask one person to nominate me. Those nominations were people who decided of their own accord to nominate me. They are women senior counsel in the Western Cape. The Western Cape has been notorious in its difficulties to transform that bar. And many of those women, and a number of them are black South Africans, they have strived endlessly to ensure with their colleagues, who are also on the list of nominees, to ensure that steps are taken to achieve the kind of transformation that is needed in that bar. When I started in 2012, I was the 13th woman ever to be appointed to the Western Cape High Court. I could count on my one hand the number of female senior counsel that there were at the bar. I could equally count at the bar in Cape Town. I could equally count on one hand the number of black senior counsel that there were. So there was a significant and serious problem in that bar. And over the last period of time, 13, 14 years, since that time, we have seen enormous strides taken. And I think that the nomination, in fact, reflects their view that I stand in support of their efforts to transform. Of course, that bar needs to transform further, but we need to credit transformation where it occurs and where steps have been taken to ensure, for instance, that women are able to access the advocate's profession equally, and so on. And that I think that I would describe, if I was saying to my children, that is tone deaf.
Thank you, Chief Justice. I just want to place it on the record that I found that LSA report perplexing and completely incongruous with the CV and the nominations and your own commentary. And I want to place it on the record.
We have it, Commissioner Trollip. Then it's Professor Marumachai. He raised his hand before you, Commissioner Mangena, as did Commissioner Moimang. We'll get to you.
I've already asked my questions, CJ.
You have?
Yes.
All right. Then it's Commissioner Moimang before you.
Thank you, CJ. Good afternoon, Judge Savage.
Good afternoon, Commissioner.
Just one from myself in relation to the judgment that you raised as part of your contribution to jurisprudence, the one that deals with the Minister of Public Service and how.
Yes, thank you.
Yes. I'm more interested in getting the significance. What is the significance
that was a
of this judgment, given the fact that the last 5 years has been described more or less as the hallmark of tension between public sector unions and the Department of Public Service Administration in relation to public service wage negotiations and settlement agreements and payment of agreed upon increases. Thank you.
Yes, thank you, Commissioner. I put that judgment forward for a few reasons. The one was, as one will remember, that was a dysfunctional strike which included essential services workers and led to the deaths of a number of people seeking medical treatment in hospitals and clinics around the country. And I felt it important because it had dealt with issues relating to that strike and the sorts of the approach of the Labour Appeal Court to the strike notice was interesting, and also to the treatment of court orders as far as the police was concerned, because there seems to be an increasing view from that time and even prior to that time that the police don't seem to think that court orders mean anything other than a voluntary exercise in enforcement. And I made quite a clear comment in that judgment around court orders, it being non-negotiable that court orders are to be enforced. That judgment was heard on a Friday, and as you'll see on the Monday morning, we handed down judgment at 9 o'clock in the morning, and Nahawu was ordered to advise its members by 1 o'clock that day of the outcome of the decision. So I drafted that judgment over the weekend, and I just thought that it would also, for that reason, be an indication of my judgment writing, my approach to judgment writing.
Now, what about the non-compliance on the part of the Minister of Public Service Administration to adhere to the agreed public service wage agreement?
Well, we did make comments around that, and I mean, I did. And I wrote the judgment. In fact, I said to my colleagues, would they mind the judgment being in the name of the court, because it would be better that it came out, it'd have a stronger message if it came out in the name of the court as opposed to just in my name. And we made comments about that. I made comments around the role of the employer in negotiations as well, and particularly a state employer with so many employees. It's really very important that the state adheres to its obligations as employer, and that it ensures that it conducts itself in those negotiations in the manner that it's supposed to, and not to just bail on agreements which then create difficulties down the line.
Thank you,
and actually create the deaths of people down the line. You know, if we hadn't had that situation emerge, we might not be in that in the same boat.
Thank you, Justice. Thank you, Sajai.
Commissioner Mungeni.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Mangena. Yes. I sat next to you the last time I was at the JSC, sharing some jokes with you, but now I'm on the other side, so you can really go for me now.
Now, yeah. With what you have said earlier on in your interaction with the Chief Justice regarding the role that you played in the run-up to the finalization of the Constitution, there is a quotation that is attributable to Ernesto Che Guevara. It says that if you tremble with indignation at every injustice, then you are a comrade of mine. Do you know that? Have you heard of that?
Yeah, I've heard that quote.
Yes. Because with what you have done, you have really proved that you cannot tolerate injustice at all. And there is a judgment that you wrote, Ekruleni local municipality versus Salga. It's a judgment that dealt with sexual harassment, and I see you did not list it as one of the important judgments here. Do you recall that judgment?
Vaguely. I'm afraid you might have to remind me.
Yes, it appears you were ahead of your times in view of the sexual harassment policy that was passed, that was adopted by the Office of the Chief Justice. In that judgment, an employee of the municipality had made remarks to a member of the public, saying to her, "You look like you'll be good in bed." And that member of the public, who was not an employee of the municipality, reported a sexual harassment complaint at the municipality and wanted the municipality to enforce its sexual harassment policy and deal with that employee. You still don't recall that case?
I don't, I'm afraid. And perhaps it's a symptom of how many cases I've dealt with.
Then the matter came to you together with your two other judges at the Labour Appeal Court. And you said that an official of a municipality in the exercise of public power needs to respect members of the public, and in execution of their power, they've got to always be mindful of the policies that are applicable to them. It did not matter that that woman who was there to obtain a driver's license was a member of the public and not an employee of the municipality. You should have a look at that judgment.
I stand firmly by that sentiment.
Yes,
and if it's mine, then that's good.
Yes, and it was written after the CIMA's judgment. So you were actually following up on the CIMA's judgment. And I thought that that was an important judgment, very significant, and it registered with me as one important judgment that should not be downplayed. And in view of the sexual harassment policy that has been adopted, you were indeed ahead of your time. Thank you for that good judgment.
Can I comment on two things? The one is that I am very committed to the transformation of this country. I live in my own family, in a mixed family, with my children having to fill out forms as to what race they are when there aren't any of the races listed. I mean, surely after 30 years we can start to deal with difference and an understanding of diversity. But that is one of the challenges I think we continue to face as we live in a country so wrecked by inequality and remain one of the most unequal countries in the world. But the other thing I'd like to mention is that I, in my own engagement with public service, had an experience this year where I went to renew a passport at Home Affairs, and I sat with people on the cement floor of a parking lot. In front of me was a farm worker, and behind me were 3 school children. We sat for 7 hours. I was writing a judgment on the floor, and I was chatting to the two people, the school children, and I was chatting to the farm worker. And we got to within 3 people of the door, and the door was closed because Home Affairs was closing. So we'd sat for 7 hours. And we can speak about Batupele and the treatment of our citizens and other people in their engagement with public services. And it goes for the judiciary as well. We must all get out of ivory towers and go and realize what it is for people out there when they engage with our public services. And so to the extent that that judgment covers something along those lines, that's a sentiment that I strongly share.
Thank you so much. My second and last one relates to Section 157 of the Labor Relations Act. And you are probably aware of the tension that has been there between the Labor Court and the High Court in relation to the issue of jurisdiction. And the latest judgment to have come from the Constitutional Court on dual jurisdiction was Baloi versus Public Protector. The Retired Chief Justice Zondo, speaking at the 30th celebration, said that the country has not had a final weight on the question of the jurisdiction of the labor court. Do you share that sentiment that the issue of dual jurisdiction has not been authoritatively decided?
I think that's right. I mean, if we create specialist courts, then why wouldn't we put issues before those specialist courts and engage the expertise that they have as far as is possible? For instance, if you take restraints of trade, if the labor courts are dealing with restraints of trade, under what circumstances? So we have got dual jurisdiction, which is sometimes a very uncomfortable fit. And there are areas where the Constitutional Court from Chirua, Fredericks, all of those early cases tried to deal with the circumstances under which one would engage, what would engage the labor court's jurisdiction and what would not. But I think it remains an area which needs more work and possibly even statutory amendment.
Thank you, Chief Justice.
Commissioner Asang. Thank you very much, Chief Justice. Judge Savage, I was going to pose this a little bit earlier, but I think it's still necessary. In the Campbell versus Simmers case, but as well as a few others that I've mentioned, and I think Commissioner Mangena has also gotten to this point, you've written and spoken actually quite powerfully about dignity, consent, and power in the workplace. And as you know, obviously, the judiciary has just adopted its own sexual harassment policy, and it's been quite critical to reframe harassment as an abuse of institutional power and a violation of constitutional values, not just workplace misconduct. So my question then is, how do you see the role of feminist jurisprudence in transforming not only what we decide in our own judgments, but how we behave as a judiciary? Particularly when it comes to power dynamics, collegiality, and the hierarchy that can often make it difficult to call out misconduct by peers for what it truly is. That's my first question.
Thank you for that question, Commissioner. I must tell you, when I grew up, I was an oldest daughter, and I know there are lots of jokes about an oldest daughter in a family. I was an oldest daughter. I had an academic father. And my parents never treated me in any way that made me feel that I had anything but the opportunity, I should push myself as far as I could go, that there was no constraint, no particular job that a girl should do, no particular subjects a girl should take. By the time I got into the workplace, I must tell you that changed, and it was rather a rude awakening. I suddenly realized that, having not seen any need to call myself a feminist because I apparently felt quite confident about my rights as a woman, I found that there was a very different reality when that came to bear at work. So to the extent that it's important to advance issues that concern women and feminist jurisprudence does this, it has an essential role to play. It pushes us outside of the boundaries of where we currently live into the boundaries of where we want to be as a society. We are and remain one of the most violent societies in the world, not in conjunction with remaining one of the most unequal. If we have 16 days of activism against gender-based violence, we should have a decade of activism against poverty, against gender-based violence, against the violence of children, against letting children grow up in circumstances that are simply unjust and uncalled for and unconstitutional. So we need to be pushed as a society, and if feminist jurisprudence does it, it's very good for us in the judiciary to have those perspectives brought to bear. And very often they are, through amici who come to present argument before our courts, in submissions that are made, if they don't in fact make oral submissions, and so on. But it performs a very important function and continues to do so.
So related to that, right now I think we're seeing a whole lot of, not just young women, I'd say women in general, who are watching the judiciary quite closely, not only for its judgments, but how it's handling its own internal culture, especially given the Megenenge tribunal, but also many others that probably haven't come out in the public arena. So we agree that the policy is a step forward, But policies alone don't dismantle patriarchy. So the question really is, how should a feminist judge lead genuine cultural change within an institution where that hierarchy and that difference we've spoken a little bit about can sometimes protect those who are in power?
Probably by applying to positions like this that I said I wouldn't do and being encouraged by people to do it. That's one of the first steps, so that people in the judiciary can make the change they want to see. When I was at Bowman Gilfillan, I was the oldest woman with children, as I recall, in the firm. And I used to leave at 3 o'clock in the afternoon and then work in the evenings at home after my children had gone to sleep. And one young woman, both black and white, came to me and said, "How are you so brave, Kate? How are you so brave? How do you leave this workplace like this?" And I said, "Just follow me. Just pack your bag and follow me. That's how you do it." So I think you lead by example. And I think I have relied, certainly in the application for this, for the nomination for this position, I've relied on being led by example. And I think that's one of the first ways that one does it. And I think also increasingly is with the number of women who are now in the judiciary, we need to increasingly start to ensure that one provides the support and backing that is needed, that we take action where bullying occurs. I have reached out to the Chief Justice in circumstances where I had felt bullied, and I got a very, very supportive response. And it is exactly that kind of support that I think changes the institutional culture. And this is well before the Chief Justice was the Chief Justice. So I would support women continuing to do that in the judiciary, because that's what makes for real change. And I think for young women looking in at our judiciary, I hope that to some extent some of us might be able to be something of a role model. I accept that we have maybe 20 years older than the woman who might be critical of what's going on, but I think we need to hear perspectives, and we need young voices. We need to hear young voices. We're a very young country with young people being in the majority, and we must make sure that we remember and hear those voices, and that we are able to really give meaning to those voices, so that the Constitution and the constitutional projects not simply brought into the gutter of everything else that everybody's critical of the country. It doesn't mean that you can't be critical of the judiciary, can't be critical of the judgments of the court, that we can't try and encourage the court to take different and further steps forward. But it does mean that I think we need to be open as the judiciary to hearing the voices, particularly of younger people, and understanding the kinds of challenges they face. Have we really ever thought of the fact that 60% of people under 35 don't get a job, or 30? We've got some very, very significant difficulties.
Commissioner Steinberg, followed by J.P. Dalezi.
Good evening, almost.
Good evening, Commissioner.
A comment and a question. The comment is that I was very moved by your letter of application, your letter of nomination. And that must be all the female silks in Cape Town, and it's a ringing endorsement.
Thank you, it is, and I'm humbled by it. I really am. I think it really is credit to them in large measure.
It is. And I think you've sat here today and spoken for them and for many of us.
Thank you.
I'd actually like to ask a question about the law. Section 172 of the Constitution, subsection 1A, we're talking here about remedy.
Yes.
1A is a must. When you find an action or law unconstitutional, you must declare it invalid to the extent of its unconstitutionality. B, however, provides a discretion, the just and equitable order. As a High Court judge, and with the enormous volume of cases that we know High Court judges have, would it be useful for the appellate courts to give more direction, more rules almost, on how you exercise that discretion?
Without a doubt. I think it's one of the areas that we are needing more assistance on. Remedy is such an important area. And it is also so important when looking at, for instance, issues such as the development of the common law and what that might look like, and finding what is an effective remedy, under what circumstances it's effective, in terms of how far its reach is and how it could perhaps be improved. So I think there's definitely more scope for expanding jurisprudentially an understanding of just and equitable.
The Constitutional Court tends to emphasize the case-by-case basis on which cases must be decided. And no one can ever take away the judge's discretion because the Constitution gives it to them. But I do, as an advocate, it's very difficult to ever advise a client in the field of administrative law, for example, what their prospects of success are. Because something can be invalid and unconstitutional. The challenge could be brought late, and it can still not actually be set aside. In that area, do you think it's possible to create guidelines, without removing a judge's discretion, create guidelines?
I think one can. I mean, if one looks at, I think one can slowly start to develop the law to work towards, in different cases, from case to case, what just and equitable relief might look like. Yes, there might be areas in which it's not able, it might be cases in which it's quite different from another case, but that doesn't mean that one can't develop a common thread of principle running through it. And I think that there is, I agree with you that my experience of being at the court is that one does get something of a feeling of a case-by-case basis. And I attended the Stellenbosch Labour Law Symposium colloquium this week on Thursday and Friday, and found it fascinating to not only engage with some of the drafters of the LRA and some of the members of NEDLAC, who are very critical of what the Constitutional Court is doing on labour law, but also with advocates who feel that on a case-to-case, case-by-case basis, they can't tell whether they're going to get leave to appeal or not, even in the Labour Appeal Court, and that this is posing some difficulty when they're trying to advise their clients. So, yes, I don't know how one solves that problem, but it's certainly, these are some issues that exist.
Well, in other jurisdictions, you do see quite hard and fast guidelines and rules coming down in judgments from the Constitutional, from the Apex Court.
From the Apex Court, absolutely.
Okay, thank you.
Thank you, Chief Justice, and good afternoon, Judge Savage.
Good afternoon,
yes.
Colleague LAC Judge Commissioner.
Yes. I must say the first question you have dealt with it, I've never known you to be someone to easily succumb to bullying. And I'm glad that you'll continue to fight it, not only for yourself, but other colleagues in the judiciary. But something that you may have also dealt with, but I don't want it to be left open. It might be as if it's corroboration of something that was raised by Commissioner Trollip. We have the letter from the Black Lawyers Association, which says that we think that the experience of the Constitutional Court, even as a legal practitioner, does not appear to be significant. Hence, she does not have many cases that have appeared in that court. We think that she could benefit from some stints at the Constitutional Court in an acting capacity. And in conclusion, they say, we do not support her for appointment in that court, given her lean experience of that court, even as a practitioner. May perhaps want to comment on that in addition to what we have said before.
Thank you, Judge President Commissioner Tlaleti. I was disappointed to receive that comment, firstly because it's factually inaccurate. I'm acting in the Constitutional Court, and secondly, perhaps more so because in the past the Black Lawyers Association has in fact supported my candidature for various courts. I reached out to my colleague who's the Judge President of the Western Cape, and she, Judge Bokwana, and she indicated to me that I shouldn't take it personally, that she was also not supported by the Black Lawyers Association when she was appointed, and so we had a bit of a laugh about it. But the point is, as far as the Labour Appeal Court is concerned, many of my judgments have gone to the Constitutional Court, and some of them have stood the test of time. That I have had various experiences in the Constitutional Court in my practice, and I have been involved in these areas. I'm sorry that the Black Lawyers Association feels that, but I think that I would bring unique experience to the Constitutional Court with my almost 10 years experience in the Labour Appeal Court as a specialist court. There's limited Labour appeal experience in that court currently, and I think it would be a valuable addition, one. And two, I think I bring my more general experience and outlook on life and my approach to transformation in this country to that court that I think would stand me in good stead.
Thank you. Thank you, Chief.
Well, you are in very good company, Justice Savage. I never enjoyed the support of the BLA, and I was their member when I was still in practice and did a lot of work for them. So there you have it. Is it a follow-up, Commissioner Ngwaito?
No, not on the BLA. It's a follow-up on the questions that were asked by Commissioner Steinberg. Good afternoon, Judge Savage.
Good afternoon, Commissioner Nkatobi.
Very, very nice to see you in that position, despite your own apparent trepidation. So the theme of your sort of legal presentation has been around inequality and your commitment to the constitutional project, as you call it, in the rule of law, but primarily to solve the problem of inequality. But the difficulty is really, what is the jurisprudential basis for doing that?
Well, that's some of the criticism of academics, saying that we're not developing equality jurisprudence. What we're developing is jurisprudence around rights such as dignity and other rights, on which we're then hanging constitutional relief given in particular socioeconomic rights.
Yes.
So I think we do need to give more guidance on what the substance of equality is. Bearing in mind, of course, that often those who challenge the inequality provisions are often the people we're not intending to have use them to their advantage, like affirmative action legislation.
Yes, yes, and I think we both agree that that's something that should be done, but the question is, what is it? What does it look like? Does the Constitution have an economic vision? Specifically, a vision about economic equality? Is it, where are we going to find it? Is it in Section 9, in Section 26, in Section 27?
I think you find it first in the preamble. I think you find it when you say that we, therefore, through our freely elected representatives, not only heal, which we haven't actually done, as I said earlier, we lay the foundations for a democratic and open society in which government is based on the will of the people, and every citizen is protected by law, and that we improve the quality of life of all citizens, free the potential of each people. That's the first place that we find a kind of reference to improving the quality of life. And then you take it through from there into the provisions of Section 1 onwards, those foundational provisions, which guide what kind of a society we're trying to build, and you then build it through into the Bill of Rights. And I think that one needs to more actively deal with the rights in the Bill of Rights to build the jurisprudence around building an equal society. We cannot, and this Constitution can't possibly be a transformative one, if we are going to permit the rampant inequality that currently exists in this country to continue. So we have to use, I think that the consensus, the social compact that we arrived at is in many ways fit for purpose. It does need development. It may need amendment here and there, but I think that it is fit for purpose, and it should allow us to use the courts to drive that process of building a more equitable society, whether it's through land, whether it's through property, whether it's through access to resources, whatever it is.
Yes. One of the clearer provisions is Section 25. Not so much the land provisions, but the property provisions. That if you read that section properly, what it is trying to provide for is property equality. And the main feature of dispossession in this country since the arrival of the whites in the Cape was land. And if you want to resolve the problem of racialized inequality, you have to dismantle the property ownership. And that's the fundamental reason why we have a constitution. So that's the one argument in favor of the approach that you've articulated today. The other is that actually the Constitution decided not to deal with the economy at all. And in that sense, it left it to the legislature to pass acts of parliament on a issue by issue.
Well, on the issue by issue, if you look, for instance, at competition law, the Competition Act, it is an attempt to provide a regulatory regime for certain areas of economic activity. It does reference workers, but certainly, and I think what it's trying to do is achieve a more equitable distribution or access to resources in some way. But yes, some of that law could go further. As far as the property clause is concerned, well, if you're asking me if I'm a hardline, I probably say I'm a social democrat, and we can find ways to find within a social democracy that in the way that some in my family might say they're democratic socialists. But what one can do in the society is find ways of using the Constitution to build the access to resources that we want. We tax so that we can build access to resources. What we need to stop is people stealing the money that we have. We also need to make sure that we are developing and policy from a governmental perspective that sees wide-scale transformation, whether we take a Singapore approach where we force neighborhoods to integrate, whether we need to do something slightly more severe than what we're doing now. I'm not sure that it's for the courts to necessarily come up with a policy, but I can totally accept that we need to do something more severe than where we are. If we're going to build a society that sees is good and is one that is fit for purpose into the next century.
Yes, I mean, the reason why Section 25 is an easier section for economic equality is because it gives the power to the state to expropriate property for distribution. There is no other comparable section in the Bill of Rights that entitles the state to take something that belongs to a different person and give it to someone else in order to pursue the public interest.
And that provision hasn't been used. I mean, it's been used so little. When I had a debate with a colleague 10 years ago who said to me, this Constitution isn't good for purpose on the property issue and on land rights and so on. And I said, but why don't we use it? Why don't we use, this was one of the last clauses to be negotiated. There is no right to property. It was one of the last clauses that, with the right to lockout and with the education rights. Perhaps education has been the easiest of them. The lockout certainly hasn't been an issue of any moment. It seemed to be far more of a political issue at the time, but it's not really become an issue of any moment. And the area of property, ironically, is one, although it was hotly contested, in which the state has taken so few steps to actually implement in terms of this constitutional provision. So it can do so.
Well, some of us are wondering why the government is not expropriating land to give it to people who don't have it. There is a representative of the executive who sits on the JSC.
Well, of course, don't let me be understood, please, Commissioner Nkatobi, to be saying that I sanction wide-scale, uncontrolled, unconstitutional conduct in relation to distribution. But I am a firm believer that we, and I think most right-minded South Africans across the racial spectrum will agree, and the class spectrum, will agree that we need to do something very, very serious to deal with some of the pressing issues facing our country. And we will not be able to let children grow up in peace with access to proper resources if we don't do it, with access to jobs, with access to housing, with access to appropriate levels of water, food, etc. We won't be able to do it if we don't all commit ourselves to being part of that constitutional project, and that includes government. Government's done a lot. There are very, very many areas. The area of the world from which you are saw immediately after 1994 an enormous electrification campaign which does turn people's lives around, which does allow access to some level of engagement, certainly even now when we see children trying to study under candlelight still. But we need to do more, and there are no two ways about it, and the courts need to be part of that project.
Would you agree that there is an implicit provision in the Constitution, in the Bill of Rights, of the right to economic equality?
Yes, I think social justice must mean economic equality.
In that sense, it's explicit.
I think so. I can't see how social justice can mean anything other than allowing people to engage equally in the economy. If I have a child who is a middle-class child who goes to a government high school and then engages in the economy, that child must have that child and a child who comes from Khayelitsha, from a single family where they are living in an informal settlement, that child must be able to engage equally in this economy, and we need to take steps to ensure that happens. The interesting factors, and we can have a long conversation about this, but the interesting thing that came up at the colloquium this last week was the drive to do internships and learnerships, and what that's really causing. Is that really manifesting as jobs? And the stats are not good for it. So what we're seeing is that we'll have matriculants coming into the workplace at a very low level on an internship, but at the end of that year, the next person will come in because it's good for the company to just take the next internship grant, and so they go on to the next person, and that person just can't engage in the economy. So where's the economic equality there? Yeah. Where do you create people able to access equal jobs?
Yes, so I think in some, maybe you have
we
finally
did
answered.
Say, just two questions, Commissioner Nkaitobi. It is a riveting and critical topic, I admit, and but then we could go on and on and on, and teasing just one question into 1,000 different directions does not make it one or two questions.
This is really the last comment.
Let's close it off, please.
This is just the last comment, nothing else.
Okay.
So Justice Savage, you would say that the commitment to social justice in the Constitution is really a commitment to economic equality?
I think so, building it. Certainly we must strive towards it. Like I would think the kind of economic equality of arms that you would see in other more established economies. For instance, if you went to the known social democracies in the world, you would have that kind of access. Yes, I'd say so.
Thank you, Chief Justice.
Commissioner, President Willemette.
Yes, thank you very much for the opportunity, Chief Justice. Justice Savage, just one last point. You heard the Chief Justice mentioning that I am very, very eager to have you at our court. She knows this because I did contact the Judge President of the Western Cape Division to ask her to release you, but I was too late because the Chief Justice had already snapped you. But the other thing that I wanted to mention is I heard you regarding the concerns that you raised regarding bullying and so forth, and I very much appreciate your zero tolerance towards that. And I happen to serve on the Council of Sajai, the South African Judicial Education Institute, and every July of every year, before that, in July we have seminars, but before July, the CEO, Dr. Moshoe, usually approaches all the heads of Koto to ask whether some of their colleagues cannot present at the seminar. I would urge you to consider making a presentation for Sajai on the Judicial Code of Conduct, because if you have a look at Article 11 thereof, it spells it out very, very clearly that every judicial officer is is expected to foster collegiality, meaning when you are collegial to your colleague, it's not a favor that you are doing, you are actually duty-bound to do that. So I'm just saying, please consider raising your hand for that, because I think it would assist very much in the department that you alluded to.
Thank you. I will do so. Thank
you.
you.
Thank you, CJ.
Thank you, President, and I support that motion. Minister?
Thank you very much, CJ. Good afternoon, Justice Savage.
Good afternoon, Minister.
It's quite refreshing to sit here and listen to you. Interesting having read your CV and looked at your journey, but I think more interesting listening to you. And I do think that many women, when they hear you, they echo most of your sentiments, but are proud to see how you can stand your ground.
Thank you.
That is appreciated. And having worked, you know, what inspires me, and I think this is one of the things that one looks at it, having worked with the Constitution, one part of what we talk about in terms of the preamble of the Constitution, it talks about healing of the past. So it goes to the issues of restorative justice. And from where you're sitting, as a person in the bench, and I've listened to you, even the issues that you talk about as advocate, Ngatobi was a commissioner, Ngatobi was saying there's a representative of the executive here. Quite a number, I do agree, and a lot needs to be done to ensure that we can secure children in the country and the future. Do you think that there is a role that the judiciary can play, and what can there be a role in terms of around dealing with healing of the past and restorative justice?
Something that has really troubled me over quite a long time, because I in fact started to do some research on what happened in Nazi Germany at the end of World War II in terms of that population and how one built a common consensus. And I've got a lot of views on the issue. There was paid for by the Allies in the end of World War II, there was a public education campaign around healing that society. And I think we perhaps have not done enough. I think the fact is that it's difficult to heal a society which remains that is not integrated, in which we're all living in our own little worlds, in which language is an issue of difference, of significant difference, in which our children are going to schools and learning languages and not able to speak them. At the end of how many years of learning isiXhosa or isiZulu, they can't speak isiZulu or isiXhosa, and they can't speak even Afrikaans if they learned Afrikaans often. And we need to really look at how we as a society engage with healing into the future. Because what we've created, of course, is a youth that has grown up past 1994. They did not grow up under apartheid. They did not know of the whites-only beaches and benches. They did not know of all of the protests that were going on. They did not know of a lot of what was happening in the country. They were born after that time. They heard about it. But what they see is the effects of it. And we really need, as a society, to take some steps. So what can the judiciary do in taking those steps? I think where possible, where it's open to the judiciary, we can take those steps. But I would see it being led essentially by government. And perhaps through our schools, and through our neighborhoods. We need to diversify our society. We need to open up our economy. We need to make people able to get jobs. We need what everybody around the table knows. But we need to take active steps to achieve it so that we can build the society that we are proud of into the future. And I think, when we watch rugby, I didn't used to watch rugby, but I now am a great rugby fan. And it just shows you what happens as you feel a team is diversifying and so on. And one takes rugby looks at the rugby team. If one recalls, about 20 years ago, there was a huge hoo-la-la about the fact that there were going to be quotas imposed on the rugby team, that they had to diversify. And then what happened was that you had clever people involved in rugby who made sure that they did diversify, and they did. And so we've got a team that apparently all of us can now support. Well, we need to do the same in the rest of our society. We need to make sure that we are all growing up in neighborhoods where children don't They have friends of all hues who come from all sorts of backgrounds, who are different religions, who've got different languages, and so on. And the judiciary needs to make sure that that sort of healing is able to happen by the kinds of judgments and orders that we make.
Thank you. All right, we finally reached the end of your interview, Justice Savage.
Thank you.
Thanks again for coming here this afternoon. I think it was well worth it. And you've certainly given me, I can only speak for myself, you've given me a lot of food for thought. I've heard the interesting things you've raised. I'm listening. We'll talk more. Thank you very much.
Thank you very much. Thank you, Commissioners. Thank you.
That brings